Mr. Lee, can you hear me?
Yes, sir, I can. Can you hear me?
I can. Thank you. And we're the YouTube is up streaming and we're broadcasting live at this time, just FYI. So yeah, I hear you loud and clear.
All right, thank you, sir. I'm ready for business.
Great. And did you provide us the real-time links? I'm
I did
just going.
this morning, like around 3 o'clock, and it came from Cumbre.
I see it here, 3:24 a.m. Thank you.
You bet.
Can I just do a quick mic check? Can you guys hear me? Good morning.
Yep.
I can hear you, sir.
Perfect. Thank you both.
You
See you in a
bet.
bit. Commissioner O'Connell, just to let you know, we do have the YouTube up and running, so always good to. You don't have to do anything. I'm just letting you know because folks sometimes forget.
Yeah, no, thank you. It's also
No problem.
good here for what not to do.
Exactly.
So in order to avoid interrupting you, I have to pop out for a meeting at 9:45. Should be back by 10:30 at the latest. I was going to try to keep the Zoom going and just go off camera and go on mute. And it's
That's fine.
meetings on Teams. So hopefully I won't be popping in and off of Zoom.
No, that's fine. If you want to just leave your window open, muted, and video off, that's totally fine.
Yeah.
And I muted and video off because you never know if someone's going to walk into your office and start speaking. That's all.
Yeah. No, that's right.
Yeah, and Mr. Chair, what we'll do on the first witness, we'll make sure we go to you first. I'm not sure if any of the other commissioners are planning on coming this morning, but we'll go to you first just so you can ask your questions. The first witness, I think, will be Mr. Monroy.
Oh, okay. I don't have any questions for him.
Oh, okay. Well,
Which he
Do
just
you want to?
questions.
Do you want? I mean, we don't have to necessarily do Monray first. So we can kind of do it whatever order we want. I mean,
No, I'd say you should keep it and start with him because he's testimony in support of stiff, right?
Yep.
Yeah. He also filed direct testimony.
Yeah. Mr. Stipulation Henry Monroy.
Judge, do we have any public comment this morning?
No, sir, we do not.
Thank you.
Public comment was handled at a separate hearing, so not on the agenda today.
and John, you might just want to identify that occurred.
Okay.
You know, and
Do you have
again,
the date? Do you have the date
Yeah.
on that by any chance?
I
don't remember. I'd have to look it up.
Yeah, I can go figure that out. I have to go into the email. Where is the email? Just going to go to our calendar. I know it was in January.
I think it was on January 15th.
Yeah, January 15th in Albuquerque.
Yep, there it is.
New Mexico 811 building. Call before you dig.
Okay. Hearing examiner Ryan, what time do you want to let everybody in? I'm sort of thinking we should let them in a little bit earlier just so they can test their video and
Sure.
mics and all that.
It's fine.
All right, I'll let them in.
Yep.
Good morning, everyone. It's a little early. We're not going to get started quite yet, but if anybody wants to check their video or their mic, you're welcome to do that now.
Just remember that we are streaming live on YouTube, and we get that stream going up early just because we've had technical issues previously. So it's always good to have it going. So it's going now.
Good morning. This is Julie Clark from Walmart. Can you hear me? Thank you.
Yes.
Yes, we can.
Good morning. This is Kurt Bain with Kroger. Can you hear me?
Morning, Mr. Brame. Yes, we can.
Thank you.
Good morning, everyone. Nick Rossi with the PRC staff.
Morning, Mr. Russi.
Judge Crennicamp, are you the lead?
I'll be handling the sort of procedural mechanics, yes.
All right, thank you.
And hearing examiner Crennicamp, I'll keep my eye on the waiting room just in case anyone pops up.
Okay, that sounds good.
So you don't have to worry about that. It's a multitasking project, these hearings, really is.
I'm trying to make a quick scan of the attendees so far. Do we have everybody? All the parties, are they represented?
It looks close.
Well, it's 9 o'clock. I think, is Ms. Beatles present from WRA? That's the only party that I am catching right now that might be missing.
She did send an email that I saw Anna responded to, and I think she indicated that she was going to watch via Zoom or so via YouTube until it was time for her to come on. So I think that's what
Okay.
she's doing.
Okay. I think we have everyone else. So I guess we can go ahead and get started. Good morning, everyone. The time is now 9 o'clock a.m. and this hearing will come to order. We're now on the record in the matter of the evidentiary hearing of Public Service Company of New Mexico's application for revision of its retail electric rates pursuant to advice notice number 625. This matter is before the New Mexico Public Regulation Commission, docketed as case number 24-00089-UT. My name is John Crennicamp. I'm joined today by Christopher Ryan. We are the hearing examiners with the PRC who will be presiding over this hearing today. This case and this hearing involves an uncontested stipulation. Following this hearing, the responsibility of the hearing examiners will be to produce a certification of the stipulation along with a recommended disposition. This hearing today is being transcribed by a court reporter. For the sake of that record, I'd like to have all the parties present enter their appearances for the record, starting with PNM.
Good morning, Mr. Hearing Examiner. John Verhule for Public Service Company of New Mexico, and with me today is my co-counsel, Debria Terwilliger from the Wilkinson firm.
Good morning to you both. Next up, Utility Division staff.
Good morning, Nicholas Rossi for PRC Utility Division, and John Bigatko will be joining us a little bit later. Thank you.
Thank you. The New Mexico Department of Justice.
Morning, Mr. Hearing Examiner Gideon Elliott, and I am joined by my colleague Jocelyn Barrett.
Okay, good morning. The City of Albuquerque.
Good morning, Brian Rowland on behalf of the City of Albuquerque.
Bernalillo County.
Good morning, Valerie Joe with Bernalillo County. With me is Mara Demule, and I believe our witness is also available, Maureen Reno. Thank you.
Excellent. Good morning. ABCWUA.
Good morning, Mr. Examiners, Commissioners, colleagues. Keith Herman with the Albuquerque-Bernalillo County Water Utility Authority, and at times will also be represented by my partner, Nan Winter.
Okay, good morning. CCAE.
Morning, Mr. Hearing Examiner, Council, and Commissioners. Charles DeSalen representing Coalition for Clean Affordable Energy, and Kara Lynch, my co-counsel, will also be covering parts of this hearing. Between the two of us, Mr. Hearing Examiner, we should be able to be here most of the time, but we may need to request being excused. And today in particular, Ms. Lynch is at the Roundhouse, and a good friend of mine is receiving a Science Achievement Award at noontime at the Roundhouse. So I may ask to be excused a little bit early and perhaps come back from lunch a little bit late, if that's okay. Thank you.
Okay, yeah, that shouldn't be a problem. Let's see, CCSA.
Stephanie Zur, appearing on behalf of the Coalition for Community Solar Access.
Great, good morning. Kroger.
Good morning, Mr. Hearing Examiner and Commissioners. Kurt Boehm appearing on behalf of the Kroger Company.
Okay. New Energy Economy. Oh, Ms. Nanasi, I think you're on mute.
Good morning, hearing examiners, colleagues, Commissioner O'Connell, Mariel Nanasi on behalf of New Energy Economy.
Good morning. NM area.
Mr. Hearing Examiner, colleagues, and Commissioner Peter Gould for NM area. And later in the week, this hearing will be covered by my colleague, Kelly Gould.
Okay, thank you. Walmart.
Good morning, Julie Clark of Clark Energy Law on behalf of Walmart.
Okay, good morning. And then I think last was WRA, but Hearing Examiner Ryan has indicated that I think Ms. Beatles will be joining us later. Is there any other party present that I did not call on? I think I covered everybody.
Mr. Hearing Examiner, this is Joseph Yar on behalf of Onward Energy Holdings. Good morning.
Oh, good morning.
Everyone, Commissioner. I would like to request to be excused from the hearing, if that's possible.
Absolutely. Yeah, that request is granted.
Thank you.
Thank you.
Okay. Mr. Kreinkamp, following up on what Mr. Yar requested, I don't know how to ask this, but is it okay if at times, since we're not cross-examining, if there are witnesses whose testimony is not that material to our position in the case, that we attend using the YouTube link, or do we need to give you and Mr. Ryan some notice of that so that you're able to keep score and make sure you know who is here and who is not?
No, I think that's fine. I don't know that we necessarily need to be told every time. I mean, the one issue that would come up is I do think we're going to be moving through certain witnesses fairly quickly. And so the only, bad spot we would be put in is if it's time for your witness and, you're not there, or your witness isn't there.
Yeah.
But as long as you're generally monitoring the hearing, I think that's fine. Commissioner Ryan, do you have a preference on that?
Yeah, so I think if we just consider the fact that, we're here for the hearing, this adjudicative body is assembled in part for the commission, of course, and we are legislatively required to do so, but it, of course, is a venue that is designed to give you all maximum opportunity to participate. And to the extent to which you wish to not participate and not appear, that's perfectly acceptable to me. You just do that with the understanding that if you missed something, well, that's on you. So, yes, I don't think this will go on too terribly long. We're aware it's an unopposed stipulation, and my view is you can participate however much you'd prefer. But if you are away, understand that that's something you'll have to live with if you didn't get a chance to ask a question you wished.
Okay. There are a couple of housekeeping items I do want to address, but before I do that, I believe that we are joined this morning by all of the members of the commission. And so I'd just like to start with them just introducing themselves as well, starting maybe with Commissioner Aguilera.
Thank you, hearing examiner. Thank you all for coming to this hearing. I'm looking forward to, whatever questions the hearing examiners might have, and, appreciate you all being here. So I don't really have anything by way of introductions. That's it. Thank you.
That's fine. Thank you, Commissioner Aguilera. Commissioner Nybert.
Thank you. Greg Nybert, plan to listen in. Probably won't have any questions, but appreciate the opportunity. Thank you.
Excellent. Thank you for being with us. And last but not least, Chair O'Connell.
Good morning, all. Let's have a great hearing.
Thank you, sir. Okay, so just a few procedural notes about the hearing over the next few days. I have a number of items to run through. At the end, I'll turn it over to the parties and see if there's anything else that we need to address before we get started. And if there are questions or concerns at any point, just raise your hand or interject. That's fine. So first and foremost, we have, by my count, approximately 21 witnesses who are prepared to testify this morning. Given that this is an uncontested stipulation and therefore cross-examination would be friendly cross-examination, we don't need to worry about time limits. We are pleased that the parties were able to confer with one another and propose an order of witness examination. We are generally going to try to stick to that order. In that pre-hearing memorandum, a number of parties identified times when their witnesses were unavailable. That was roughly 10, I think, of the 21 witnesses. We can't guarantee that we will be able to honor that in every instance. We will try to. And where possible, we will accommodate temporary unavailability by moving witnesses around or moving to the next witness, something like that, and trying to address that later. And also, just to flag again, I don't anticipate that hearing examiner Ryan and I will take a great deal of time with any particular witness. So again, we are likely to start moving fairly quickly, especially once we get to the intervener witnesses. Hearing examiner Ryan and I conferred briefly this morning and over the weekend. There are 2 witnesses for whom we do not have questions. Those witnesses are Christopher Sandberg from NEE and Justin Brandt from CCAE. Before I tell everybody that those witnesses are excused, I do just want to ask, we have all 3 of the commissioners present. Do any of the commissioners, did you have any questions for either Mr. Sandberg or Mr. Brandt? Or any concern with us releasing them?
I have no concern with that. Thanks for asking. And then just a little bit of business cleanup. I'm going to be popping in and out this morning, so apologize for that. But reason I can do that is full faith in hearing examiners and Mr. Lee.
Thanks, sir.
No concerns for me either. Thank you.
Okay, thank you. All right, so it doesn't sound like we have any questions. So Mr. Sandberg and Mr. Brandt will not be needed to testify. And we'll talk about the admission of those testimonies here in just a little bit.
And then, John, hearing examiner Krankamp, if I may, I think I just want to say for the purpose of the benefit of the parties, and then this kind of goes along with Mr. Gould's questions. The questions that we have, I mean, part of this is learning, right? And I will be the first to tell you that this is a very difficult. All of this stuff is always difficult. And I'm not trying to be jokey there. I genuinely think that. So I would hope you wouldn't allow us to ask the questions that we have. I don't anticipate it will take us a lot of time. But trying to imagine all the concerns one might have, whether you're a commissioner, a member of the public, us hearing examiners. It's a lot. So if you all need to turn off your videos and want to just sort of monitor in the background so that you can multitask, that is entirely acceptable. The point here is just to give us the opportunity to ask what we feel like we need to, and to do so with maximum efficiency.
So next procedural note, Deborah Dole, the attorney for REIA NM, emailed the hearing examiners last night asking to be excused. I communicated to her that that request was granted. And so just reiterating that for the record, that I don't believe she'll be joining us. Next up, just for the record, there was a public comment hearing held in this case on January 15th, 2025 in Albuquerque. Public comment, though, is still being accepted in writing and can be emailed to the PRC's Records Bureau. So just confirming that. And then next, I think maybe one of the more important items. So paragraph 29 of the uncontested stipulation, that provided that the parties had agreed to the admission of any pre-filed direct and supplemental testimonies and the exhibits of the witnesses. The preference of the hearing examiners, just to make sure that things flow properly on our end, is to adopt that paragraph with respect to those witnesses who will not be testifying during the hearing. We still would prefer for those witnesses who are testifying that those sort of foundational questions with respect to that testimony are still asked on direct before the testimony is admitted. So the exhibits by my count that would be ready for admission at this time, because their witnesses would not be testifying. And I'll go slowly. I want to make sure that this is accurate and that Mr. Lee gets all this down. The exhibits that are ready for admission without witness testimony are PNM exhibits 1, 6, 7, 8, and 9. And exhibits, PNM exhibits 19 through 31. And then the other two exhibits would be NEE exhibit 1 and CCAE exhibit 1. Any questions on that? Did I capture everything? I believe that I did, but Mr. Verheul, does that sound correct to you as far as the PNM exhibits?
It does, sir. Thank you.
Thank you. Okay. So seeing no questions and pursuant to that paragraph of the stipulation, those exhibits are hereby admitted into the record. Next, there was an unopposed motion filed by PNM on February 10th, 2025, seeking leave for Julio Aguirre to adopt the direct testimony of Stella Chan. That, again, motion was unopposed. It is hereby granted. That being said, again, Mr. Aguirre will not be testifying during the hearing, as I understand it.
Mr. Hearing Examiner, this is Mary Ellen Manassi. Can
Yes.
I just state for the record that New Energy Economy Exhibit 1 that you've now admitted is the testimony of Christopher Sandberg in support of uncontested stipulation?
Yes, absolutely. Thank you.
Thank you.
Mr. DeSalen, anything you wanted to say about that CCAE exhibit? If you did, I didn't want to preclude you.
No, thank you, Mr. Hearing Examiner. That's just a testimony of Justin Brandt, and appreciate your move. Yeah, I think this is a good procedure. Thank you.
Thanks, sir. Okay, next up, Hearing Examiner Ryan has one other procedural item and possibly more.
Sure. So a recent order was issued on the motion for intervention of Ecomax, and we are aware that there was also a motion filed by PNM on October 24th to strike the intervention of New Mexico independent power producers. And when you look at that motion, and this, I'm explaining this for the record, the first sentences of the PNM motion indicate that the New Mexico independent power producers filed their motion to intervene on October 11th. But if one were to go to e-docket, which I am looking at presently right now, you will note there is no motion for intervention October 11th of the New Mexico independent power producers. And the reason that New Mexico independent power producers motion for leave to intervene does not appear on e-docket is because they did not follow the commission's filing practices with the Records Bureau. And I have in my possession in my email exchange with our Records Bureau, who instructed New Mexico independent power producers how to properly file motions with the commission. And the New Mexico independent power producers could not comply, apparently. So there is no motion. And that is the answer to that. Thus, there's no need to resolve PNM's motion to strike the intervention because the motion to intervene was never filed. That was the only matter I had.
Okay, thank you. Okay, so I believe those are all of the procedural items that the hearing examiners had.
Sorry, Mr. Verheuvel. Yeah, Mr. Verheuvel, I didn't mean to cut you off.
Thank you. Mr. Krankamp, while you're going through motions to adopt testimony, in addition to Mr. Aguirre adopting the testimony of Stella Chan, on November 1, PNM also filed a motion for Jeremy Heslop to adopt the direct testimony of R. Brent Heffington.
Okay, I see that. For some reason, I thought that had already been granted through a written motion, but that motion too, being unopposed, will also be granted.
Thank you.
Thank you. So thank you for that, Mr. Verheuvel. Is there anything else from PNM or any of the other parties, any procedural items or questions regarding the hearing today before we get started? Okay, I don't see any. All right, so with that, we can go ahead and get started. And PNM, you can call your first witness.
PNM calls Henry Monroy.
And I do see Mr. Monroy here. Mr. Lee, you want to swear in the witness, please?
Mr. Monroy, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth. So
I do.
Thank you, sir.
Mr. Monroy, please state your name and your job title.
My name is Henry Monroy, and I currently serve as Vice President of Regulatory for Public Service Company of New Mexico.
Do you have before you what has been labeled PNM Hearing Exhibit 2?
Yes, sir.
And is that your testimony in support of stipulation?
Yes, sir.
Was this prepared by you or under your supervision?
Yes, sir.
Is it a true and accurate account to the best of your knowledge?
Yes.
Do you have any additions or corrections to it at this time?
I do. I have one correction. On page 7, line 2, I would replace at the end of that sentence, there's a number 52.05%. The correct number is 52.50%.
Thank you. If I asked you the same questions today, would the answers be the same?
Yes, sir.
Mr. Hearing Examiner, at this point, I move to admit PNM Exhibit number 2, the direct testimony in support of stipulation of Henry Monroy.
Thank you, Mr. Verheuvel. There's no objection pursuant to that provision of the stipulation. So PNM Exhibit 2 is admitted into the record.
Mr. Monroy, do you also have before you what's been labeled PNM Exhibit number 10?
Yes, sir, I do.
This is your direct testimony filed in June of 2024?
That is correct.
Was this prepared by you or under your supervision?
Yes, it was.
Except for the stipulation, does this testimony represent a true and accurate account to the best of your knowledge?
Yes, sir, it does.
Are there any additions or corrections to it?
No, sir.
But for the stipulation, if I asked you the same questions today, would the answers be the same?
Yes, sir.
Mr. Hearing Examiner, at this time, I'd like to move for admission of PNM Exhibit number 10, the direct testimony of Henry Monroy.
Thank you. Again, pursuant to paragraph 29 of the stipulation, there's no objection to the admission, so PNM Exhibit 10 is admitted into the record.
And real quickly, Mr. Verhul, just for clarification, I did pull up PNM Exhibit 2, which is the direct testimony in support of stipulation of Henry Monroy, and I'm looking at page 7, line 2. It doesn't appear as though there's a strike through. I see the 52.05%, and Mr. Monroy's just corrected that should be 52.5. So I guess just for the record, I want to clarify that that's not corrected within the stipulation filed testimony. There's no indicate. So in other words, someone would have to come to this transcript to see that that exists.
That's correct, Mr. Hearing Examiner. If you would like, we can upload. No, you're shaking your head.
No, that's fine. I don't. No, it's not. I mean, I obviously this is an uncontested stipulation, and it's not a big deal at all. It's just that, in the future, I think what's very useful. Because I had someone ask me this very question, about corrections to the transcript, and it's interesting because I'm sure all of us, to some extent, do the same thing, which is, we have the pre-filed testimony, we read it, we make notes, we highlight stuff, and then and then invariably, because we're dealing in a world of numbers, there's always corrections, right? So I get it, but I think it's always useful to only allow those corrections that could produce meaningful conclusion, and I think that is one of them. And then so I don't need anyone to make spelling changes, right? Like we'll figure that out, and plus we want to minimize the amount of corrections that occur. And then when you do have a correction like that, I think it is always useful, and this is just, I'm purely saying from a matter of practice moving forward, for us to see the strike through, because what'll happen is if ultimately that stipulation exhibit went off to some other locale, right, other court or wherever, they would see very clearly that there's a strike through and a correction. So I just think it's a best practice. That's all.
I appreciate that, Mr. Hearing Examiner, and we will certainly keep that in mind.
Thank you.
I have no more exhibits to introduce via this witness, Mr. Hearing Examiner. So at this point, I would tender the witness for any questions.
Okay. To clarify, Mr. Verhul, I show that we admitted Exhibit 2 and Exhibit 10. Did we admit Exhibit 11?
We did not, and thank you for catching that.
No problem.
Mr. Monroy, do you have in front of you what's been labeled PNM Exhibit number 11?
I do.
This is your August 1, 2024 supplemental testimony?
That is correct.
Was this prepared by you or under your supervision?
Yes, it was.
But for the stipulation, is it a true and accurate account to the best of your knowledge?
Yes, it is.
Any additions or corrections to it?
No.
But for the stipulation, if I asked you the same questions today, would the answers be the same?
Yes, sir.
Mr. Hearing Examiner, at this time, I'd like to move to admit PNM Exhibit number 11, the August 1, 2024 supplemental testimony of Henry Monroy.
Thank you, Mr. Verhul. There being no objection, Exhibit 11, PNM Exhibit 11 is admitted into the record. And I believe that concludes your direct, Mr. Verhul.
It does. Thank you, Mr. Hearing Examiner.
Thank you, sir. Okay, let's see. Let me go to the commissioners first. Commissioner Aguilera or Commissioner Nybert, any questions for Mr. Monroy?
No, sir.
Not for me, thank you.
Okay, thank you. And Chair O'Connell, any questions for Mr. Monroy?
No, thank you.
Thank you. Hearing Examiner Ryan.
Good morning, Mr. Monroy. How are you, sir?
Good. Good morning. How are you?
Fine, thank you. I'm presently in the drafting process of a law review article about stipulation, so I think actually they're very interesting, and I've been thinking a great deal about them. One of the questions I have is as a procedural tool, and I understand that if I was PNM, I would aggressively litigate as well. The question I basically have is, as I was thinking about all the varying testimony in this case, so much of it says something to the effect of like, well, the application came in at a much higher level than where we've stipulated, and therefore that's a good outcome. And of course, thankfully, we have testimony in this case from both Dr. Gigax and Ms. Crane say that the result would be the same under an empirical analysis that's independent of the stipulation. So the question I just want to ask you, Mr. Monroy, just as a general matter, is and it's really not meant as an accusation at all. It's really meant purely as a question. Why should the commission not, when they see large initial applications and stipulation, sort of have cynicism around that, where you say, well, you started very high and now you've come down, but perhaps, that's where we should have started in the first place. So what was the initial application about? Do you understand the nature of my question, sir?
I do. I appreciate your question. So, Mr. Hearing Examiner, I think, when PNM, I can't speak for the utilities, but when PNM files its case, that is its best estimate of what it's going to cost and what the revenues are necessary to provide electric service. I don't, PNM, or at least, and since at least I've taken over our filings, I can't speak to prior, but there's an accurate representation of what it costs to run our service. I think if you look, especially in this case, on what's different or why the number came down, I think you have very specific adjustments that are, as part of the stipulation, PNM agrees to them, but they're definitely lower than what we believe would be appropriate to run the utility, or the revenues to run the utility. So I think, this request, the stipulation is approximately 60% of the original ask. I think there's some large adjustments that kind of drove that change, namely the change to the Four Corners depreciation. I think that was a discussion amongst the parties, and it agreed to the stipulation that as a means to help with customer impacts, that did lower the overall request, but that would not in itself say that the original filing was not accurate or a representation of what we felt was the cost to run the utility for that period. I think another large adjustment is the change to both the return on equity as well as the capital structure. That's about another $20 to $23 million. So obviously those are always disputed in a regulatory proceeding, with parties having various different viewpoints on what are appropriate levels there. So I think when you take those two into account, that's 40 million of the overall almost $70 million reduction on those two adjustments. I wouldn't say those were put in there just to puff up a number. Those are valid requests from the utilities perspective. So I think what I would take away is the 60% really reflects very serious negotiations amongst, parties that participated in the settlement, that came to a conclusion that everyone can live with. I always feel whenever you have any type of settlement, as long as everyone's walking away just a little unhappy, then it's probably struck the right tenor. So, but I guess that's my overall response is I would hope the commission would not feel that utilities, or at least PNM's initial filings, are puffed up in any manner, as they are supported by the testimony and the positions, and we file our cases before the commission.
Thank you. Can you just, for me, the ESAs, and then for purposes of what impact that has on the actual increase in the revenue requirement for this case, can you help me just, what is the new amount of money that is requested in this case for the ESAs, and what does that do for the revenue requirement?
Sure. Give me 1 second. Let me get you the right number. So the driver for the energy storage agreements, so these are energy storage agreement costs that are currently not reflected in base rates that are anticipated to be there for our test period. That driver is $37.2 million.
Okay. And I guess my question is, if the total number is 80, the 50 already is in rates, is that right?
That's correct, sir. So 82 million is the total in the test period. The delta of about 45 million reflects the ESA costs that were already included in our previous rate case.
Okay. That's what I understood. I just wanted to make sure that I correctly understood that. The tax questions about if there's a change to federal corporate income tax, am I to read that to be, we saw with the last administration, fairly significant change of tax stuff. Is that the anticipation there?
That's what that provision's intended to capture, that if there are changes at the federal level to the corporate tax rates, that those changes are effective to PNM on or before December 31 of 2025, then those changes would be reflected in our phase 2 compliance filing.
Okay.
Very similar to the tax reform that was passed back in 2017 that I think PNM, given the timing of they had a stipulation or a settlement also ongoing, we were able to pass those impacts through a compliance filing as well.
So in other words, we really don't. I mean, that provision's in there only because we sort of don't know what's to come effectively.
That is correct. And if there are no changes that are effective on or before that date, then that provision does not have any impact to the phase 2 rates.
Great. There's writing from lots of folks in this case about wildfire consideration, and the events that transpired in Los Angeles, I think really brings home the need, and I guess it sounds to me, and I'm just asking as a general matter, PNM's committed to, within rates itself, really accurately pricing how we assure no fires occur like those that occurred recently in California.
Mr. Hearing Examiner, yes, I can say that. Wildfire is obviously a very growing risk, a large risk for not only PNM, but all utilities that have forests or areas that could have the opportunity for wildfire risk. I can confirm for the commission and for yourself, Mr. Hearing Examiner, that these rates will allow us to continue to explore and implement our wildfire mitigation activities, including pole inspections, especially in our high fire risk areas, pole inspections, continuing to harden those areas, and continue to do the steps we need to do to make sure we are adequately mitigating that risk as best as possible. I think one of the provisions in the stipulation, it was a motion for the commission to also hold workshops. I think that we find that beneficial to have a broader discussion that hopefully the commission can participate or at least lead or orchestrate to make sure that us and our partner IOUs in the state are really taking advantage of best practices, knowledge sharing, and making sure that we as utilities are appropriately addressing that risk. And so, but yes, I can confirm to the commission that the stipulation and the rates that they represent will allow us to continue to address our wildfire mitigation activities.
And the insurance premium additions that occurred, because the costs have gone up to procure the insurance. I assume that still reflects, though, that there's a sort of macro concern that if you have enough damage, even the insurer at some point has limitations as to what it can, reimburse, right?
I agree. I think there's a larger risk to the utility itself, right?
Okay.
With these wildfires that exist. And so, the utility can, do its part on wildfire mitigation, but I think, liability and insurance and all those things is beyond my expertise, but I think maybe there's some state policy issues that definitely the state could be exploring to kind of ensure that really our residents are protected as best as possible without endangering or creating a significant risk that the utility can continue to operate and provide service, as both are critical services, both the safety of our customers and the need for them to have electricity. So
in many ways, what I hear you saying is that the rate considerations and the things that we allow the utility to fund, that you've proposed and that the stipulation addresses, and that's really just one tentacle of the octopus, if you will, whatever. I don't know if that's the best metaphor, but in other words, it's a bunch of systems that need to function all collectively to really have security.
Yes, I believe so. Between managing the forest, making sure the fuel is kind of being contained and controlled, to making sure residents can still get insurance for their own personal property, right? I think there's just some policy risks that need to be addressed. And I think your analogy is great. one tentacle of an octopus. That probably all needs to be addressed.
Great. I just wanted to make sure I understood something, and it's an allocation question. So if you could go to your testimony at page 35, this was the stipulation testimony.
Yes, sir, I'm there.
And the question is, what is the purpose of paragraph 27 of the stipulation? And then the answer, I won't ask you to read it all for the benefit of our court reporter, but I was just trying to make sure that I understood what that paragraph is trying to convey. And perhaps can you just unpack it a little bit and just explain to me what you're trying to articulate there, perhaps in slightly different words, so that I'm certain to understand?
Sure. As part of the stipulation, the signatories of the stipulation wanted the commission to understand the impact to two allocations that were proposed in the original filing that we made. This had to deal with the Energy 4 allocator, which has to do with what we proposed is a non-renewable percentage of 79.97 to all rate schedules except rate schedule 36B. And also in our original application, PNM proposed that costs for transmission interconnected energy storage agreements would be functionalized between transmission production and demand. The informational purposes, the signatories felt it was important for the commission to understand that if the allocators, so we'll take them one at a time, what would be the allocation to the classes if the Energy 4 allocator was applied to all rate schedules, including 36B? And also, what would be the cost-based allocation of costs if the transmission ESA costs were allocated solely to production? And so the signatories wanted that in there. I believe PNM witness Dr. Pitts provides a table that shows the shift in cost allocations had those two allocation changes been utilized when we designed the rates for the stipulation.
One question I was going to, I would like to ask based on another. I understand the concept that when we were talking about rate design of, you're not authorized to discriminate within the rates, and that the word discrimination isn't a great word because it's not suggesting something, the sort of terrible things that happen in our society, whatever. We're talking basically about making policy choices between classes. And I had a discussion with our, not about this case, but just a general discussion about rates generally. When we talk about things like gradualism, for instance, aren't we in some regard discriminating if we were to say gradualism must be prioritized?
I guess I would say you're trying to balance a couple of things, right? You have cost causation principles, which in the principle makes sense that each class should bear the costs that are allocated to provide service. I think you're also trying to balance the concern of rate shock or a change to any one customer class that would shock the customer. So I don't know if gradualism discriminates against one class or another. I think it's a tool to try to balance those two overriding principles that each of them themselves are valid and should be considered. So I wouldn't think you're discriminating against the other class. Obviously, a subsidization, there's definitely subsidizations between the classes, but I think you're trying to balance all of those overriding principles amongst each other. And I'm not sure, I think that even with the gradualism and with the banding that PNM has applied, I would say the rates are still fair, just, and reasonable. And so then by definition, I don't think they are discriminatory.
Pricing Advisory Committee, I guess my question, we heard about that at some length in 22-270. And I'm just wondering, is there any concern that that's not going to bear fruit in the sense of that there's really a wide array of concerns there, and then what should the commission understand about where things are with the advisory committee and how much progress has been achieved in terms of all of these issues that I won't get into here, but you're aware of them, I'm aware of them, and I understand all the negotiations. But I guess if I was to try to formulate my thoughts all into a question, I'd say, why should the commission have confidence that that process is going to ultimately help solve these problems?
Sure. No, I think that's a great question. And here's how I view the Pricing Advisory Committee and the benefit it's providing. I'm not Pollyanna, and I'm not going to say that PRAC is going to be able to gain all the stakeholders or the interveners who are participating in it and be able to come with a holistic solution that is supported in our next rate case. I would love to get there. But I'm not sure that's the goal. What my goal is, as PNM goals, is really to have a baseline of understanding from all the parties of what their concerns, what their positions are, what their views are, and for the parties to understand how we're looking at allocation, functionalization, and the various kind of rate design topics that we're needing to address. I think that benefits the commission because when PNM makes the proposals to change modern rate design, which is really, I believe, coming in the next case, especially, and thank you to the commissioners and to the commission. PNM is on its way with its grid modernization plan. AMI and smart meters is really a critical piece to giving our customers the information and the tools they need. So when we propose rate design changes, they are informed and able to participate in what those new rate designs may do and how they may help them in the system overall. So I think the PRAC, the benefit is gaining this common understanding amongst the parties. I think there may be certain issues that the hearing examiners, the commission themselves may have to just decide between the parties, but I think having the discussions, having the ability and time to talk through those in a non-litigated format are very valuable to PNM to make sure we are understanding, because our interveners represent our customers, right? And so that's an insight we don't necessarily have that they can provide and give us input to. And so I think that Pricing Advisory Committee is allowing us to be more informed and more educated with our own proposals that we bring before the commission. So I do think there is value to that.
And this is my final question. It kind of goes back to where we started in the conversation. From your experience with rate applications, would you see utility in the opportunity to provide the utility applicant, and then this is a question obviously that would have more impact than just on PNM, that's why I'm using those words, having the opportunity to sort of file what is out of the gate a stipulated application for rates?
Out of the gate.
Meaning, in other words, like what the way process works now is you file an application, then the interveners have a time to assess it. And I think the question is, when one might ask, well, why not get together ahead of the filing and have that discussion and then have the filing be one that is already a stipulated filing?
Right. No, I appreciate that, Mr. Hearing Examiner. And let me give you a couple of thoughts on it. So I think it depends on the filing before the commission in itself. I will say rate cases present a unique challenge in that when a utility, especially a publicly traded company like PNM, files a rate case, that's generally deemed material non-public information. And so there's certain limitations on how much discussions PNM can have with stakeholders and interveners prior to actually making the filing. And so whereas, and I think I can share this, in this case, we did have discussions with interveners prior to us making the filing. Those discussions were directional and kind of high-level informational and not really the ability to start digging into specific requests, specific dollar numbers, and specific analysis. And a lot of that's driven because it's sensitive information to the public, right? And so we can't be releasing or sharing necessarily the size of the requests and things of that nature to our intervener group. So that's kind of the major prohibition, at least on a rate case, of trying to do that. I think we are trying on Other not as sensitive information like resource filings, we are definitely starting to and trying to work with stakeholders prior to our filings, really to gather their input and make sure we understand what concerns, areas that we're not thinking about that either maybe we can address before we make the filing, or at least just be aware when we make the filing. So I think stipulated filings is something that can be explored in certain areas. I do struggle with a rate case or anything that is deemed public material information. I think that just kind of prohibits that discussion. But I will say, I do think with this procedural schedule that was set up and how this process worked, I think this is an optimal way for rate cases that do have this type of information, that interveners need the time to go through the data, but still come to the commission and conserve both the interveners' resources and hopefully commission's resources, and come up with a settlement in this case that results in fair, just, and reasonable rates. And so I guess I would struggle with the rate case just because of that public information requirement, but I do think in other cases there is definitely an opportunity that should be explored.
No, it's a very interesting answer. Thank you. That gives us a great deal of information. Last question is predicated on something you just said there. You know, when I was reading Dr. Blank's testimony in this case, the stipulation testimony, one of the factual claims he makes to say, you know, how can we be certain that this was the result of arm's length negotiations, is he actually points out the resources expended on settlements negotiations exceeded that which he understood would be necessary for a fully litigated case. Did you understand? I mean, I sort of thought that was it. I mean, I thought that was very interesting. I mean, is it your position too that the company probably has spent more negotiating the settlement than they would have had if it was litigated?
I don't know if more. I can definitely see the same amount. I mean, like, I'll just be honest, like, preparing for this hearing was less than if it was a litigated hearing, right? So there are some inherent benefits, but the amount of work that was put into the settlement is definitely, I could see being similar to the amount of work we would have had to have done in filing rebuttal testimony, for example, right? Because you're hearing parties' positions, you're having to talk through those positions and come up with your own arguments of trying to, you know, persuade or convince why, you know, you need to get a certain outcome. And so I guess for myself, I would still think there was definitely a benefit of the stipulation on resources. It definitely accelerated when you would expend those resources. Like I said, you know, probably all the time we would have spent over the holidays dealing with rebuttal and trying to come up with arguments was definitely spent right before Thanksgiving. But I do think, you know, coming before here, I mean, it's less resources to prepare just to, you know, the hearings to meet the commissioners and hearing examiners' expectations than preparing for cross from 13 other parties. But it's still a significant amount of work, though, either way.
Right. Very good. That was all very helpful, Mr. Monroy. Thank you for your answers. They're always insightful, and I learned a lot just talking to you. So thank you.
Thank you.
Hearing
Thank
examiner
you.
Ryan, that's all my questions. Yeah.
Okay. Thank you, Hearing Examiner Ryan. I appreciate it. Good morning, Mr. Monroy.
Good morning.
I just have a couple of questions for you. Probably won't take quite as much time. Hearing Examiner Ryan asked you a little bit about gradualism and this issue of cost causation, and you gave him sort of a lengthy answer about that. And I want to sort of piggyback on that with my first question. Again, your PNM's sort of generalist witness, and so the big picture questions are directed to you. As you are well aware, I mean, one of the criteria for stipulations before the commission is whether or not they violate any important regulatory principle, right?
Correct.
And what I see just going through all of the testimony that PNM filed and then the interveners and staff, you do have this sort of tension between cost causation and then, as you testified, avoiding rate shock, right? Those are both, I think, regulatory principles. And I was wondering if you would testify, just sort of elaborate just a little bit more in terms of, as Hearing Examiner Ryan and I view the stipulation that the parties have agreed to, and we consider whether it violates any important regulatory principles, how we should sort of approach that balance.
No, I appreciate that. And I guess the main point I would make there, what I would share is if you think about how we did the rate design here, how we functionalized, how we classified, functionalized, and allocated costs, it's very similar to what we did in the prior case that was litigated, that was accepted, and that it resulted in fair, just, reasonable rates. We do have banding proposed in this settlement. Banding was also accepted and implemented in our last rate case that were used to set fair, just, and reasonable rates. So I guess my simple answer is the stipulation itself, whereas the percentages are a little different, the banding's a little different, and the dollar amount's obviously very different. The underlying principles of how you allocated costs, how you dealt with the difference between cost-based rates versus banded rates. To me, the commission has already provided that guidance that it is acceptable and then these rates kind of mirror those principles from our previous rate case and were implemented in the stipulations. So I guess holistically, that's how I would think one can get comfortable that the commission, if they adopt and approve the stipulation, aren't violating any regulatory principles.
That's helpful. And I guess looking at the previous rate case as a comparison, my understanding is that through the stipulation, we're moving closer to cost causation. Is that right? So you're moving a little bit away from the interclass subsidies. Is that correct?
We are making progress. I think there's probably some other witnesses who are a little bit more detailed, like maybe PNM Dr. Pitts, or maybe it was blank, I can't remember, who actually did a little subsidy comparison. But these do move towards, I think we now have 2 or 3 classes that are going to be cost-based rates, which is great. The subsidy that the residential class receives, I believe, went from 47 million to about 40 million. That's subject to check. Dr. Pitts can kind of confirm those numbers for you. But yes, we are moving towards cost-based rates while trying to continue to apply all those other principles around gradualism.
Okay, thank you. I wanted to ask you about one statement that I saw in your testimony. This is your stipulation testimony, which is PNM Exhibit 2, on page 13. You have a statement here. You talk about the lowered stipulated revenue requirement will present challenges for the company in terms of managing its budgets and overall costs. But PNM also believes that the stipulated revenue requirement, I guess, is reasonable. Can you elaborate just a little bit on those challenges that you're sort of alluding to there, and why, even in light of those challenges, you still think that this stipulation is in the public interest?
Sure. And I think, one of the things the utility or PNM does in how we manage our business day to day, there's always a prioritization, right? Both in our capital programs and where we invest our money, both in our maintenance programs and how we manage our, operational costs. And so obviously the request is lower than what we were forecasting is needed to operate the business. And so that's where I talk about that will present challenges to the utility. Those challenges play out in the form of how do we prioritize all of the important things that we need to do. And I'll give you a quick example. Wildfire is going to be a high prioritization, right? So that's not going to be, something that's going to be haircut or adjusted necessarily, because that's an important risk to both our customers and to the utility to make sure we're addressing that. But that prioritization will cause us to go back and look at, do we make all these investments at the same time, or do they get pushed out 6 months? Do they get pushed out 3 months? Do they get pushed out 9 months? Certain O&M initiatives that we just have to manage inflation. I mean, inflation is a real cost, and it's very difficult for us, but those are the kinds of challenges that we'll be forced to do internally to make sure we can still provide the service. And so those are the challenges I'm referring to. We'll have to go back through our own reprioritization and making sure we're still hitting all the things we need to do, but the timing of when we do them may need to be adjusted.
Okay. Okay, that's helpful. And then I guess sort of just the last question that I had for you. You've you just mentioned wildfire mitigation. You talked a little bit about it with Hearing Examiner Ryan. That is also an interest. And I understand I think the top line dollar amount was something like 12 million of additional O&M and I think insurance premium expenses. That was the addition in the revenue requirement. And I can get into those details with, I think it might be Mr. Sanders. But just in terms of, I understand, I can easily understand how, a premium increase on the insurance side, how that would be a direct cost to PNM. Can you, I guess, flesh out to me how those O&M expenses regarding wildfires, how that money would be spent?
Sure, and I definitely think PNM Witness Sanders can probably give you a little bit more information than I have, but I'll give you a couple examples. So for example, we are going through and doing pole inspections for all of our poles in high risk fire areas. Those are incremental O&M costs that we are wanting to do. We're spending more money on vegetation management to making sure the high fire, I think I'm filling on it. Anyways, high fire risk areas are being addressed first and foremost. And a little bit that is a little bit of acceleration, right? So we might be spending more money to send out more crews to get those done now versus waiting on a normal 2 to 4 year cycle. So those are kind of the initiatives that we're trying to spend more money on because it's a pressing risk. And to be honest, I can tell you probably even the O&M dollars that we forecast when we filed the future test year, we're probably spending a little bit more than that already. And so, it's just, that's the prioritization that we do at this utility to make sure that we're addressing the biggest risks to our customers. And so those are kind of some of the examples of what we're spending the additional dollars on.
Great. That's very helpful.
And here's Emma Crankamp. Your questions, unless do you have further questioning? I have some
No,
stuff
I'm
that came up.
finished. By all means, go ahead.
Well, yeah. So hearing Emma Crankamp's questioning made me think of a few things. One of the things that come up with all the testimony is the contribution to the Good Neighbor Fund. And I'm sorry if I'm speaking too fast, Mr. Lee. So I'm trying to understand when I see the number 1.5 million, what does that represent? And then the question becomes, how am I to understand that number in relation to what level of a sort of generosity does that equal for PNM? How realistically will that benefit low income ratepayers? Because how many of them utilize that service, and how far will 1.5 million go? So can you give me any more information about what the commission is to make about that commitment?
Yeah, no, that's an excellent question. Thank you. So just to kind of level set, the Good Neighbor Fund over the last 4 years has generally given out approximately about $500,000 a year. That's to the benefit of anywhere between 3,000 to 4,000 customers a year. In 2023, the company made a contribution to the Good Neighbor Fund, and so 2023 is a little bit of an anomaly. We gave almost 700,000 or 800,000 out that year to about 6,000 or 7,000 customers that year. That was due in large parts to a very, very extreme summer that our customers experienced. But what will the 1.5 million do? I'll give you a couple of concrete examples. Because of the funding limits of where we've been in that Good Neighbor Fund, we've been capping the assistance a customer can receive at $120 in a 12-month period. This additional funding will allow us to go back to the $170 over a 12-month period. So it will allow us to provide a little bit more assistance to those of our customers who are in need of it. We also, talking with the individual who runs the Good Neighbor Fund, they want to make it as sustainable. So they plan to also increase the overall funding by about $300,000 a year. Obviously, that can change based on customer needs, and there's no specific guidelines, but that will allow us to also increase the number of customers that can receive the fund by about 1,500 to 2,000. So if you're just trying to put that in context, like I said, about 500,000 is what we take in and what we are able to pay out in a year. Sometimes a little higher, sometimes a little lower, but these are just general averages. And so that 1.5 million will allow us to increase the overall annual award we can give each customer and hopefully provide it to an increased number of customers for quite some time.
And did you give an approximate number of customers who have previously utilize the service under the reduced contribution amount? Did you say
Yeah,
700?
It's about 3,000 to 4,000 is what we've been running. And so
Ratepayers?
Of customers, yes, sir.
Yeah.
4,000 customers. And so then we're hoping about another 1,500 to 2,000 a year with the additional funding.
So from the utility
need and based on, requests, and then also increasing the amount of assistance we're able to give.
Okay. So from it sounds like from your perspective, at least the utility would take the position that that's a generous contribution that's significantly increased from previous practice.
Yes, sir. Yes.
And the one last question I had was, and I don't know, it's probably going to be very difficult for you to answer this, but I'm not if you don't, if it's too broad of a conversation, it's fine. And one of the questions I have is, we know that the PNM's ratepayers, or many of them, are low income, within 200% of the federal poverty level, and so the stipulation greatly reduces the increased costs that those ratepayers will face, but we know also that they're subsidized still anyway. So if they were actually asked to pay cost of service, it would be significant. I guess my question is, what is the long-term strategy for ensuring that PNM's ratepayers can afford electricity bills and like don't end up in a position where they, I don't know, feel as though like they're being sort of ignored in the question of affordability. And I will tell you, I know it's a broad question, I realize that, but I mean, one answer to this, I assume, is, well, grid mod, load shifting, reducing overall system costs through the technological investments. And I guess I'm just wondering if you have anything further to say about that subject.
No, and I think you hit on a great one, and I think I touched on it earlier. I think the one of the huge things we really hope to unlock is with grid mod is really being able to communicate and talk to our customers, and so they understand how shifts in their own usage of our product can help lower the overall cost that we're all receiving. I mean, I just think that is a fundamental mind shift in how customers have interacted with PNM, and it's exciting. And I think we can't lose sight of how monumental that shift is going to be for customers to start considering how they use their product and when it's most advantageous, not only to help lower their own bill, but to help lower the overall cost of the system itself. I guess, do I have the silver bullet answer? No. But I just want to give you, Mr. Hearing Examiner, the Commission, comfort that portability is first and foremost in our decisions. And how do we see that playing out? A lot of times we have to shift out capital into future periods above what's actually in our filing, because we kind of look at the impacts of our customers and what they can afford now versus spreading it over time. Obviously, you have to prioritize those because you also are obligated to make sure the system's reliable and safe. But it's just a natural tension that we have in here. The company itself looks for broader solutions. We joined EIM. The company is committed to joining the day-ahead market with CAISO. I believe we're starting to focus, and the commissions to start seeing filings for new transmission lines. I think transmission is going to be key to helping both unlock some of the resources in the state to make sure that our customers can take advantage of them, both unlock economic development so we can continue to grow our base. I know we continue to explore and look at regional solutions. I think regional is going to play the key to having more customers, a broader base, and being able to just optimize the system, not PNM system, which can be optimized, but really optimize a regional system. I think those are the critical steps and policies that we're exploring that we need to be moving forward to ensure that affordability for our customers is not lost.
Thank you. That was all I had for follow-up, Hearing Examiner Krankamp.
And Mr. Monroy, I did want to just follow up with you. I had a few questions about the Good Neighbor Fund as well. I was going to wait on these, but as long as just to follow up on what Hearing Examiner Ryan was asking you, just a couple of questions. PNM customers, your ratepayers themselves, they also have the ability to contribute to the Good Neighbor Fund as well. Is that right? I think when they pay online, at least.
That is correct. They have the ability to contribute to the Good Neighbor Fund.
Okay. And can you give me an idea of about how much money customers donate to the Good Neighbor Fund annually?
Sure. On average, it's around $200,000.
Okay.
And what I have, the number I have is that's total customer and PNM employee contributions. I don't have a breakout between those two, but I mean, PNM employees are customers too. So it's about
Right.
$200,000 a year.
Okay. Yeah, and again, I'm just trying to, like hearing Examiner Ryan, trying to put this into perspective, just in case it was asked, by the commissioners. I guess another question. So I think I heard you say that was it as part of the last rate case, PNM also made a contribution to the Good Neighbor Fund? Is that right? Did I hear you say that?
No, that was just made. That wasn't commission ordered or part of any settlement. That was the company's decision solely to make an additional contribution to the Good Neighbor Fund.
Okay. And when was that?
So they made one in 2023 for $650,000, and then additional $400,000 in 2024. Although the decision to do that was made in 2023, they just timed the funding.
Okay.
Yeah, that
Okay.
wasn't because of any regulatory proceeding. That was just our response to a very extreme summer that our customers experienced in 2023.
Okay. I don't have anything else, Chris. Hearing Examiner Ryan, anything on your end?
No, that's fine.
Okay. Let's see. Mr. Verheul, any questions on redirect?
None. Thank you.
Okay, thank you. And then any remaining questions from any of the commissioners or any of the parties, if anybody wants to raise their hand? Okay. Seeing none. Mr. Monroy, thank you very much for your testimony today, sir. We appreciate it.
Great. Thank you.
Thank you. Okay, that brings us to.
So, Crying Camp, why don't we take our morning break?
Yes.
Bio break is essential for me at this point.
Sounds good. So it's about 10 after right now. Why don't we come back at about 10:20?
Great.
And
thanks.
for now we'll be off the record. Thank you. Okay, it's 10:20. Is everybody ready to come back on the record? Okay, looks like it. Mr. Lee, sir, I think we're ready to go back on the record.
Thank you, sir.
Okay, we're back on the record, and I believe that it is time, Mr. Verhule, if you want to call your next witness.
Thank you, Mr. Hearing Examiner. PNM calls Adrian McKenzie.
Mr. Lee, if you would swear in the witness, please.
Mr. McKenzie, would you raise your right hand, please? You solemnly swear the testimony you're about to give, the matter not pending, should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir.
Mr. McKenzie, please state your name and your job title.
My name is Adrian McKenzie, and I'm a president of FinCap Inc., a regulatory consulting firm.
Do you have before you what has been labeled PNM Hearing Exhibit number 3?
Yes, I do.
And this is your testimony in support of stipulation?
That's correct.
Was this prepared by you or under your supervision?
Yes, it was.
And but for the is it a true and accurate account to the best of your knowledge?
Yes, it is.
Are there any additions or corrections to it?
No, sir.
If I asked you the same questions today, would the answers be the same?
Yes, they would be.
Mr. Hearing Examiner, at this time, I'd like to move to admit PNM Hearing Exhibit number 3.
Thank you. There being no objection pursuant to the stipulation, PNM Exhibit number 3 is admitted into the record.
Mr. McKenzie, do you also have before you what has been labeled PNM Hearing Exhibit number 12?
Yes, I do.
This is your direct testimony that was filed in June of last year.
That's correct.
Was this prepared by you or under your supervision?
Yes, it was.
And but for the stipulation, is it a true and accurate account to the best of your knowledge?
Yes, it is.
Are there any additions or corrections to it?
No, sir.
But for the stipulation, if I asked you the same questions today, would the answers be the same?
Yes, they would be.
Mr. Hearing Examiner, at this point, I would move to admit PNM Hearing Exhibit number 12, the direct testimony of Adrian McKenzie.
Thank you, Mr. Verhule. Again, there being no objection pursuant to the stipulation, PNM Exhibit number 12 is admitted into the record.
Thank you. At this point, I would offer the witness for any questions.
Thank you. Okay, let's see. Let's go through the commissioners. Commissioner Aguilera, do you have any questions for Mr. McKenzie?
I do not. Thank you, Hearing Examiner.
Thank you. Commissioner Nybert, any questions for Mr. McKenzie?
No, sir.
Thank you. Chair O'Connell, any questions for Mr. McKenzie?
Yeah, thank you. I just have a couple high-level questions and just for background, Mr. McKenzie, they stem from conversations that commissioners have about just overall goals of rate regulating utilities. So just broadly, do you believe that investor opinion or investor sentiment about how commissions decide rate cases, like and this particular items like ROE and capital structure, do those opinions have an impact on a utility's cost of debt?
Yes, I believe they do. I mean, I think to the extent that the investment community perceives the regulatory environment as positive, as credit supportive, that certainly can reduce the uncertainty that investors associate with a particular debt issue issued by a utility. It can help support the credit ratings, and all of that ultimately should lead to a lower cost of debt in the marketplace.
And then similarly, does it affect utilities' cost of equity?
Yes, absolutely. I mean, equity investors recognize the importance of the regulatory environment in terms of their ability to earn a fair rate of return, whether that's through regulatory lag or through a rate case process that leads to a return that perhaps investors don't view as constructive. All of those aspects of the regulatory environment are reflected in common equity investors' evaluation of the relative risk of owning a utility stock.
Yeah, thank you. And then, typical of the rate cases I've seen in my time on the commission, this case had testimony provided by numerous parties that covered an extremely wide range of potential ROE outcomes. Looking at the stipulation in this case, how do you expect investors to view the quality of the numbers in that stipulation for things like cost of debt and cost of equity?
Well, certainly from the standpoint of, first off, the cost of debt remains unchanged, I believe, from the company's filed case to the stipulation. With respect to the cost of equity and with respect to risk generally, which obviously is a concern for debt investors, I would expect the investment community to view this comprehensive settlement very favorably. One of the key concerns that the investment community has elaborated in the past is basically some concern over predictability of rate case outcomes for PNM. I think this stipulation really marks a turning point in the sense that the investment community sees that parties with very disparate interests, obviously different opinions about issues such as ROE, can get around a table and negotiate an outcome, a comprehensive outcome that essentially respects all of the parties' positions in the end. And I think this ability to negotiate, to come to agreement on a settlement is a major sign of improvement in the regulatory environment that I think the rating agencies recognize, and I think also common equity investors would recognize. It removes a level of uncertainty associated with a litigated case. It also, again, just reinforces that the parties are able to rise above this adversarial temperament that normally characterizes a rate proceeding and come to a constructive resolution of what are contentious issues. I think if the rest of the world could demonstrate the same degree of consideration, we'd all be in a better place. So, I think already PNM's conversations with the credit rating agencies, they've indicated to the company that they view this as a favorable outcome.
Yeah, thank you. And thank you for that clarification. I was thinking about future cost of debt, not what's in the case here. But would you agree that, for example, ROE is on the low end or below the numbers that are normally rewarded in or approved, I shouldn't say rewarded, in rate cases around the country?
Yes. I mean, I think, again, the certainty that comes from the stipulation is a positive for investors. I think the magnitude of the number that is reflected in the stipulation is a positive for customers. If we look at the last quarter of last year, for example, vertically integrated utilities in general rate cases such as this were awarded an average of 9.9% as an ROE. So clearly the 9.45 is attractive from the customer standpoint versus the national average. For 2024, the national average is about 9.84. So we've been seeing a slow uptick in allowed ROEs, which at least to a certain extent matches the higher interest rates we're seeing in the market. But again, the stipulation does preserve an ROE which is favorable to customers vis-a-vis the industry.
Yeah, thank you for that. And I mean, these questions stem from, observation hearing examiner Ryan made at the beginning of the hearing today is when we're faced with rate case filings, and frankly, the ROE testimony tends to be very hyperbolic. You get to a point where, okay, we've got a stipulation in front of us. As you've testified, the ROE number looks very consumer friendly. Just also hear that there will be dire consequences if investors aren't happy with the outcome of the rate case. So I'm just trying to understand how I hear you that the parties working together to find common ground is very valuable, and I agree with that. I'm just trying to square that against the, again, hyperbolic testimony that comes through in rate cases about that one particular number.
Yeah, and I think again that is one advantage to a stipulation is we avoid the hyperbolic. I'm very pleased not to have to write rebuttal testimony. Me and Mr. Monroy agree on that, and to the point that you were alluding to, at least with respect to perhaps coverage ratios and downgrades, and if we don't get this and if we don't get that, what's going to happen to our credit metrics? I mean, those are all very legitimate considerations for the company on a long-term basis. They do have to maintain their credit standing so that they can raise the capital that's necessary to meet a very challenging capital expenditure budget over the next years to meet the energy transition, all those things. But this settlement does go some way to not only to reassuring the credit rating agencies and investors in terms of the tenor of the regulatory environment, it also improves the credit metrics. So coupled with the company's ability to renegotiate the Atrisco battery contract, for example, to remove that from being a debt equivalent in the eyes of the credit rating agencies, along with the ROE and the capital structure incorporated in the settlement, they can achieve a metric which will allow them to maintain their current ratings. So that's obviously a priority both for the company and ultimately for customers.
Well, yeah, thank you, Mr. McKenzie. That was the topic I wanted to explore, and thank you for your testimony in this hearing.
Thank you, sir.
No further questions from me, Mr. Krankamp.
Thank you, Mr. Chair. I appreciate it. Hearing Examiner Ryan, any questions for Mr. McKenzie?
Yeah, I'll start just by following up with where Commissioner O'Connell was. And I've read all the testimony in this case, both the direct and all the intervener responses in the stipulation as to why the ROE number is correct. But so, Mr. McKenzie, when after the rate case occurs, right, it seems like there's a possibility of two different outcomes. Number one, the ROE was set at a number that was too low, or alternatively was set at a number that's too high. What are the indicators that we can look at which give us an answer to that question? So how do we know? Like, and I think that's one of the things when your application came in and I read the testimony, I just felt wondering, like, well, what we set last time, what impact did that have? How would we measure it? And why would the commission have, would doubt itself about whether it was correctly set? I hope I've asked you a clear question.
Oh, certainly. Obviously, it's very difficult given the fact that we can't observe the cost of equity. You can observe the cost of debt, but not the cost of equity. Obviously, that's a challenging question because it becomes very difficult to develop an analysis before a rate case and after a rate case, and has it affected the cost of equity? We can look more directly, I think, at investment commentary to get some sense of how a regulatory decision is perceived. And after the last case, certainly S&P noted that it was not, in their view, a credit supportive outcome. We had investment advisory services like Value Line, which is widely followed, saying it was a poor outcome. But I think the investment community, and particularly the bond rating agencies, also recognize that perhaps the last rate case was not the best case on which to judge what's going to happen with the regulatory environment in New Mexico going forward. I think they recognized there was some legacy issues that complicated the last case. And so they really were taking a wait and see attitude. And I think a positive outcome in this case, which I believe the settlement represents, would I think go a long way to reassuring them that there has been a change. I think the other obvious but less favorable way of judging the impact of a rate case would be ultimately if a company were downgraded as the result of it, which does happen. It happened in Arizona. It's happened in other states where an unfavorable outcome was sufficient enough to provoke a downgrade in the credit rating. But that, I think, is a more extreme example. I think the rating agencies and investors have a degree of patience. They are willing to wait and see how the dust settles and how the commission will be adjudicating these proceedings going forward, and whether the parties can work out an agreement that ultimately satisfies the need to maintain the company's financial strength. And I think this agreement does that.
Just for clarity, if I remember correctly, and I should know this, but it's kind of 9.26 was the 270 case, correct?
That's correct.
And then to move to 9.45, what does that mean in terms of total dollars? I mean, as far as can we just say that equals this many more dollars for purposes of equity?
We could, but I can't. So I think perhaps another witness can address the dollar impact. But I would point out, we are looking at an increase in the ROE certainly, but it's nowhere as significant as the increase in debt costs, which is a barometer for capital costs, right? I mean, it's one thing we can look at definitively in the market. And for example, in the last case, Ms. Reno referenced a 30-year Treasury bond yield in her testimony when she was supporting her recommendation in that case. That yield is now 100 basis points higher in the market today, which means the cost of capital has increased. So directionally, the ROE is going in the right direction. I think that's also important for investors to see. We're not seeing a case where the ROE is moving in an opposite way to observable benchmarks for capital costs like bond yields. But I can't tell you the dollar impact of a 19 basis point increase in the ROE.
Okay. A sort of macro level question too. The Bluefield and Hope cases, and I see them cited with great frequency in the ROE testimony that the commission receives and the varying utilities it regulates, and then just writing about it throughout. It struck me as interesting because those cases are, what are the years on them? 1923 and 44. Certainly the financial landscape, just in terms of the sophistication of like spreading risk. I mean, just mechanisms that existed in finance, or that exist in finance now that didn't at those times those cases were decided. It always leaves me wondering, like, what use are Bluefield and Hope anymore, and to what extent do they just create pretty much the most general standards one could think of, as far as like guiding, and maybe that's beneficial. But I sit around wondering. I read the cases and I read the standards, and I feel like these aren't. There was really nothing to them. It's like whatever's reasonable. But maybe that's the best the law can do in this context. And I'm not asking you as a lawyer. I'm wondering more from your perspective as a analyst when you recite those cases and you say these are the standards. I mean, what is it you're thinking about? Do you have those thoughts too? Like this is all outdated?
No, I don't share those thoughts. I mean, I think, and I'm not a lawyer, but the 14th Amendment
I've
hasn't
lost the
changed.
witness.
Sorry? I'm sorry.
I lost your voice there for a minute. No, I do not share.
Okay, I don't share your opinion that they're outdated in the sense of their relevance for this case. Again, the 14th Amendment hasn't changed. It's all about takings. And yes, they are very general, and I think that's a good thing. Basically, those cases established that it's the end result that matters. It's not how you get there. So the Supreme Court is not telling us how to apply the CAP-M or the DCF to get a reasonable ROE, but they are saying that these basic principles of maintaining the company's financial strength, of maintaining the company's ability to attract capital, and providing a fair rate of return to investors are important. And they're also ensuring that there is a balance between customer and ratepayer interests. So customers should not pay more than the cost of debt or the cost of equity. Now that leaves it to regulators in the context of a litigated proceeding to wade through the evidence and decide what that reasonable level is. And then we have benchmarks like we discussed earlier to say, well, did they meet that test? And certainly if the company's credit metrics erode so that it is endangered in terms of its bond rating, if it is unable to provide a return on equity that matches other available investments of comparable risk, then we have a situation where the Hope and Bluefield tenets are being violated. So, and that's clearly why regulatory lag is an issue.
Hang on, Mr. McKenzie. Hang on.
Is everybody else losing me, or?
Hang on. I did not lose you, but Mr. Lee did.
I got Hope and Bluefield tenants are being.
And Mr. Lee, is it that the witness is speaking too fast, or that his audio is cutting in and out on your end?
Cutting in and out.
Why don't we try this, Mr. McKenzie? If you want to just try speaking up, maybe just a little louder. Maybe that'll help Mr. Lee.
Yeah, I think it's not a question of volume. It sounds like the connection is not good on his end, but I will endeavor to speak louder if that helps him.
Thank you.
Yeah.
So if you could pick up where you left off, and Mr. Lee, where was that again?
The Hope and Bluefield tenants.
Mr. McKenzie, if it helps at all, I think you were saying if the company's credit metrics erode such that it is endangered in terms of its bond rating, or if it's unable to provide a return on equity that matches other available investments of comparable risk, then we have a situation where the Hope and Bluefield tenants are being, and then that's where Mr. Lee lost you, if you want to pick up from there.
Okay. They're being violated. So I think the principles behind Hope and Bluefield still apply, and I grant that there is no specificity in terms of how we go about the nuts and bolts of regulation, but that allows for changes over time. So as you mentioned, back in 44 and 23 or 29, nobody had a concept of the DCF model or the CAP-M or beta or risk premium approaches. They were basically looking at comparable earnings. Those models have been introduced over time, and and it doesn't require a Supreme Court decision to allow that. So, I think the flexibility afforded by those decisions is helpful, but the principles still apply.
At page 9 of your stipulation testimony, if you could just go there at lines 5 through 7, you write, the investment community has highlighted a disparity between authorized ROEs for utilities and underlying capital market conditions, as reflected in observable bond yields. I was hoping you could unpack that a little bit for me, just explain the point you're making there.
Sure. Basically, allowed ROEs are like turning a battleship. Capital markets can react very quickly. So we had a situation where we had a very significant increase in bond yields. And I discussed this in greater detail in my direct testimony, but we had a very significant increase in bond yields starting in the first quarter of 2022. And bond yields, again, they're an indicator of capital costs. The cost of equity is an opportunity cost. So investors recognize that they can earn certain returns for certain investments out in the marketplace. And if the return on long-term debt goes up, they expect the cost of equity to move in the same direction, not by the same amount necessarily, but in the same direction. So we had a directional change in the long-term debt cost, which was significant. That change has not been matched by similar increases in allowed ROEs. And the investment community has pointed that out here. Basically, there hasn't been a proportional increase. The investment community recognizes, I think, something that is frequently an issue in rate cases currently, which is affordability. That was discussed earlier. So the regulators are faced with balancing consumer interests and the interests of investors and making sure these Hope and Bluefield standards aren't violated. The investment community also recognizes that affordability has been pressuring ROEs downward in a manner that probably doesn't really reflect the underlying economic conditions. So, as I point out in my testimony, the last time that bond yields were where they are now, the allowed return was averaging over 10%. So we're not there yet. You know, we've moved up to 9.9 and it's moving up very slowly. But that's the point I'm making, is that if you look at where bond yields are, the cost of equity should be higher today than is reflected in current allowed returns, in my view.
At page 10, lines 10 through 11, yields on BAA rated public utility bonds average 5.77% during November 2024. I guess I'm just curious, what should I take away from that statement there?
Well, in isolation, that's not that helpful, but I think what you need to do is look at the table on the following page, on page 11. And there I'm showing that for those 3 years, 2010 through 2012, the average allowed ROE was 10.17. And the average bond yield at that time was 5.47, a little lower than, in fact, we're up to about 6% now. So that's really making the point that we just discussed, is that, again, if you buy the accepted notion that there's a risk premium here between utility debt and utility equity, if bond yields are about where they were or higher when authorized returns were above 10, that's a benchmark. And it certainly shows that 9.45 is a reasonable outcome in the context of a comprehensive settlement.
And what is the, I mean, to the extent to which I'm the increase in the bond yield numbers, is there some thing that we can attribute that to? I mean, I understand that's a very broad question.
Yeah, there's any number of things we can attribute that to. Certainly at the beginning of this increase in bond yields, it was due to much higher inflation expectations. Those, because of the Federal Reserve's moves to tighten economic policy, right? So that had an effect on bond yields. Now we're seeing a situation where we've had some very positive developments in terms of inflation rates. It came down from a peak of 9% to about 3% in January. But that 3% marks an uptick, and now there's concern that perhaps the fiscal policies of the incoming administration might result in higher inflation. So you have concerns about the impacts of tariffs, concerns about the impacts of expanding budgetary deficits, and what that means for long-term capital. Investors expect to be rewarded to recover that cost of inflation. So that's going to be reflected in required returns, as are overall uncertainties about the path of the economy and other considerations.
Okay, thank you. Those were all the questions I had, Hearing Examiner Krankamp.
Thank you, Hearing Examiner Ryan. Good morning, Mr. McKenzie. I just have a few questions for you.
Yes, sir.
And this is mostly going to be following up on, I think, questions that the chair was asking you earlier. Can you turn to page 6 of your stipulation testimony?
Okay, I'm there.
So I was struck by this this table, and then the sentence on between lines 12 and 14 there, where you said that the 9.45% ROE established in the stipulation falls below the average and median ROEs authorized for other integrated electric utilities in each of the most recent 8 quarters. That would tell me, I mean, my interpretation of that would be if it's below the average and median ROEs, then an ROE of 9.45% would sort of inhibit PNM in terms of attracting capital. What I understood you to testify previously to the chair was that normally it would, but the investment community will appreciate the fact that this was an ROE that was established through a stipulation. Is that a fair description of your testimony previously?
Yeah, I mean, let's be clear. Investors would be a lot happier at an ROE of 10.45, right? I mean, that would give the company a lot more cushion in terms of its financial metrics. It might even result in an upgrade to their credit rating, which could be positive. But again, the regulatory environment is not evaluated strictly on the basis of some credit metric, like a funds from operations to debt ratio. That's one important thing that the credit rating agencies might look at. But I think turning back to my testimony earlier, yes, the stipulation, the fact that it was agreed to, it's an unopposed stipulation. It's a comprehensive settlement. And it marks a departure from the very adversarial cases that have characterized PNM's rate cases in the recent past, goes a long way to reassuring investors and taking away some of that uncertainty that they build into the costs that they require. So again, taken as a whole in the context of the settlement, this is a good outcome. And I would also point out that, the headline number of an ROE within the context of a litigated case, it perhaps has more significance than it does within the settlement. I mean, I don't think it's appropriate to look at the ROE in a silo. It's one of the considerations that went into the entire package that led to the revenue requirement that all the parties agreed to. And how they reached that, we don't really know all the inner workings and the thought process behind it. We know that all the parties are sophisticated. They all had skilled practitioners, subject matter experts to help them in their analysis in order for them to all reach a conclusion that this would be equally painful. As Mr. Monroe pointed out, nobody's perfectly happy, but everybody's happy enough to sign. So I think that the settlement, it's important to see it as a whole, not as individual pieces like a 9.45 ROE.
Right. Well, and the reason that I asked that, again, as you know, one of the standards for stipulations, I was discussing a different standard for stipulation with Mr. Monroy, but one of the standards, maybe the most important one, is whether the stipulation is in the public interest. And what I'm sort of getting from your testimony is the fact that this is an uncontested stipulation is itself, in some sense, evidence that it's in the public interest, because the investment community will appreciate the fact that PNM was able to reach this agreement with all the other parties to the case. Is that correct?
Yes, I agree with that wholeheartedly. And again, from the standpoint of investors, it's positive because it gives some certainty, because it evidences an improvement in the regulatory environment. It does improve the ROE. It provides a capital structure, which is an improvement over the last case. All of those things allow PNM to improve its credit metrics within the guideline ratios for its current rating, albeit at the low end. And for customers, it clearly provides an ROE that's below what is being approved in other regulatory jurisdictions. So it's a burden it's less burdensome for customers in New Mexico than it is in other states. And the capital structure is in line with, albeit a little bit lower in terms of an equity component than has been authorized in recent electric rate proceedings.
Okay. One clarification question I was going to ask you, especially when the chair was asking you questions, you referred to the investment community. Just for my own purposes, can you sort of flesh out who you're referring to when you use that term? Are you referring to the credit agencies, the credit rating agencies? Just when you say investment community, how am I to interpret that phrase?
Well, that applies both to the bondholder constituents as well as common equity investors. I think both of those parties would view this settlement in a favorable light. Obviously, the credit rating agencies, since they publish regular reports, they're independent agencies. We look to them for guidance as to the opinion of investors, and certainly while credit rating agencies' responsibilities are to bondholders, not to stockholders, there's a lot of overlap between the risk factors that are considered in assigning a rating and the risk factors that investors would consider before buying a common stock.
Okay.
I lost him again. Wait. Can you hear me?
Yes, I can, Mr. Lee.
I have no idea why it's cutting out. I can't see. Now it's saying my connection is unstable.
Yeah.
Consider before buying a common stock. That was the last thing I heard.
Okay.
I think that might have been the last thing I said.
Thank you. Go ahead, Judge.
Yeah, I'm looking at the answer now. I think that's a satisfactory answer in any event. Last question to you, Mr. McKenzie. If you look at page 7 of your stipulation testimony, you were asked a question there that I found a little bit striking. And the question is the same level of rigor necessary to evaluate the reasonableness of the ROE established in the stipulation? And the answer to that question was no. Can you elaborate on your answer there? It would seem in some sense that the commission's obligation to ensure just and reasonable rates would be unchanged between a stipulation and then a litigated case. So if you could then explain why that same level of rigor is unnecessary in a case like this, that would be helpful to me.
Absolutely. And I believe that the same level of rigor is necessary both in a litigated case and in reviewing a settlement. So I'm not suggesting that the commission's burden has changed. What I am suggesting is, going back to our earlier discussion, that I think it's not appropriate to single out a single component of a comprehensive settlement and evaluate that under a microscope, because the agreement essentially requires give and take on any number of other issues, as well as ROE.
Stop. Sorry, Mr. Lee is waving his hand.
Hang on, Mr. McKenzie.
Mr. Lee, you're muted.
You're muted, sir.
If you want to give me a minute, I can pull up a hotspot, because I have no.
Okay. Why don't we take 5 minutes? It's 11.
Well, why don't we let's Yeah, let's take a, but John, Karen's our chronic kid. Let's stay on with Mr. Lee and see. The parties can go, but we should stay and just figure this problem out. We'll be off record, but we
We'll be
got
off
to see
record
if, yeah.
for 5 minutes.
Let me get my hotspot. It's
that might be where, Mr. Lee, are you in? Well, he probably grabbing something. I'm thinking when this happens, usually it somehow there are varying neighborhoods. Sometimes it will be impacted. It
Yeah.
depends on where Mr. Lee is living. Because I know I've had issues where it's like up where we are, it'll all of a sudden get super slow. And like that's not a consistent. And there was actually a time that the building was out, but everybody else was up, which was
Yeah,
crazy.
I remember that happening.
So my guess is that this is somehow wherever Mr. Lee is he's having. We should check with him. Now again, I don't answer any of these questions.
I'm on the south side of Santa Fe, and I've never really only had a problem one other time in all the hearings I've taken.
Yeah, I know that. And so, Mr. Lee, just one thing that can impact is anyone else in your household utilizing internet service for any purpose. Like, so for instance, if someone has a television on and it requires to come through your internet, then that can somehow impact the speeds and create that circumstance.
Thank you for that. No one else is here at the moment, but
okay. If you have like
video off,
that might help too.
If I take the video off, I may not know who's speaking.
Yeah, that's true. Well,
you could turn your video off. Yeah, you could turn your video off.
Okay, let me.
And the only issue there, of course, is it's, for instance, we just saw Mr. Lee waving his arms, and
yeah,
he'd have to make audible indications.
Yeah,
I suppose that we can just do that until. I suppose the other alternative would be we try to wrap up with Mr. McKenzie, and then take our lunch break and allow Mr. Lee to. I don't.
Hotspot on. Let me switch.
It may dump you out, Mr. Lee. If you do, we'll let you back in. Yeah, I think it
kicked him out.
Yeah, it dumped him. Yeah, it's going because he had to switch. But I do think it is probably, if he's working off a hotspot, the thing that's going to eat the most bandwidth of the hotspot's definitely going to be his video.
Yeah.
But then also what's going on is he's actually seeing a video.
Mm-hmm.
I'm wondering maybe it'd be better for him to call in.
Well, that may make it more difficult for him. I don't know.
I don't know either. Because if he's just operating off audio, then actually having like just your cell running.
I think they typically prefer to have their video on.
Yeah, no, I know they do, but if that can't happen.
Yeah. I mean, we could, in theory, break for lunch. It's a little early.
It is, and there's Mr. Lee's in the waiting room.
I'll just let him in.
I wonder if that does to the real time. If anything.
Yeah. Yeah, we can hear you. You're sort of cutting in and out. Can you try again?
Can you hear me?
Yeah, now I can hear you.
How about us? Are we clear on your end?
Yes, you are. You guys are the only thing on this hotspot, so hopefully we'll be fine.
Okay.
Okay.
Okay. Well, just let us know if you're still having issues and we'll try to troubleshoot as need be.
Thank you.
Okay. Let's see. Before we get back on the record, do we have everyone with us? Mr. McKenzie, you there?
Yes, I am.
And
Mr.
then
Lee,
Mr.
can you hear me?
Are you there,
Mr.
Judge?
Yeah, we are here. You just froze. I'm not sure if you heard Mr. McKenzie.
I did not, but let me, can you hear me?
Yes.
Yeah,
There's
I have yeah.
nothing on this hotspot, and it is saying I have an unstable connection, so it must be something in the area.
Could be.
I'm going.
I think we should break for lunch. I think we have to figure out a permanent solution.
I agree. I agree. Okay, Mr. Lee, I think what we're going to do now is we're going to break for lunch. We'll hopefully get your internet back. What time do you want to come back, Hearing Examiner Ryan? At noon?
Yeah, and
12:30?
I guess if the parties will just reappear on Zoom, by noon, and then hopefully we'll see if we need more time. We need more time because we got to have our court reporter.
Yeah. Mr. Verheul, I see you nodding your head. Is that acceptable to you?
I don't have a better solution, Mr. Hearing Examiner.
Yeah.
Okay. All right. Well, we'll be off the record until about noon, and hopefully our technical issues will be resolved at that point. Thank you, everybody.
Great. Yeah.
Thank you.
Mr. Lee, why don't
I'm going to go out and see if I can reset the system or figure out what's going on.
Yeah, that might be the thing to do.
You'll have to let me in back at noontime.
We will.
Yeah.
We'll let you back in as soon as you try. I think one of us will probably be monitoring the Zoom.
Right, and I suppose the only other option would be, there seems like there's two things. If we can't get it, because we having those interruptions isn't going to work. So I suppose if it's remains unstable, then we would have to either, number one, not resume today, or if there's an alternative location where you can go. I don't know if that's an option.
I could go to my office.
Yeah, I mean that would be the only other option, I suppose. And if we had to take a little break for that, Mr. Lee, don't worry about it. I mean, it has to be. We just need to make this work.
If he's in Santa Fe, he could come here, couldn't he?
His machinery equipment.
My office is close. It's like 15 minutes away.
Okay.
All right. Well, Mr. Lee, how about you just we'll keep our Zoom things on, and when you need to jump in and let us know information, just do that. I'll just leave my speaker on.
Just say for whatever it's worth, I switch back to the other one. Oh no, I'm on the other. I'm still on this one. All right. Well, I'll see if I can reset it or figure it out.
Okay.
Great.
Thank you, gentlemen.
sir. Appreciate it.
Okay.
Judge Ryan or Judge Cronenkamp,
Yes, sir, I'm here. This is John.
I've reset the system. I don't have any way of knowing if it's stable or not, but according to according to someone who may know, I have reestablished a new sort of channel altogether. So I've never had really this issue before. My hotspot is also set up just in case I have to switch to it. And in the alternative, I can go to the office and perhaps from this point forward, well, I'll start with my video on and then I could turn it off, or else I could just leave it off at your discretion.
Okay. Yeah, you're welcome to leave your camera off. That's totally your call. That sounds good. We'll take a chance. We'll see how it is at noon. So
okay. Thank you very much.
Thanks, sir. Appreciate it.
I'm here, gentlemen, and I am going to turn my video off.
Okay,
Great.
no,
Well,
no
and
problem.
Mr. Lee, feel free to interject audibly whenever you feel the need to do so.
Thank you, sir.
Hearing examiner Ryan, should we wait until right at noon?
Well, we did say we would wait till noon,
We did.
so let's just wait a few minutes here. And then, I don't know, maybe Mr. McKenzie, before we go on the record, I don't know, just to make sure that, 'cause it seems like the problem with Mr. Lee came from your side. But I know it's not you, but for whatever reason, that's how we experience it. So I just want to make sure he hear you. I don't want you to have to like say the alphabet or anything, but
Okay, well, I'm here and I'm ready to go whenever Mr. Lee is ready.
Mr. Lee, was he clear on your end?
Yes, sir.
Okay.
Ms. Beatles, it's good to see you.
Likewise. And Mr. Hearing Examiners, thank you for accommodating me this morning and let me know when you would like me to enter my appearance for the record. I have been following on YouTube.
Okay, that sounds good. Maybe we'll do that right when we just come back and we'll just get it out of the way. Okay, I have noon. I think everybody's ready to proceed. So with that, Mr. Lee, if we could go back on the record, sir.
Go ahead.
Okay, we're back on the record. The time is now noon. And before we resume the questioning of Mr. McKenzie, we are joined now by Ms. Beatles from Western Resource Advocates, and I'd like her to just enter her appearance for the record.
Yes, thank you. I'd like to enter my appearance. Sydney Beatles for Western Resource Advocates.
Thank you. Appreciate it. And with that, we'll go ahead and resume, Mr. McKenzie. Where we left off, I had asked you about the question in your testimony, your stipulation testimony on page 7, whether the same level of rigor was necessary to evaluate the reasonableness of the ROE. I think you had said that you believe that the same level of rigor was necessary between a litigated case and a settlement case, but it was not appropriate to single out a single component of a stipulation. Do you want to resume that answer and maybe just give that answer again?
Yes, sir. Thank you. I think you characterized my testimony correctly in terms of the overall burden on the commission to make sure that the end result of a stipulated settlement or a litigated case is reasonable balance between investors and consumers. I don't think the burden has changed. I think the commission has to exercise its authority both over settlements and over litigated proceedings. But I think the the way that the commission exercises that authority, I think, within the context of a comprehensive settlement is different. So in the case of the ROE specifically, where we would, if we had a litigated proceeding, the commission would have to consider a lot of evidence on detailed applications of various financial models and the respective positions of the expert witnesses in that subject area, and come to some definitive conclusion as to how to apply models, which models to give most weight to, and ultimately what it believes to be a fair ROE given the evidentiary record. In the case of a settlement, I think number one, the commission should recognize that, again, the ROE is just a single component of an overall comprehensive agreement. So there is give and take among the parties on various issues to the settlement. The 9.45 ROE, while it wouldn't be the litigation position of the company, within the context of the other aspects of the settlement, is acceptable to the company and allows it to maintain its financial integrity. So I think the commission in this respect can look to more general benchmarks, such as those that I've presented in my testimony. And those benchmarks would be authorized returns in other jurisdictions, indicators of how a DCF model might be applied, let's say, under the same framework that the commission has adopted in past proceedings. These types of general benchmarks provide the commission with the evidence it needs to ensure itself that the ROE is in the public interest, and the settlement as a whole is in the public interest, but it doesn't require delving into the more complex issues of applications of financial models and all of the evidentiary requirements to apply those models.
Okay. And just, I guess, to put a fine point on that, if we look at your direct testimony, and page 22 of that, you talk a little bit about at that time, you talked a little bit about the application of the PRC's DCF precedent, sort of consistent with what you were just referring to. And you talked about the application of that precedent would result in an ROE range of 9.5% to 10.2% with a midpoint of 9.9. So I guess what you're saying is, even though this particular ROE would actually be below that that ROE range, it's still reasonable in the context of this overall stipulation. Is that fair?
Yes, that's fair. And I develop a similar application of that DCF precedent in my stipulation testimony on page 5, and show that the 9.45 just falls just slightly below the bottom end of that 9.5 to 10.5 range. So again, I think the commission can be confident that the 9.45 ROE is a positive outcome for ratepayers.
Okay. And then I did have one other clarification question for you. This is in your stipulation testimony. There's on page 8, again, your stipulation testimony, you talk about greater care should be given to avoid an apples and oranges comparison when referencing authorized ROEs in a litigated proceeding. Can you clarify what you mean by apples and oranges? Are you referring to, let's say, a stipulation case on the one hand and a litigated case on the other? Is that what you mean by apples and oranges?
No, there I'm actually referring to, again, I'm trying to draw a distinction between the evidentiary burden that the commission might have to prove up every single aspect of a litigated proceeding, such as ROE, versus a stipulated settlement. And what I'm suggesting here is that, we all know that authorized returns in prior cases in other jurisdictions are often discussed both in litigated proceedings and in settlement cases as a benchmark, as a general rule of thumb. And what I'm saying here is that while I do encourage the commission to look at that evidence as a way of demonstrating to itself that it can be comfortable with the 9.545 ROE, I think if this were to be a litigated case, there are differences between outcomes in prior cases that that don't allow the commission to rely specifically on, let's say, RRA data, allowed returns as the basis to set an ROE in a litigated case. Those apples to oranges that I'm referring to can be any number of things. One of them would be differences in capital costs between the time when a regulator in some other jurisdiction set an ROE and the current period when the commission is examining the evidence. So to the extent that interest rates go up or down, that can affect the reasonableness of a historic ROE versus what might be warranted in the present circumstances. Other considerations could be risk differences. Another one could be differences in the utility services provided. So to the extent that we are looking at an allowed ROE for a distribution-only utility that doesn't have generation resources, that also can be a distinction that's important and that can differentiate ROE findings from what might be warranted in any single litigated proceeding.
Okay. That makes sense. Thank you very much for your testimony, Mr. McKenzie. Hearing Examiner Ryan, did you have any follow-up questions for Mr. McKenzie?
Yeah, just a few, Mr. McKenzie, real quickly. Going back to the question about what is the financial impact of moving from 9.26 to 9.45, the previously approved ROE to the present. The answer might be no. So if that's the case, that's fine. If I was to figure out, for instance, we started at 10.45 and came down 100 basis points to 9.45, and that was basically a $20 million forfeiture from the company's part. And forfeiture may not be the right word, but they agreed to forego that amount. Could I use those figures somehow to make a rough estimate of what 0.19 means in terms of the company from the previous ROE to the present?
Yeah, I mean, if we know that 20 million is the impact of 100 basis point change, then we could certainly just divide that by 100 and multiply by 19, and that should give us our answer.
Okay. And then this is a purely mechanics question. So when we talk about attracting capital, and I'm thinking right now, just recently, PNM filed a financing case, 250012, I think is the number it was given. It's somewhere on my machine here. I believe that's correct. Yes, 250012. That's a financing case. And if you don't know the answers, it's fine. I'm just trying to understand the mechanics. So the company will go out and issue unsecured notes or notes of some kind, which I understand is sort of the debt part of the equation. Is that correct?
Well, I don't know the specifics of the case you're referring to, but I mean, general utility practice, you would perhaps rely on short-term securities for an amount of time until it's practical to go out and issue long-term debt, depending on market situation, and depending, you're not going to issue long-term bonds to cover every expenditure. You'll build up your short-term debt and then go out to the market and issue long-term securities as a way of ultimately financing investment in long-term plan.
Okay, so what you're saying there, if I understood correctly, is that actually that application where they're talking about senior unsecured notes and a revolving credit facility that may reflect short-term debt?
Correct. Yeah, shorter term.
And that's different than the long-term debt that's identified within the weighted average cost of capital that's in this case?
That's right. And usually, again, it's just the method of financing lends itself to reliance on shorter term instruments in the immediate term till the balance builds up to a certain point. And then given the debt markets and when the company feels is a good time to go out in the market to issue long-term debt, it will issue that debt and retire the short-term obligations.
Okay. So that's what I guess what I'm trying to say is that part of it I think I understand, because the whatever long-term debt or however you're doing it short-term debt, the actual notes themselves or whatever instrument it is will specify the payments that PNM has to make to borrow that money, correct?
Yes, they will. And the interest rates on those instruments will reflect the degree of security, the maturity of the instrument, et cetera, which would differ from a long-term secured bond.
But is ultimately does all of that sort of become a part of PNM's long-term debt cost, or no? Or is it sort of separate things?
Well, it will only become a part of PNM's long-term debt costs when the utility retires that short-term debt by issuing new long-term bonds in the market.
Okay. So then really the where I wanted to go with all this was that I think I understand all that, but when I'm trying to understand when we talk about attracting equity capital, when we say the cost is 9.45 and it was 10.45 in the application, whatever. When we say those numbers, where does that appear? Like that's not something that PNM's going out and obviously issuing things with this number specified. Like, and maybe it is. I don't really like understand the mechanics of how we go from a set return on equity to the actual instances where the utility's receiving capital investments at that specified amount. And I know that might not even occur. I'm just curious if you can give me a little tutorial on how that function works.
Yeah, so that's the difficulty when we turn to equity is as you mentioned, there is no observable return requirement. Common stockholders don't have the same type of security that a debt holder has, an instrument that actually specifies contractually the return that the company has to give to the common equity holder. The common equity holder essentially only receives dividends and or capital gains when they sell the stock. And that's why determining the cost of equity is so complicated. There's nothing we can look to that specifies that number. We can look to general benchmarks like trends in bond yields, and we can apply financial models like the DCF to try to get inside the common equity investor's mind. What do they expect when they buy a share of PNM stock or any other publicly traded utility? They have in their mind some notion of the return they're going to receive through those two components, dividends and stock price appreciation. So we have to kind of work backwards with financial models to determine that. But it is a real cost that the company has to pay. And in order to be able to continue to maintain its stock price, to continue to be able to issue new common stock at a reasonable cost, the commission needs to authorize a return that allows that. And the other part of this equation is that the ROE does play a very central role, obviously, in the cash flow that the utility is able to obtain through providing service. So to the extent that the ROE is reduced, that reduces cash flows. It also has impacts on bondholders because the cushion, if you will, above the payments that debt holders receive would be reduced through that. So that's why the coverage ratios, like the fund from operations to debt ratio, is such a critical component of the credit ratings evaluation of the utility.
Okay. You may what's the yield, the dividend yield that the PNM stock is paying at present, or what has sort of ballpark been what they pay?
Yeah, I can give you some indication. It's around 3.5% currently.
Okay, and you indicated that's a part of that equation of how we figure out how do you attract equity capital when you're paying dividends that utility stocks frequently do. That's part of that component.
That's part of the return that investors receive by owning the stock, certainly. And then again, the other component is capital gains through an appreciating stock price, which is not realized until the investor sells the stock, but that's the other side of it. So to the extent that an ROE is set that's below where investors think it should be, then potentially the stock price could decline, which
Gotcha.
implies a negative return to stockholders in effect.
Okay, well, those were all my follow-up questions. Thank you, Mr. McKenzie.
You're very welcome.
Thank you. Mr. Verheul, any questions on redirect?
I have none. Thank you.
Thank you. Any remaining questions from the commissioners? Seeing none. Mr. McKenzie, thank you very much for testifying here today. We appreciate it.
Thank you very much.
Thank you. Okay, Mr. Verheul, you can call your third witness.
I'm going to do an attorney switch here, Mr. Hearing Examiner, so my colleague, Ms. Terwilliger, will take it from here.
Good afternoon, Ms. Terwilliger.
Noon. PNM calls Mr. Kyle Sanders.
Okay. Is Mr. Sanders with us?
He should be, or he's making his way to the.
He has to come into the, I don't see him in the waiting room yet, unless he's already in. PNM witness is in, so.
Yeah, that's him. He'll just have to get into that room. He
Sure.
might not have been expecting that Mr. McKenzie would wrap up so quickly. So just give us 1 second.
No problem.
He is on his way, and I expect him to be ready within the next minute.
Great. Thank you.
Good afternoon, Mr. Sanders.
Good afternoon.
Good afternoon. Can I, let's see, Mr. Lee, are you able to swear in the witness?
Yes, Your Honor.
Okay, please do so.
Mr. Sanders, would you please raise your right hand? You solemnly swear the testimony you're about to give, no matter not penny, should be the truth, the whole truth, nothing but the truth.
Yes, sir.
Thank you, sir.
Sanders, can you state your name and your title for the record, please?
My name is Kyle Sanders. I am the Executive Director of Financial Planning, Corporate Budget, and Cost of Service.
And you're filing testimony on behalf of whom?
PNM, the company.
And you have in front of you what's been marked as PNM Exhibit number 4, which is your direct testimony in support of the stipulation filed on January 10th, 2025. Is that right?
Yes, ma'am.
That testimony was prepared by you or under your direction?
Yes, ma'am.
And is this testimony true and accurate to the best of your knowledge?
Yes, ma'am.
Do you have any additions or corrections to that testimony?
I do not.
And if I ask you the same questions today, would your answers be the same?
Yes.
I move for admission of PNM Exhibit number 4, please.
Thank you. Per the stipulation, there's no objection, so PNM Exhibit 4 is hereby admitted into the record.
Mr. Sanders, you have in front of you what's been marked as PNM Exhibit number 13, which is your direct testimony filed June 14th, 2024.
Yes, ma'am.
Is that testimony filed by you or under your direction?
Yes, ma'am.
And subject to the terms of the stipulation, is this testimony true and accurate to the best of your knowledge?
Yes, ma'am.
Are there any additions or corrections to that testimony?
No, ma'am.
But for the stipulation, if I asked you those same questions today, would your answers be the same?
Yes, ma'am.
I move for admission of PNM Exhibit number 13, please.
Thank you. Again, per the stipulation, there's no objection, so PNM Exhibit number 13 is admitted into the record.
Okay, and do you mind, hearing examiner, if I take 14 and 15 together?
I do not. I do not.
Okay. Mr. Sanders, you have PNM Exhibits number 14 and 15 in front of you. 14 is the supplemental testimony in response to the October 15th, 2024 bench request filed on November 12th, 2024. And PNM Exhibit number 15 is supplemental testimony in response to the February 3rd, 2025 bench request filed on February 11th, 2025. Do you have both of those pieces of testimony in front of you?
Yes, ma'am.
Were those pieces of testimony filed by you or under your direction?
Yes, ma'am.
Subject to the terms of the stipulation, is this testimony true and accurate to the best of your knowledge?
Yes, ma'am.
Are there any additions or corrections to either of those exhibits?
No, ma'am.
But for the stipulation, if I asked you the questions today, would your answers be the same?
Yes, ma'am.
I move for admission of PNM exhibits 14 and 15.
Thank you. Again, per the stipulation, there's no objection. PNM exhibits 14 and 15 are admitted into the record.
I think that's all for Mr. Sanders in terms of admission of testimony, so I make him available for examination.
Thank you very much. Let's see. I believe that Commissioner Aguilera is not present at this time. Commissioner Nybert, do you have any questions for Mr. Sanders? Okay, hearing none. Chair O'Connell, do you have any questions for Mr. Sanders? Also hearing none. Hearing examiner Ryan.
Mr. Sanders, if you go to your stipulation testimony at page 10, you talk about stipulation paragraph 9D, like Debbie 9D. And it's the requested rate case expenses. And you note there that the stipulation agrees that rate case expenses will be recovered with a return on rate base at the embedded debt rate in the WACC. That's WACC, the weighted average cost of capital. Whereas in the application, the company initially requested for the full weighted average cost of capital. And I was trying to understand what it was the company sort of gave up in that moment when you say, obviously then you don't factor in the return on equity, but I mean, I guess what the question I would have for you is why would you factor that in the first place? And I understand if the answer is going to be something along the lines of like, well, that's actually our cost of capital, but maybe you could go beyond that and explain why under other circumstances you would get the full WACC.
Sure. I mean, so the full WACC is our cost of capital, is our carrying cost for expenses. These are expenses the company has expended that could have otherwise, been spent on other investments in order to go down this proceeding. So under that, we just request the full weighted average cost of capital to reflect the true carrying costs for the expenditures made.
But if I understand the sentence correctly, you're saying the signatories agree that rate case expenses be recovered with a return on rate base at the embedded debt rate in the WACC. So that's you're going to get less money back for the rate case expenses, correct?
Yes, it's the carrying charge applied to the regulatory asset for that. Under the full WACC, you would get the equity component as well, which, if you look at page 8 of my testimony, I show the full WACC that's included within the stipulation. And so at a full WACC, you would get a return of 6.9%. And then really there's an incremental piece for having to pay tax on the revenue of it. So really you're getting a return, the customer impact is the 8.54% on that. Whereas at the embedded cost of debt, the carrying charge associated with that is that 4.24 shown in that table above for the cost of debt. So it's an overall reduction to the revenue requirement, still recognizing that there is a carrying cost to the customer for the company for those expenditures made and recovering that, but just reducing the amount of that carrying cost to a debt rate as opposed to the equity component as well.
Okay. So moving on, page 11 of your stip direct, you talk about the stipulation paragraph 9F, like Frank. You're going to record the difference in actual ESA costs in a regulatory asset or liability. And I understand how that works. I guess my question was, I mean, shouldn't the commission want the utility to be as efficient as possible with the ESAs? And I mean, I understand that's what the liability is doing, I suppose, because if you guys get a cost overrun, well, that's not beneficial because that should be returned, not a cost overrun, but if you have more than it actually costs, you'll return that money to the ratepayers. But the reverse seems problematic because it would seem to eliminate cost containment incentives. Am I saying something that's comprehensible there?
I think I understand your question. So I guess from this, these are contractual costs, and so they will be what the commission has already approved within the resource filings for the actual cost of the contract for the energy storage agreement. What this provision does is allows for.
Hang on. Go ahead, Mr. Lee.
I lost him again. These are contractual costs, so these will be what the commission has already approved.
Yes, so they will be the actual cost for each of these contracts that were approved by the commission in their respective resource filings. So the point of the regulatory asset / liability is not really to capture differences of the cost of these, but rather the differences of timing of when these contracts start and come online. So within our test period, there are certain of the ESA contracts that I believe come online within November of 25 and February of 26. So if those were to shift out and be delayed in their implementation, we would then record a regulatory liability for what we've collected and return that to customers. If on the flip side they came on early, or the annualization of those costs going to go forward would then be recorded to the regulatory asset and be subject to the next proceeding.
I understand. That's very helpful. That was all of my questions for Mr. Sanders, hearing examiner Krankamp.
Thank you. Good afternoon, Mr. Sanders. I have just a couple of questions for you.
Sir.
I want to go back to hearing examiner Ryan was asking you about, I believe it was adjustment number 5, about the rate case expenses. And I just want to make sure that I'm reading your testimony right. You remember that line of questioning, I'm assuming?
Yes, sir.
Okay. If you go to page 6 of your stipulation testimony, I'm looking at table KTS3 there. There's a adjustment there, a downward adjustment of $107,672. That is that adjustment that we're talking about, right?
Yes, sir.
So had the rate case expenses been at the full whack, that would have cost an additional $107,672.
That is correct.
Okay. Do you know by chance how those rate case expenses have been treated in PNM's, let's just take its previous rate case, how it was handled there?
In the most recent rate case that just finalized, they were at the cost of debt.
Okay.
Let's see, I actually think I know this. In the 2016, which was stipulated, so I don't know that you can necessarily say one way or the other on that, but they were included at the illustrative at the full cost of cert or at the full whack. And in the 2015, I think it's 15-00261-UT case, which was fully litigated, they were included at the full whack, the full cost of capital in that case.
Okay. Thank you. That's helpful. Let me ask you about adjustment 9, staying on that same table. This is also, this is addressed elsewhere in your testimony. I'm not pulling it up right now, but in any event, on adjustment 9, there's a generic $12.9 million reduction in the non-fuel revenue requirement. I'm assuming that 12.9 was a product of negotiation. So I have less questions, I guess. I'm not as interested in how that number was derived as much as I'm interested in what will that actually mean to PNM in terms of, an operating basis. What can you help me understand what that type of reduction means on a practical level?
Sure. And like I think Mr. Monroy testified earlier this morning, it will create some challenges in how we manage, our costs, our business and that, but we will manage within the revenues that are authorized by the commission that are subject to this proceeding and the stipulation. And so it may result in some different prioritizations. We will look at better, more effective ways to try to manage inflation. It may also result in additional regulatory lag to the company until we can have another future rate case. But it'll be something that as the company we do have to manage to. I don't have any specifics or anything like that of how we would address it. I think prioritization of work and looking at our inflationary impacts and factors of that are key things that we will look at as we move forward on how we help to stay within the revenues that are authorized.
Okay. And that $12.9 million reduction, is that in O&M expenses?
So within the illustrative cost of service, that's where it is included.
Sorry, sir. Illustrial?
In the illustrative cost of service, it's attached as KTS1 to my testimony, to my stipulation testimony. Within that, it is included as a reduction to operating expenses. However, I think if you read all the other parties' testimony, it is intended to be representative of potential positions that other parties could have taken on specific matters while not having to hash out every single potential sticking point for one individual party, while recognizing that there are a multitude of issues that parties could take, whether that be potential rate-based capital investments or in operating expenses. But for functionality of creating an illustrative cost of service, that is where it's included. I don't know that it's fair to categorize it as that's the bottom line, what it represents.
Okay. All right. That's helpful. Yeah, the other table that I was looking at was on page 4. I just had two other questions about this. One, it looks like, so on top of that generic reduction that we were just talking about, there was another $3 million reduction in the investments in distribution, transmission, and generation. Is that correct?
So on that table, yes, that's how it shows up. I will say that as a function of how mathematical procedures work, it is actually related to the change in the return on equity and capital structure. In the initial file drivers that I had done, the change to the WACC was the first thing done. So as I go back, the change to that ROE now impacts those other investments as well, just from a pure order in which you do math changes each individual component slightly.
Okay. Well, with that in mind, let me ask you about, there's a fair amount of testimony in the record about this wildfire docket, and they're going to file a motion, or they have filed a motion. I'll get my answer to that later, but I see that at least on this table, the wildfire O&M expenses and then the insurance premiums, there's no deduction in that category. Is that correct, or am I misunderstanding the math on that one as well?
No, that is correct. I mean, as Mr. Monroy testified earlier, the wildfire is a very important prioritization for us, and we wouldn't expect, any adjustments to any of the requested funding on that line.
Okay. Okay. I don't think I have any additional questions for you. Thank you very much.
Thank you.
Anything further, Mr. Ryan, Hearing Examiner Ryan?
No, I'm good. Thank you.
Okay. Ms. Terwilliger, any redirect?
Redirect, thank you.
Okay. Unless there's anything further from the commissioners, and I don't see any questions, then Mr. Sanders, thank you very much for your testimony, sir. Appreciate it.
Thank you. Appreciate the time.
And PNM, you can call your fourth and final witness.
Yes, thank you, Hearing Examiner. We called Dr. Heidi Pitts to stand, and they're using the same witness room, so it'd just be a minute while they switch spaces.
Sounds good.
Just gonna go check and make sure the switch is happening.
Sounds good.
She's on her way.
Great.
I'm gonna turn on the video.
Okay. Looks like we have Dr. Pitts with us.
Did the witness be sworn?
Mr. Lee, if you can swear in the witness.
Dr. Pitts, if you'd please raise your right hand. You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Thank you, ma'am.
Thank you.
Good afternoon. Can you state your name and your title for the record?
My name is Heidi Pitts, and my title is Lead Pricing Analyst for PNM.
Thank you. And you have in front of you what's been marked as PNM Exhibit number 5, which is your direct testimony in support of the stipulation.
Yes.
Was that testimony prepared by you or under your direction?
Yes, it was.
Is this testimony true and accurate to the best of your knowledge?
Yes.
Any additions or corrections to that testimony?
No.
If I asked you those same questions today, would your answers be the same?
Yes.
I move for admission of PNM Exhibit number 5, please.
Thank you. Again, per the stipulation, there being no objection, PNM Exhibit 5 is admitted into the record.
I'm going to take the other 3 pieces at once, if that's okay with you, hearing
That's
examiner.
fine. Yes, that's fine.
Dr. Pitts, do you have in front of you what's been marked as PNM Exhibit number 16, which is your direct testimony filed on June 14th, 2024?
Yes.
You have in front of you what's been marked as PNM Exhibit number 17, which is your August 1st, 2024 supplemental testimony.
Yes.
And PNM Exhibit number 18, which is your supplemental testimony in response to the February 3rd bench request filed on February 11th, 2025.
Yes.
And were each of those pieces of testimony prepared by you or under your direction?
Yes.
Subject to the stipulation terms, is this testimony true and accurate to the best of your knowledge?
Yes.
I'm sorry, do you have any additions or corrections to any of those pieces of testimony?
No.
If I ask you those same questions today, would your answers be the same?
Yes.
Okay. I move for admission of exhibits number 16, 17, and 18.
Okay, thank you. Per the stipulation, there's no objection. PNM exhibits 16, 17, and 18 are admitted into the record.
Thank you. Hearing examiner, Dr. Pitts is available for examination.
Thank you. Let's see. Commissioner Nybert, do you have any questions for Dr. Pitts?
I do not.
Okay, thank you. I believe Commissioner Nybert's the only commissioner with us right now. So that brings us to you, Hearing Examiner Ryan. Do you have any questions for Dr. Pitts?
Sure. Yes, I do. Dr. Pitts, if the ESAs, you can hear me, correct?
Yes, I can.
Yeah, sometimes I can't tell. All right, no, but I just, the headphones sometimes, whatever, I hear myself occasionally, but then I go away. If the ESAs were to be collected through the fuel clause as was initially proposed, I'm asking a really basic question. The first question would be, but does the banding mechanism apply in the fuel clause context? I think the answer is no.
No, it does not.
So had the ESAs moved through the fuel clause or been recovered through the fuel clause, do we know what the impact on say the residential class would have been?
Do you mean just within base rates, like what the impact was for base rates alone, not including the ESAs and the fuel clause?
Yeah, I guess I'm just trying to understand. I mean, I understand the company changed course and decided we'll just leave them alone in base rates. And I asked Mr. Monroy earlier, like, what did that contribute to the overall revenue requirement increase? And I just want to know, like, if that was a benefit that was secured for the residential ratepayers, that this actually helps them in some ways.
So in the as filed application, the banded increase would have been about 77 million, and then the 41 million of the ESAs in Rider 23. It's about 118 overall. And in the stipulation, and so on a percentage basis, that was an increase of 32.47%, including those two components. And in the stipulated case, the increase is about 77 million. So, and that includes the fuel or the ESAs that would have been in fuel. And so the banded increase is 19.85. So it is a benefit to residential customers because it should be compared not to the banded increase in the stipulation should be compared to the total increase of the banded increase plus the ESAs in fuel in the as filed application to have an apples to apples comparison.
I think I understand what you said, but I need to think about that a little more. But that's fine. I think I follow. That was useful.
If you compare it, because I believe all of the direct filed testimonies were admitted. So PNM witness Chan in table SC3 had the total as filed increase, the banded increase plus the fuel increase for the 32.47. And so that would be compared to the stipulation exhibit 2, which is has the banded increase total and then by phase for the stipulation. So if you compare those two, you get the complete picture or the apples to apples comparison, if you will.
Good. Okay. And I'll definitely do that as we're moving forward. So since you brought up the phased increase, what is the explanation for the differentiation and the amounts of the increases? If I understand your testimony correctly, this is towards the end of your testimony. It's like a $2 and change in the first and then a $9 and change in the second phase. Is that right?
Are you talking about the as filed or the stipulation?
I think I'm looking. Let me just pull up that question.
Talking about that's the stipulation bill increase by phase. Yes. And that is, you can see that in HMP3 to my testimony in support of the stipulation. And so what that is doing is giving you the impact of the base rate change only because it's a comparison for the average residential customer at 600 kWh. And it's using all the riders at the same time as the as filed application, so that the only thing changing in that are the base rate changes from the stipulation. And so the changes in the as filed application, the phase 2 increase would have been $23.60. And in this stipulation, the phase 2 increase is $9.79. So that is just a one usage level comparison to give you a sense of the impact of the stipulation on the base rates negotiated by all the parties.
Okay, yes, and it is on page 30 of your testimony, and just so I understand, or your stipulation testimony, and that's at line 7 through 9. So paragraph 26 notes the average residential customer taking service on residential 1A consuming 600 kilowatt hours will see an average monthly impact of $279 under phase 1 rates and $979 under phase 2 rates. And I'm not sure that I followed the explanation. Can you try again? And I think it's important because we should be able to tell the ratepayers this is why it's going up and why more in the second phase, unless I just really missed your point.
No, there were a lot of bill impacts in this filing. And so in my testimony in support of the stipulation, there are 3 sets of bill impacts. So when we're looking at the bill impact of $2.79 in phase 1 and then $9.79 in phase 2, that's just comparing to what we filed in the application. So all the riders are kept at the same levels that they were in June 2024. They've not been updated to what a customer would see now on their bill in January 2025. And so that was just so that you could see, so that you would be able to compare the impact on the bill of the base rate change due to the stipulation. Okay. But if you want to see the impact of like what a customer would see today on their bill with the riders at the rates that they are currently in effect at, you would look at exhibits 1 and 2 to my testimony in support, because those are the full impacts for all the rate schedules in phase 1 and phase 2. And so when you look at that, the bill impact, so the percentage increase for phase 2 comparing the stipulation impact was 23.6% in the, let me look that up. It was $23.60. It was 26.7% bill increase. And now with the phase 2 $9.79 bill impact, it's 11.10% increase. So that's just the impact of the base rates. But if you want to look at the bill impact under current rates, the phase 2 bill impact is approximately 11.7%. And the bill increases from like $86.52 under current rates to $96.61 under the stipulation rates and at current riders. So I understand there are a lot of bill impacts, but that's what we were trying to do, was provide an apples to apples comparison against the average rate impact that we filed with the application, but then also the bill impact, what people are seeing on their bills today.
Okay.
And then the different phases.
Okay. Just a second. I need to get back to the part of the testimony that I was asking you questions about. I noticed that one of the agreement that was reached was to the allocation at the upper level, the revenue requirement increase allocation at the upper level should not exceed 20%, while the impact of the revenue requirement increase at the lower level should not exceed 7%. And when I was reading that originally, I thought to myself, well, you've set a chart. It can't be more than this for the subsidized classes. It shouldn't be more than 20%. And then it seemed to me like what I was looking for, and I didn't see it, and maybe you could just explain if this is a legitimate thought or not, that the rate increase for the classes that are already subsidizing should not fall below a certain amount, right? So if everyone's going to get a rate increase, well, then the rate increase should be at least this much for the subsidizing classes, but it's not actually. It's just like the max. You guys set a ceiling instead of a floor, if you will. And I mean, I'm wondering if that does that reflect a sort of policy choice? And I'm sort of rambling a little bit, but do you understand what I'm asking you?
May I ask what do you mean by a policy choice? Did I understand that correctly?
Yeah, well, it just seems to me like you're setting a maximum amount for the residential class at 20%. And then the thought I had was, well, okay, well then there's going to be some sort of minimum amount that the other classes will have to contribute. But it isn't. It's like we're going to only give you an increase of a maximum amount rather than a minimum increase. And I guess I'm wondering why have a maximum percentage increase for certain rate classes? Again, maybe my thought is confused, but I just thought I'd see a ceiling and a floor, and instead we have two ceilings for the two classes, or two different rate class categories.
Right. You're thinking of it like a banding range where you have the lower range, which is the floor, and then you have an upper range as the ceiling. I think the signatories wanted to see what rate increases or what revenue requirement increases might happen under the two maximum level percentages that they gave us as guidelines. And so they agreed that they didn't want to see the subsidized rate schedules have an increase of more than 20%. But at the same time, they didn't want the subsidizing rate schedules to have a rate increase of more than 7%. And so within that, then we provided ideas or suggestions, or not suggestions, but like results, I guess, is a better answer, so that they could see what the practical impact of those guidelines was, and they decided on the final amount. But the initial guideline were those two ceilings. But I don't know whether it was a policy decision, but I do think that it relates to one of the guiding principles of both PNM's as-filed application and the settlement of trying to mitigate the rate increase on the residential rate schedule. And so that was one of the considerations, I believe.
So those numbers of 20 and 7, am I to understand that those were principally, or maybe perhaps entirely, came from the interveners in this case, to the effect of like, okay, we don't want more than this? Is that how that was conveyed?
Yes.
Okay, that answers that question for me very much. Okay, so then my next question is answered by that answer as well. So the general, looking at your testimony, page 5, the general power 3B, they'll have stipulated it's the 3B general power, and then the irrigation time of use 10A and B have stipulated revenue requirement increases of 9.75 and 15.4% respectively. So if those other numbers, if the 7 and 20 were sort of generated by parties was this also the case here?
Well, these two followed the same kind of principles as in PNM's as filed application, where the rate schedules that fell in between the upper increase and the lower increase were given their cost-based increase. And so these were the two rate schedules in PNM's as filed application that also had a cost-based increase that was between those two ranges. And in the ranges provided by the signatories, these two rate schedules still fell within those two bands. And so they received their cost-based increase because, again, that's another kind of guiding principle of both PNM's application and then the stipulation too, trying to move towards parity. So for these two rate schedules, they were able to do that.
And is that also the case with the remaining rate schedules, the lower, well, maybe not because it's the lower level banding revenue requirement. So in effect, those are sort of that 6.95% increase is a function of banding and some degree of gradualism movement.
Right. The fact that the three subsidized rate schedules are at the upper level of the range is, again, it mitigates the impact of the residential rate schedule, and yet it still moves these classes closer to parity than they were in the last rate case. So movement is being made. It is, to your point, the gradualism principle has to come into play as well. And so the rate schedules that are receiving a 6.95% increase their subsidy is reducing a little less. They're subsidizing a little less than they were in the last rate schedule. The majority of the rate classes, not all, but the majority are moving closer to parity. So we're still making progress under these stipulated rate increases.
But the number itself of 6.95 is reached through the banding application, correct?
Oh, yes, sorry. It is.
No, that's okay. No, your answer was very helpful. I'm just want to make sure you see these numbers, and I just kind of wondered to myself, well, where did they come from? And I know there's answers to these questions. It's a lot of information to receive at once. So part of me is just confirming with you.
Yes, all of the rate schedules would have, with the exception of 4B, would have received a revenue requirement decrease under the cost of service, and you can see this rate design model. 4B would have received a very slight increase. And so instead, they all receive a 6.95% increase as they continue to subsidize, but at a lesser level.
Okay. When you at page 6, you talk about do the stipulation and its resulting rates align with the guiding principles? And then you say yes, and then the sentence says the allocation of costs among the customer classes for the stipulation proportionally moderates the rate impacts to certain subsidized customers. And the notion that it proportionally moderates them, I mean, it sounds like, in other words, that those words indicate that the representatives in the proceeding for the ratepayers, I presume the Department of Justice and then staff of the commission, felt that a 20% cap for an increase would in fact then be a proportional moderation of rate impacts. Would that be an accurate statement?
Well, I mean, I don't know. I wasn't in these talks, but they all agreed to it, and they all agreed that this proportionally moderated or mitigated the rate increase. And so I don't know. Again, since I wasn't there, I don't know exactly who drove what, but they all agreed that this was a mitigating impact on the residential rate schedule. And that was one of the goals. So that I think is how
And just to be clear, I'm not asking for you to divulge anything about the settling parties and their negotiations. I mean, that's not the point of the question. What I would ask would be is like, well, who decides what proportionally moderates means? And on some level, I guess you all do. But I can imagine a ratepayer saying, well, I don't want to have to pay anything more for electricity ever. And that would be their version of proportionally moderates. And
Right.
we know that that's, I mean, that's the rub, right? So that's the difficulty of all of this is there are costs. They do have to be borne. And then the question of how do we negotiate, and obviously, and you calculate and all this. That's what I'm trying to understand. And it sounds like the answer is really, that yes, because the interveners are signing on to this, that's evidence enough of itself that is a proportional moderation of costs.
Yes, I mean, but also this is my testimony, and what I was thinking about when I wrote that term is just that they are the three rate schedules that are subsidized are receiving the exact increase, 19.85, and so it's proportional for them. They're all moving towards rate parity, so that's what was going through my mind in using this term. So I can only speak for what I was thinking about with proportionally moderates.
Sure. But I guess this gets into a broader question, which is, when I see the application came in and there was a very large number, I forget the total, was it over 30% increase for the residential class under the initial application?
Yeah, about 32.5%.
And the commission received a lot of communication about that, and that's unsurprising. I think it was one of the largest increase in PNM's history. Am I wrong about that?
I don't know. We could look into that, but off the top of my head, I don't know.
Okay. I seem to recall one of the interveners perhaps making that comment someplace. It was in a newspaper article or something, which isn't part of the record, but I'm just recollecting the moments after the filing came. And, obviously we're talking about a very different set of increases as a consequence of the stipulation, but it still leaves us in this place where, there are all these low income ratepayers in the state. And I think they'll be still dissatisfied with the idea that they have to pay more because it's not necessarily electricity that is the only thing they pay for in their lives. They pay for a lot of stuff, and the cost of living only seems to be going up. So I guess my broad question to you, Ms. Pitts, or Dr. Pitts, is when do we expect to see costs going down if the other investments are going to ostensibly provide that? And I'm talking about grid mod and the things that Mr. Monroy explained to me in his testimony about here's where we see customers achieving costs. And I guess more generally, just for purposes of this rate case, to tell customers, here's why you shouldn't think that this is going to be $10 increases every so many years out into infinity.
You're asking me when costs are going to go down in the future?
Well, I know, and I don't know. Maybe you can't tell me. Maybe that's the answer. I don't know. I guess I'm just wondering, like, what is the strategy for cost containment for the residential class in the long run?
I mean, I don't know exactly, because one of the goals, of course, is to move all rate schedules to their cost of service. And the residential class for a while has been subsidized by other customers. So some of the increase, not the increase in quantitative dollars, but as we try to move towards parity, we're making up the subsidy as well. So for instance, the comparison in this case would be that the residential rate schedule is getting a 19.85% increase. The commercial and industrial classes are getting a 6.95% increase. So maybe things change or balance out once we get to a balanced cost-based rate system where the rates truly reflect the cost to serve and there aren't subsidies built in. Maybe that's the answer. I don't know exactly. I don't know that costs ever go down, really, because the underlying costs that PNM incurs go up as well. And so the company doesn't have control over that, over construction costs or, I don't know, other things that go into serving customers. So it's hard to say. And then, but I do think moving to cost-based rates will change the impact because people, if we get to cost-based rates and then at a certain point with the deployment of AMI, as we have time of day rates open to all customers, then there are different ways that they can control their bill. Right now, the vast majority of residential customers, over 99%, are on residential 1A, which the rate structure is a conservation-minded rate structure where the inclining block rate structure means that the more you use, the more you pay because the block 2 energy rate is higher than the block 1, block 3 is higher than block 2, and you incur those blocks as you use more and more energy. So, and we live in an age where, electrification means that a lot more things are using electricity. It's hard to use less. And so the tools we need to give customers to mitigate rate increases or to give them more control are things like the time of day rates, which at some point will be open to everyone when AMI is fully deployed. And so then they can take advantage of on-peak and off-peak rates, or if the residential rate schedule then has a super off-peak rate, the way the commercial classes do under the pilot, that also would, it's just a different structure even than the residential time of day pilot has right now. So I think that there are other rate design options in the future that will give more control to customers. And so that's the way to help residential customers going forward, rather than the inclining block structure that was largely set up to encourage customers to use less, because that's the only way to save money. And so that, I think, is the future of like rate design for PNM and probably all the utilities.
And then to the extent to which, sort of California is the harbinger of things to come, I believe, if I understand correctly, they have income variable rates there. Is that something that the company sees in the long run as the company would embrace, or no?
When you say the income variable rate in California, you mean the low income rate?
Yeah, well, in effect, California has a very disparate sort of set of incomes between its citizens, and so some are very affluent and others are not, very much not. And so my understanding, just general perusal of newspapers, that effectively there's been experiments with figuring out different rate structures for different income levels. That in other words, kind of like progressive taxation. Is that, and maybe I'm wrong, but if that's something that is out there, is it something that PNM's thought about?
A rate schedule or a rate design like what you just described, we haven't progressive taxation or progressive rate design. I'd have to do some research and see exactly what that entails, but we're open to what we consider modern rate design, of which the time of day pilot is the first step, just recognizing that not only are customers' energy consumption patterns changing, but our rate design needs to change as well. And so if that's something that would be useful to PNM's customers, then we would certainly consider it. And if it's something that we can do under like an AMI or with our billing system, I mean, we have some constraints here with our billing system, what it is able to do, but yes, we're looking.
Well, I mean, and I'm not suggesting anything, but to be very clear, I really am just saying, was Ms. Chan in our last hearing, made the case to say that this subsidy of the residential class in New Mexico has existed for a very long time. Do you know how long that's existed?
At least since the 2015 rate case, but I'd have to go back and see if in the 2010 or previous, there was a 2008 rate case, 2010, to see when exactly it began, but I'm aware of it since 2015.
At least since 2015. And I understood Ms. Chan to sort of say in that case, well, look, it's a real problem and it's not entirely clear to the company. This is what I recall from Ms. Chan's testimony in that case, how exactly you deal with that, because it's not as if you can magically put money into people's pockets. And, when you have a increasing cost across the board for people, the newspapers will all write, oh, even though the stipulation came and you all showed up here and said, this is what we should do. There will be many ratepayers out there who are upset about having to pay more. And I guess part of our job here is to verify that, in fact, the increase in cost is all valid. But I guess I'm just wondering, what's the long-term strategy for solving that? And from what I understand from the company so far is that grid mod and time varying rates are the thing that you all are kind of moving towards as the solution to the low income ratepayer problem.
Well, that's our first step for sure, because we have the time of day pilot going right now, and grid mod was just approved. So we move forward in that. And so those are things that have been approved that we have concrete steps towards in the near future. But there are other rate designs that are possible, farther on. Whether it's, if rates varied by the hour according to what, to reflect the true cost, that's true time varying rates, right? But our billing system cannot handle rates that vary by the hour. But there are various ways that we can move forward once we have fully implemented time of day. Then we learn from that and think about what the next steps are. Or to your point about alternate rate schedules, I do think that California has a low income rate. I don't think any utility in New Mexico can do that without legislative changes at the moment, but that's certainly, if that ever came about at the legislature, that would be something that would be interesting as well to implement for our customers.
Well, right. And I don't think, I agree with you entirely. And the point is, only so much can be done in rates. And we know Mountain States exists and says you can't discriminate between rate classes. And that's its own set of things. And, Mr. Monroy articulated how gradualism and rate shock aren't necessarily concepts that then, my question was, well, how are we ever not discriminating? Like, where is the non-discrimination perspective? Like, the word discrimination is terrible because it's not describing it, like the circumstance, right? It's like, how do we ever get to pure cost? Because so much of this is subjective, and how we allocate matters, where it comes from, like through which mechanism, through rates, riders. There's so many choices in there. It seems almost baffling to me to say we'll ever get to like, this is pure cost for these particular classes, but maybe I'm wrong about that. Am I wrong?
I don't know. I think that there are policy decisions in rates as well. And so to get to true cost-based rates across the board for all rate schedules would eliminate the possibility of having any kind of policy choices in rate design, because it would strictly be cost-based. So that's a decision for you all in the commission, ultimately where you want to go. But I think that's the trade-off, right?
But you're suggesting that there is such a place as pure cost-based, where we've made no subjective policy judgments whatsoever, and we can in fact just calculate that place does exist.
Well, sure. I mean, it exists, but would we ever get there? And there's also a difference between having a cost-based revenue requirement increase for the rate schedule as a whole, and then if you have the different components that make up the tariff be cost-based as well. So, I mean, there's policy decisions at every level because it's what do we want to incentivize as a state or as a utility, and so as a commission, and so
Right.
decisions have to be made.
And then what hearing examiner Kleincamp and I were talking just this morning before our hearing, and he made a good point, which was, when you think about the choice to be made between how much gets loaded into the customer charge versus how much goes through volumetric charges, the fact that there is no demand charge within the residential classes generally, but now we know through the time of day pilot that actually that might be in the EPE's case, and I think that is the case. The EPE is looking at doing time of day rates with a demand charge function in their pilot. And like that's, what you're capturing there are like those were all policy choices, is my point. And so I don't see how you ever make set rates with just like, oh, we've just done math. This is just math. I don't know that place exists. I don't buy it, but maybe you could. That's my position.
I think if you got to where it was just math, then the policy choices go away.
Okay. From a rate design perspective, Ms. Pitts, is there any, Dr. Pitts, is there any legitimacy to the notion that, if you have a residential subsidization within the actual rates, that, it's much easier for industrial or business customers to pass costs along to their downstream customers than it is to say to the residential ratepayers earn more money? Is there any legitimacy to that?
Wait, so may I restate the question to make sure I understand it?
Absolutely.
So you're saying that it's easier or is it true that it's easier for the commercial and industrial classes who are subsidizing classes and they're getting a rate increase, they can just pass that along in the cost of their products that they sell, whereas residential customers cannot just go out and make more money or have a higher salary just so that they can pay electricity.
Right. I mean, it gets to the question I'm asking you is I understand the movement towards unity. I understand what that's all about. And I'm wondering that the question I'm underlying is like, is the subsidy as problematic as people make it out to be?
Well, I mean, residential customers buy the products that all these businesses make. So they'll pay for it one way or the other.
Or the other.
Either their electric rates kind of reflect costs, and so they can make choices that way, or they will see the cost passed on in the products they buy or the services they get from the government.
Yeah. In other words, the balloon animal has so much air on it in it wherever you squeeze, that doesn't change anything.
Yes.
I'm just going through your testimony and reviewing my questions. That was all I had for Dr. Pitts, hearing examiner Kleincamp. Thank you, Dr. Pitts.
Thank you, sir.
Thank you. Dr. Pitts, your testimony has been fascinating. I don't have very many. In fact, I only have one question remaining for you. I just want to make sure that I'm correct about the banding ranges here, so that I'm correctly reviewing the stipulation. My understanding is that the banding range used in the stipulation is 51% on the low end to 145% on the high end. Is that correct?
Well, that was me trying to generate kind of to refer back to hearing examiner Ryan's question about the two maximums, was trying to create kind of the upper and lower band that to be able to compare to what we were doing in the as filed case. And so the signatories didn't give us the upper and lower band. They gave us the two maximums, the 20,
Right.
not to exceed 20%, not to exceed 7%. And then we finalized and the signatories agreed on the 19.85% and the 6.95%. And then I was just calculating what that would look like is an upper and lower bound so that it was kind of comparable to the as filed
Okay.
which did not have two maximums. It had an upper and lower banding range. So
Right. So in other words, you were working backwards off of those other numbers that the parties had agreed to through the stipulation.
yes, exactly.
Okay. But just in terms of comparing this to the original application, then I want to step back and compare it to the banding range used in the 270 case from 2022. So in the application that PNM filed in this case, the banding range that you had proposed originally was 0% to 175%.
Yes.
Is that correct? Okay. And then in 270, the banding range that was approved as part of the recommended decision, then I guess the final decision in order was 25% on the low end and then 175% on the high end.
Yes.
Okay. Okay. That's all the questions I had. Thank you very much for your testimony. It was very interesting.
Thank you, Mr. Hearing Examiner.
Appreciate it. Mr. Williger, any questions on redirect?
No, thank you.
Okay. Unless there's any remaining questions from Hearing Examiner Ryan or any of the parties?
Nope.
Seeing none, then Dr. Pitts, thank you very much for your testimony. We appreciate it.
Thank you very much.
And I believe that concludes all of PNM's witnesses, Ms. Terwilliger. Am I correct about that?
Yes, that concludes our case.
Okay, thank you very much. All right. So we had previously excused Mr. Sandberg. So the next on the list is Ms. Weller from WRA. I believe she was trying to join.
I think I let her in.
Okay. Is she are you available, Ms. Weller? I think
Good
there was.
afternoon, hearing examiners. Yes, I am.
Okay. All right. Good enough. Ms. Beatles, go ahead and call your first witness.
Thank you. Western Resource Advocates calls Anna Linden Weller.
Thank you. And Mr. Lee, if you could please swear in the witness.
Mr. Weller, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter now pending will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
For the record, Dr. Weller, please state your name and your employer.
My name is Anna Linden Weller, and my employer is Western Resource Advocates.
And what is your position with Western Resource Advocates?
I am the Senior Policy Advisor for Clean Energy on the New Mexico team at Western Resource Advocates.
Do you have before you WRA Exhibit 1, which is your direct testimony in support of the stipulation filed in this docket on January 10th, 2025?
Yes, I do.
Do you have any changes or corrections to that testimony?
No, I do not.
If you were to answer today the same questions contained in that testimony, would your answers be the same?
Yes, they would.
And are they true and correct to the best of your knowledge and belief?
They are.
I move the admission of WRA Exhibit 1.
Thank you, Ms. Beatles. Per the stipulation, there's no objection, so WRA Exhibit 1 is admitted into the record.
Thank you. I now pass the witness for your questions.
Thank you. Let's see. Commissioner Nybert, do you have any questions for Ms. Weller?
I do not.
Okay, thank you. Hearing Examiner Ryan.
Ms. Weller, we were trying to assess earlier with Mr. Monroy what the 1.5 million Good Neighbor Fund contribution, like how should the commission think about that? And, you see the number originally and you say, oh, it's any individual would sort of think of that as a lot of money. But, I mean, if we just compare it to the, turn of the ROE here that the company's requested, they'll get 20 million there on the revenue requirement. So that's 1/20th, or a little more than that, obviously. So I guess the question for you, Ms. Weller, is why is that a good thing? What should the commission make of it, and is it significant?
I do think it is significant. It's not an enormous number, but it's not a small number either. 1.5 million. And going back to Mr. Monroe's testimony earlier this morning, at a rate of $175 per customer, that serves more than 10,000 customers in a year and might allow for the company to have a more consistent ability to help some of their customers. Personally, I think that the presence of the commitment in the stipulation shows a certain amount of willingness on the company's part to recognize that there is a real rate impact on their low-income customers.
Is the number, I mean, I'm operating off a basic assumption, and I think this came from the last rate case. I don't know where I'm getting it, but it's roughly half of PNM's customers are what we would call low income. Do you have any further details about that?
It depends on how you define low income, of course, but I think, yes, if we're looking at like below 150% of the federal poverty level, that would be right. And it, depending on how you're defining low income, that can change.
Okay, I think some of the and I can't remember which statutes, this might have been either TEP or grid mod or something, was using 200% of the federal poverty level.
Mhm.
And I believe that was the number. Do you have any idea what the number is, if that's the basis?
It would be around half. I don't have a precise figure. I could get that for you if you'd like.
Yeah, let's do that, just so that we have updated numbers. So if you wouldn't mind, just Miss Beatles supplying that as a response to a bench request. Call that bench request 1.
We can do that.
And then in your testimony, Ms. Weller, you said all of the provisions, including the contribution to the Good Neighbor Fund, will support the reduction of greenhouse gas emissions and respond to the effects of climate change. I just was curious what that Good Neighbor Fund contribution, how does that achieve that outcome?
Well, there are several steps that sort of get me there. And I look at the reduction of greenhouse gases as a holistic objective across, that can be achieved across PNM's operations. So one of the ways that greenhouse gases can be reduced is by electrification of home heating and cooling. And electrification, of course, you pay for electricity. A low-income customer, as we've previously discussed in Dr. Pitts' testimony, electrification does increase the amount of electricity people use, costs more. Having the ability to help more low-income customers not get into arrears on their accounts does make electrification more possible for those customers, which over time and overall reduces greenhouse gas emissions.
Okay. Dr. Blank wrote in his testimony that from his perspective, more resources were expended on the settlement than would have been necessary to litigate the case fully. That's just what he wrote in his testimony, his stipulation testimony. And you pointed out that there's substantial efficiencies and conservation of resources arising from the stipulation. Those seem to be inconsistent positions. So can you tell me, I guess from a WRA's perspective as their witness, you're of the perspective that money was saved here in the course of creating this stipulation?
I believe for WRA, money was saved. We had a contract expert who would have provided testimony in a fully litigated case in addition to my testimony. And in the course of the negotiations, the issues on which that expert would have testified were resolved in a way that we found satisfactory.
Okay, those are all my questions. Thank you, Ms. Weller.
Thank
Dr. Weller,
you.
excuse me.
Thank you. Dr. Weller, I just have a couple of questions for you. Most of my questions relate to, I guess this is pages 7 through 10 of your stipulation testimony about wildfire mitigation.
Mm-hmm.
You talk a little bit about the commitment in paragraph 21 of the stipulation for PNM to file a motion in this other case, 22-00154-UT, to request that fire mitigation workshops be held before the commission. You said that was going to be filed, or you hoped to work with PNM to file this motion in January 2025. I guess preliminarily, was that motion filed in January?
Yes, it was. It was filed on January 17th.
Okay, great. Thank you. And can you talk a little bit about why that particular commitment from PNM was important to WRA? The way that I was looking at it, it seemed like WRA and CCAE and other signatories could already file a motion like that. And so I'm just curious, I guess, from your perspective, why having PNM's, having PNM join you in that is important as part of this stipulation.
So yes, I agree entirely. WRA or anybody else could have filed that motion at any time, but it is a much more effective process if a utility is fully committed to exploring best practices for wildfire mitigation and wildfire risk management and participates from the beginning, including in the design of the workshops or any possible rulemaking or other procedure that might emerge from those workshops. Having PNM be committed from the beginning to a serious, in-depth process with the interveners, I think is a vast benefit. It will mean that we get right down to the real issues much faster.
Okay, that's helpful. The other component, I guess, of the original application that was filed and PNM testified earlier today, several of their witnesses testified, I guess, had survived through the stipulation was the additional costs that PNM is going to have to shoulder for insurance premiums from wildfire and then additional wildfire sort of O&M, preventative measures. Was that also an important provision that sort of continued through the stipulation for WRA? And do you see that as important as this workshop?
I see wildfire mitigation in general as absolutely vital to the ability of the company to continue to provide electric service in general. And the costs of acquiring wildfire insurance that PNM is incurring are not unusual or exceptional to PNM. It is across the West, in fact, across the entire US, that utilities are seeing much higher premium costs. And that's actually one of the issues that I hope will be explored at the workshops is the best ways of acquiring adequate and prudent amounts of disaster insurance for both wildfires and other disasters. But yes, I do think that the costs in the initial application that remain in the stipulation represent PNM's concerted effort to try to prevent wildfires where they can.
Okay, thank you. I think those are the only questions that I had for you, Ms. Willer, or Dr. Willer. Thank you very much.
And then Ms. Beatles, with the question about the low-income customers, I mean, I could understand if that's a better question to ask PNM. I mean, just thinking about it, but I just think it's important. So much has been discussed in these stipulation, and all of the parties are saying, well, this is a good outcome for the residential, and your witness said that. So I guess if will it be a problem for you to submit that information? We can ask PNM, I suppose, Ms. Beatles, if we need to.
That is information that we track and can supply.
Okay.
And I think we can look at it, both relative to 150% of the federal poverty line and 200%. And we can go back to past PNM cases, but we also have independent sources.
Great. All right. Just wanted to make sure that wasn't going to cause you any headaches. So thank you.
Did I speak ahead of us, Dr. Weller?
No, I think that we can certainly come up with that. It may be 1 or 2 years out of date due to census records, but that is probably true of nearly everybody's data.
So if you want something like more like recent and that and truly captures PNM's understanding of its customer base, I recognize that PNM may be a better source. I mean, it looks like Mr. Verheul just came onto the picture.
Yeah, Mr. Verheul.
I did, and thank you, Ms. Beatles. Yeah, PNM would be happy to supply what it is that you're requesting, or in the alternative, if you would also like WRA to be involved, we'd be happy to work with them to provide them with data.
Great. So just to keep it simple, Ms. Beatles, since the record reflects it was a bench request for your witness, if you could just consult with PNM when you're creating your answers, and we'll assume that whatever you'll file, PNM wouldn't object to, as a matter of fact, because you'll have consulted one another and supplied accurate information. Is that satisfactory to everybody?
Yes, thank you. We can do that.
Terrific. Thank you.
Let's see, hearing examiner Ryan, did you have anything further for Dr. Weller?
No, thank you very much, Dr. Weller.
Ms. Beatles, any questions on redirect?
No, thank you, and nothing further from Western Resource Advocates at this time.
Okay, thank you very much. Dr. Weller, we appreciate your testimony. Thank you for being with us today.
Thank you.
Thank you. All right. I believe, according to the schedule that the parties provided us, next up would be the City of Albuquerque, Mr. Rowland, and your witness would be Dr. Blank.
Yes, Dr. Blank was traveling this afternoon. He had a flight delay. He said that he believes he will be available after about 3 p.m. The schedule that was provided kind of had built in that he'd be available this morning, but possibly not this afternoon. But the last I spoke to him, he thinks after 3 p.m. Today he'd be available.
Okay. I do show that looks like our next scheduled witness would be Maureen Reno testifying on behalf of, I think, both Bernalillo County and ABC WUA. Ms. Joe, is your witness available to testify now if we called her out of order? Ms. Joe, can you hear us?
Miss Joe, you're on mute.
Yeah, are you having trouble unmuting? As it happens, hearing examiner Ryan, am I correct in thinking that it's probably time to take our next recess?
Yeah, let's do that. And then we give Miss Joe some little bit of time to figure out her equipment.
Okay. All right, we'll take a 10-minute recess, come back at about 10 till 2.
Great.
We'll off the record. Thank you.
Testing. Can anyone hear me?
I can hear you, Valerie. This is Keith.
let's see, it's 10 till. Mr. Lee, how are you doing?
Good.
Okay. Well, I think we're ready to go back on the record, sir, if you are.
Go ahead.
Okay. We are back on the record. Time is now 1:50 p.m. I think where we left off, we were going to call Maureen Reno, who is the witness of both Bernalillo County and the ABC WUA. Ms. Joe, will you be presenting this witness on behalf of Bernalillo County, or will it be Mr. Herman, who I guess it doesn't matter to us?
It will be me, and we'll just note for the record that it is co-sponsored by the Albuquerque-Bernalillo County Water Utility Authority.
Perfect. Thank you very much. All right. Let's see. Ms. Lee, or Ms. Lee, Mr. Lee, can you swear in the witness, please?
Ms. Reno, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending will be the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
Please proceed, Ms. Joe.
Thank you. And Ms. Reno, what is your name and your job title?
My name is Maureen Lynn Reno, and I'm an economist serving on behalf of Bernalillo County and the Water Authority.
And do you have in front of you what's been labeled BurnCo-ABCWUA Exhibit number 1?
Yes.
And is that your direct testimony in support of the uncontested comprehensive stipulation?
Yes.
Okay. And was BurnCo-ABCWUA Exhibit number 1 prepared or supervised by you?
Yes.
And is this testimony true and accurate to your knowledge?
Yes.
And at this time, do you have any additions or changes to your testimony?
No, I do not.
And if I asked you those same questions today, would the answers be the same?
Yes, they would be.
Okay, at this time, the county is ready for Maureen to make Maureen Reno available for examination. Thank you.
Okay, thank you. And I assume that you are also offering Bernalillo County / ABCWUA Exhibit 1 into evidence.
Yes, that's correct. Thank you.
Okay, perfect. Well, in that case, since I mean, given the stipulation, this is unopposed. This exhibit number 1 on behalf of both Bernalillo County and the Albuquerque-Bernalillo County Water Utility Authority will be admitted into evidence. And that brings us to, see who we have on with us. Commissioner Nybert, do you have any questions for Ms. Reno?
I do not.
Okay, thank you. Hearing examiner Ryan.
Yeah, Ms. Reno, the question I asked Mr. McKenzie, and I understand the answer, and I guess it just I find it's not unsatisfying because he's providing us. It's just unsatisfying in the general sense, is that the company comes in and they tell us their costs for equity is such a number, and then afterwards you wait to see, well, what impact does that have if we don't give it to them? And you heard Commissioner O'Connell having a dialogue with Mr. McKenzie about no, it's actually Mr. Monroy, excuse me, about whether or maybe it was Mr. McKenzie. It was that's an adequate return for investors' purposes in the places where investors get together. And the commissioners go to such places and they talk with these folks. And so one of the questions is, are we adequately ensuring the utility has access to equity capital? And the last rate case in 22-270, they came in and asked for a much higher number than they were rewarded. But I never saw the downstream consequences of that. And Mr. McKenzie, as he was testifying, was indicating that was unsatisfactory, the result in the last rate case on some level. And I mean, I guess my question to you, Ms. Reno, is like, how can I determine the veracity of the claim that a particular award of equity capital cost is meaningful or not? Like, is there any sort of downstream evidence? I mean, Mr. McKenzie identified a few things, rating agencies, S&P, but is there any other hard information that we can look at to try to assess that question?
Well, there are a couple things that come to mind in that rating agencies kind of look at the whole picture, right? And so in the context of the settlement, you know, the investment community will see what is being issued by the commission. And in this case, it's based on the settlement of 9.45. Investors will also look at other things pertaining to the company and what the commission has done to mitigate risk. And so as part of other parts of this filing, like for example, the future test year is another thing that investors look favorably on, the rate mechanisms in place, the other agreements addressed in the settlement as well. So investors tend to look at all of these in the context when assessing the risk of the utility. Mr. McKenzie was correct in that, we're looking at a proxy group because it's really hard to look at and estimate it such as we would with embedded cost of debt. So there is this mechanic approach where we're looking at specific models, and we're looking at what's happening in markets. And in this case, this commission in particular tends to favor the discounted cash flow model. I also incorporated another model as well, the capital asset pricing model. And so from these models, I was basically inputting what was happening in financial markets at the time of negotiations and the settlement. And so my results were very closely in line where we ended up in settlement. So I'm really confident. My average based on the DCF, and you'll see it in my testimony, the midpoint of my range was 9.33%. And then incorporating my other models was 9.46%. And so investors are aware of what's happening in the markets. They'll see that my results and then ultimately the settlement, which is very close, not very far at all. So I'm confident that the settlement based ROE is in the public interest and is fair and reasonable.
Okay, and I guess again, I mean, part of me, you sit here as the hearing examiner, and you're asked to, offer judgment on a subject, and in the last, and I guess this is, I'm sort of re-saying the question, but I'll put it maybe in different words. But the argument is, well, you need to set it at this level, or there's going to be meaningful downstream problems. And then you sort of wait to see, okay, well, we didn't do that, and now where are the problems? And so, what I heard Mr. McKenzie say today is, well, one of the things that the cost of equity obviously is built in is dividend payments back to ratepayers, and then the stock performance. And so, is it fair to, like, once we set a rate at an ROE for a utility like PNM, we could say, well, let's see how the impact was on those things. Do they? I mean, that just might be overly simplistic, but I mean, I don't think it's unreasonable to expect that if someone says, if you do this, this will be problematic, and then you don't see problems, to just sort of wonder, like, or just be confused. Like, I don't understand why you said that was going to be a problem when I can see no evidence of problems. Do you understand that it's a problem we find ourselves in as an agency?
Yes, I understand your predicament, and you have to take into account all the evidence presented to you, right? And so, what I'm responding to is, in this particular case, right? I didn't have the opportunity to put forth evidence before the settlement discussions, and so what I would have done is provided written evidence provided by Standard & Poor's, for example, which tends to write to the investment community. And they tend to have, they would present all the evidence. Mr. McKenzie was correct in that the investment community does favor settlement outcomes. But in addition to that, they tend to look at the whole settlement. So then they're not just going to pinpoint on the ROE, they're going to look at other elements as well and try to gauge the overall risk. And what I've seen in past S&P reports, that, for example, in the last rate case, I had attached a settlement report or references to a settlement report in my testimony. I didn't necessarily have that opportunity here. What I presented was my support and evidence for the settlement. And so I'm confident that the investment community will see the settlement as favorable outcome. It's in line with what the commission has issued recently in the past for a lot of ROEs. If you refer to my testimony on page 10, table 2, I present recent allowed ROEs issued by this very commission. And where we landed was pretty close to another case that was issued. The order was issued in October of 2023, and that ROE was for 9.5%. So I'm fairly confident that the investment community will see where we've landed as fair and reasonable, given the historical precedent of this commission, and in light of what else the commission has allowed in terms of the company's requests for, say, a future test year, various rate mechanisms, and other movement on some of the other key issues that some of the other witnesses have discussed today.
Okay, thank you for the dialogue. Appreciate it. Go ahead.
And I also wanted to add as well, the investment community would also look at the nature of the utility business in relation to just the fact that where the industry is heading, for example, and in terms of moving away from fossil fuels and what PNM has done to progressively address and the desires of the state legislature and their and other trends within the industry as well, in terms of anticipated increases in demand due to increased data centers, for example. And so investors tend to incorporate all these things in their analyses.
Okay, thank you very much. That's all the questions from me, hearing examiner Krankamp.
Thank you. Good afternoon, Ms. Reno. I want to follow up with you on, I guess, sort of the last sort of line of questioning from hearing examiner Ryan. You had testified at one point that you agreed with Mr. McKenzie from one of PNM's witnesses that the investment community does favor settlement outcomes. Can you elaborate a little bit on that and in particular why that is or why that would be?
It's viewed as in general as more like a constructive environment. And it was, I wasn't agreeing to necessarily his figures that he had estimated.
Right.
I was more or less agreeing to that particular statement, that there tends to be this endorsement for cases that end amicably as opposed to being litigated. And that was simply it. I've seen like S&P, for example, and Moody's, they're both credit rating agencies. They issue out publications to the investment community. And I keep in mind some particular statements from past reports on PNM and where there has been movement in settlement. They tend to view that as constructive and very positive.
Okay. Yeah, and I'm well aware that I think your models come out to different results, I think, than Mr. McKenzie's. I'm just very curious about the concept that I guess in particular the ratings agencies would respond particularly positively to stipulations and settlement agreements. That's sort of a new concept for me, but I appreciate your. But please go ahead if you want to elaborate on that.
Sorry, I didn't mean to cut you off.
No, by all means.
So again, as I was saying before, when I was answering hearing examiner Ryan's question, it tends to be included within a number of factors. So it's not a settlement itself wouldn't lead to, say, a favorable rating, for example. It would be taken in within the context of, well, what was that settlement about? What issues were resolved? How did so that was the thought I wanted to add.
Okay, well, I appreciate that. That is helpful. And I guess while we're on sort of a similar subject, I just want to make sure that I am correctly understanding your testimony. So I have gone through it. I think that what I'm understanding you to say in your testimony with respect to the ROE is that although the ROE in the stipulation at 9.45 is slightly higher than the midpoint, as far as what your modeling would suggest, you still support it as part of the stipulation. And in the context of the stipulation, it's in the public interest. Is that a fair way to characterize your testimony?
Yes.
Okay, great. Let me ask you a little bit. We've heard throughout the day today, and then also really throughout all of the testimony in this case, the word gradualism comes up a lot in terms of shifting towards more cost causation. And you may not know the answer to this, but one of the questions that hearing examiner Ryan asked, I believe Dr. Pitts earlier, is something I'm very interested in, and that is, are you aware of sort of the history behind these class subsidies and how long that practice went on? We talk a lot about shifting towards more cost causation, but what I'm interested in is just how long those class subsidies have existed. Do you have any more background information on that you can offer other than what we've already heard?
I can recall looking into some of the case history, but I don't think I dove much beyond like the past decade. And so it seems to me that, the last 3 or 4 cases, there has been this banding that has been implemented by the commission, and with the concern that residential ratepayers are probably one of the classes that are highly subsidized. But with, with a state that has such a large portion of residential ratepayers below the poverty line, that's a real concern for my client. So I've looked into this a little bit, but I haven't gone back. And when Dr. Pitts was discussing this and answering this very question earlier, I don't think when I went, into like the 2008, I didn't look into the 2008 case, the 2010 case. Just, so I would briefly just say I wasn't really finding any positions that were different than what has been in place. So I guess I haven't gone as far back as you would have liked.
No, that's
does
fine. Go ahead. Were you going to say anything else there?
I have been noticing lately, though, there's more discussion in the odors of the commission expressing this desire to move back to cost causation. That's all I was going to say.
Okay. Well, that's very helpful. I think that's all the questions I have for you, but thank you very much for your testimony. I appreciate it.
Thank you. I appreciate the opportunity.
Hearing Examiner Ryan, anything further from you?
No, thank you.
Okay, thank you. Let's see, Ms. Joe, any questions on redirect?
No questions at this time.
Okay, thank you. Any questions from any of the other parties?
Or Mr. Herman for redirect I as well, since she's a joint witness.
Any questions, Mr. Herman?
Thank you for the opportunity, but no, I'll defer to Bernalillo County here and let them take the lead.
Okay, thank you. All right, well, I don't see any other remaining questions. So Ms. Reno, thank you very much for your testimony today, and you can be excused.
Thank you.
Thank you. All right, let's see. Mr. Rowland, I'm assuming that Dr. Blank is probably still delayed at this point?
Yeah, I actually was texting with him a minute ago. He just landed. He said he should be fully set up to go right around 3 o'clock.
Okay.
So he'll let me know if it's early, but right now he's gonna need a little bit more time.
Okay, no problem. Thank you.
Thank you.
Let's see, that brings us to Justin Barnes and CCSA. Do we have Ms. Zuer with us? I do not see her. Okay. Let's take a pass on that for right now. Next up would be Assistant Attorney General Gideon Elliott or Assistant Attorney General Barrett. Are your witnesses, or I guess Ms. Crane in particular, is she available?
Not at this time. I believe we had her on for tomorrow, if I'm not mistaken. And Mr. Gigax will not be available until Thursday.
Until Thursday?
Yeah.
Okay. All right.
Unless Miss Barrett, am I correct about that?
As far as Miss Crane's concerned, yes. I think there's a chance Mr. Gigax could be available tomorrow, but not today. He was a little more flexible, but not today.
Yeah.
Okay.
Yeah. I will speak with him, but last I communicated with him this morning, the more time he has, the better. And I think we had him going right before staff.
Yeah.
Yes. All right. Well, if he can be available tomorrow, that would be very helpful because I'm not sure that this is going to run through Thursday. So.
Okay. Okay.
Okay. Next on my list, let's see. Mr. Gould, do you know if Mr. Andrews is available?
Mr. Hearing Examiner, he is not, and I do apologize, on the party's memo. We didn't list today as a day he was not available, but then he did call us over the weekend and say that his office is closed because of the presidential holiday. So, but he will be available tomorrow night, and we can present him whenever you need to fill in the schedule. But I do apologize for the inaccuracy of the memo.
All right, no, that's fine. No, don't worry about it. And in part, you know, when Hearing Examiner Krankamp and I got the memo, that was not going to be possible for us to sort of coordinate all those varying things. That was too much information, people.
Exactly. Thank you.
So we're just going through the roster here, but I just want to make sure we understand. Tomorrow will be Crane. Tomorrow will be Gigax. Tomorrow will be Andrews. Do we need to be more specific as to what time between in the morning hours or the afternoon hours?
Mr. Hearing Examiner, I'm just to reiterate, I don't know that Mr. Gigax is going to be ready to go tomorrow.
Okay.
Mr. Andrews will be available all day long, so I will send him a text and an email and tell him to be ready at his time, 10 Central.
Okay. So that would we want to take Crane first, Hearing Examiner Krankamp at 9, and then go to Andrews right after her? Because you could kind of like just say tomorrow we'll just take them in the order that they would have come today. You know what I'm saying?
Yes, yes. I believe if we do it that way and we were able to get Dr. Blank in today, then first on the list tomorrow, if he's not available today, would actually be Justin Barnes from CCSA.
Okay.
On my list.
Ms. Jur is not still present, right?
No. And before we get there, staff, if one of your witnesses could be available, that's going to be helpful because
yes,
that's where we're at.
Darren should be logging in shortly, and the next one after that will be ready also.
Perfect. Thank you. That's very helpful. Yes, so I think if we push most of the interveners to tomorrow, that should work better.
And Mr. Gigax he's saying he can do tomorrow.
Great. Thank you. Well, next up on my list here, so I show that Mr. Bieber from Kroger is unavailable today. Dr. McGovern from Walmart is unavailable today. And that does bring us to staff's first witness, who thankfully is available today.
Mr. Boehm, will Mr. Bieber be available tomorrow morning?
Yes, Your Honor.
Who was the other person, John? Or excuse me, Hearing Examiner Krankamp? You said Kroger, and then who was the other person who was supposed to go but wasn't?
Walmart's witness, Dr. McGovern.
This is Julie Clark from Walmart. She will be available tomorrow, except for she's got a window where she's not available from 11:30 a.m. until 1:30 p.m.
Well, that'll work. We can just do it, I think, in the morning. You know, you can see these things are going rapidly. Most of our questions for the utility the utility witnesses were more significant than they are for the interveners. So I think that shouldn't be a problem.
And I'm receiving an email. I just received an email now from Ms. Zuer. Sounds like Mr. Barnes will be available tomorrow all day until 3 o'clock.
All right.
So tomorrow that'll work for Mr. Barnes. All right. So that brings us to staff and Mr. Rossi. Are you prepared to call your first witness, sir?
Yes, Mr. Hearing Examiner. Just prior to calling the next witness, it looks like we'll probably get through a bunch of our witnesses today, is my guess. So I'm asking that Dr. Zadalis be one of the very first ones tomorrow morning when we get there. So with that, the staff would call Darren Zigich.
Mr. Lee, if you could please swear in the witness.
Mr. Dickens, would you please raise your right hand? You solemnly swear the testimony you're about to give, no matter not penning, should be the truth, the whole truth, nothing but the truth.
Yes, I do.
Thank you, sir.
Go ahead, Mr. Rossi.
Thank you. Good afternoon, sir. Can you please state your name for the record?
Darren Zigich.
How are you employed?
I'm an engineer with the utility division staff at the New Mexico Public Regulation Commission.
As part of your duties, did you review this application?
Yes, I did.
And did you prepare testimony for this proceeding?
Yes.
Do you have a copy of Staff Exhibit 1, direct testimony of Darren K. Zigich? And that's the testimony of you in support of the unopposed comprehensive stipulation. Do you have a copy of that?
I do, yes.
And was this testimony prepared by you?
It was, yes.
And is this exhibit your sworn testimony in this matter?
It is, yes.
If I asked you the same questions today, would your answers be the same?
Yes.
And are the answers true and accurate to the best of your knowledge?
Yes.
With that, I move to admit Staff Exhibit number 1.
Thank you. Per the stipulation, there's no objection, and Staff Exhibit 1 is hereby admitted into the record.
I have no further questions for this witness. May he be subject to further questions from commissioners, hearing examiners.
Thank you, Mr. Rossi. Okay, let's see. Commissioner Nybert, do you have any questions for Mr. Zigich?
No, sir.
Okay, thank you, sir. Hearing examiner Ryan, any questions for Mr. Zigich?
Yeah, Mr. Zigich, I'm pretty sure I'm not misremembering this, and I believe this is the case. I believe we received a comment in this case questioning PNM's need to invest in these batteries. That would be a comment from the public. Can you just articulate from your perspective as an engineer the utility of these ESAs to PNM's system?
Yes. Well, these ESAs have all gone through a separate proceeding for resource adequacy proceedings. A big chunk of this rate increase actually is the 2026 resource adequacy filing that they filed last year that we were part of. Yeah, I mean, there's the energy transition is creating new opportunities for power generation and storage, and the ETA and other rules in the state are requiring the utility to make some changes in their resource fleet. That and PNM's securitization of the San Juan coal plant also puts that carbon dioxide per megawatt hour limit on them, which is very restrictive. I would challenge any utility in the country that isn't hydro based to meet their 400-pound limit that they're currently under. So that requires a large build out of wind and solar resources, and then the storage to accommodate that, because there's certainly times of the day when they're overproducing, and you need to move that energy to other times of the day. So are batteries the ultimate solution? No, they're not. The current battery technology is fairly short duration, so a 4-hour battery is not going to get you from when the sun goes down to 2 in the morning when some of your large resources or large loads are still chugging away. But I think that's where the whole time of use rates and all these other things are going to come into play in the future, because when you produce energy with wind and solar, it's fairly cheap up front. But once you store it, there's losses, there's additional cost, there's all that. And so there's going to have to be some mechanism in the future to accommodate that added cost that's built into the system as we go forward. You can't just throw more fuel at an engine or a coal-fired power plant. You can't just throw more fuel at it, the more energy you need out of it. So these batteries are both a capital intensive investment and an energy intensive investment. And that's part of the reason for the whole PRAC discussions, because the fleet is changing. And so the whole cost of service the whole allocation of that cost needs to change with it. But yeah, they're putting in these batteries mainly to keep the lights on when the sun goes down and the wind stops going. You're getting some savings from fuel costs. They don't have to fire up a new, a jet engine in the middle of the night, because they have the energy stored in a battery. And frankly, they need it for those peak summer days in July right now. So it's either you keep buying off the market, hoping the market prices stay low, or you start generate, keeping your own resources, but they all have resource adequacies that they need to meet, and that's what PNM is doing. It's just this transition is not initially a cheap endeavor, because you're shutting down capital and having to install new capital to offset that.
Excuse me, are you saying PRAC, PR something or other?
Sorry, the PRAC, the Pricing Advisory Committee that was discussed earlier.
Yeah, so that, right, for the benefit of the record, that's PRAC, and that's PR is pricing and AC advisory committee, right? Is that correct, Mrs. Zikic?
Yes.
Thank you.
So going to page 6 of your stipulation testimony, Mr. Zikic, you're addressing there at the sort of second half of that writing, beginning at line 12, maintaining the current depreciation schedule. Is that a prudent decision for Four Corners Power Plant? That's what we're talking about there, right?
Yeah. Yes.
And I just want to make sure that I understand what you're communicating in this paragraph. So you start by saying delaying the depreciation means the book value of the plant stays relatively inflated for longer, and thus the utility continues to collect a return on equity on the larger value. That would be, I presume, a positive from the utility's perspective.
But potentially, but then I discussed this bench request that Chair O'Connell had made back in October, and Mr. Sanders, who could speak much more eloquently about this than I could, did an analysis. Yeah, in a few rate cases ago, it was decided that they should depreciate the Four Corners power plant out to 2041. That was contrary to what PNM was asking for, but that's what happened. In hindsight, if they are really leaving the facility in 2031, that was potentially the wrong decision to make at the time. Now we have this undepreciated asset that's closing before its depreciation timeline. So, essentially PNM was trying to make up ground there and depreciate the facility in line with the retirement date. That was decided, well, that's to increase the depreciation was a $20 million plus hit per year to do that. So you're essentially leaving that as is and letting it depreciate out to the 2041 timeframe. But because they get a return on equity on all of their capital, it it stays higher because the depreciation is lower. But, you know, it's like getting a 15-year mortgage versus a 30-year mortgage. You know, it's cheaper per month, but the overall cost might be higher in the long run. But it all kind of depends on if the utility securitizes that the remaining balance or not. And so there's still a lot of unknowns in what exactly is going to occur with Four Corners. Are they going to go the same route as San Juan or something else?
Okay, so just to make sure I understand. So page 6, beginning at line 12, down onto page 7 at line 5, that sort of whole question and response, you're there kind of working through the fact that, you know, PNM was asked to do sort of a critical analysis of the varying options, and you're effectively saying that the option of just maintaining the present depreciation schedules is an acceptable result for as far as the commission staff is concerned.
Yes.
Okay. Again, this comes back to the Good Neighbor Fund question I've asked Dr. Weller, and I asked the PNM witnesses. Was staff a proponent of the 1.5 million number? Was that something that you all advocated for, or how did that come into existence, as far as you're aware?
It really wasn't. I don't know what I can say. It was a number that was given and accepted kind of late in the discussions. And it was maybe that cherry on the top of the whipped cream. So I think that sealed the deal for some, and I think that was just a last ditch effort to save everything. So it was accepted as is.
On page 9 of your testimony, at lines 2 to 3, you refer to the momentary average interruption frequency index. And could you just elaborate what it identify? I mean, I've heard of SAFE, and what's the other one? SAIDI?
Yeah.
This is a new term in my lexicon.
Yeah, this is more of these little blips that you and I in our home really don't, the lights flicker and it's like, okay, at least my Netflix didn't kick off, so I'm happy. So it's these little blips to you and I in our residential customers or even small commercial. It's not a big deal. To some larger customers and some that are doing some very fine tooling and computer processing and stuff, these large blips can cause chaos in their systems. And, so certain interveners definitely wanted to make sure that this cost cutting or this stipulation didn't affect efforts in trying to mitigate this. Now, there's no true, our new rules on reliability are requiring the utilities to report these numbers, but there's no set standard. It's kind of like reliability in general. There's really no set standard. You got a reliable system or you don't, and the customers complain and this and that. This is these momentary blips or, frequency. It could be a number of small things that you and I don't normally notice on a day-to-day basis, but for certain industries out there, it's very important. Now there's plenty of behind the meter technologies that these industries employ because the grid in general hasn't been very good at these small interruptions. And, and then I think the concern is with more variable resources on the grid moving forward, these may become more problematic. And this was just an effort to make sure that PNM with other cost-cutting measures to accommodate this stipulation weren't going to roll back any efforts in this area. There's no hard line, there's no real commitment to meet a certain value. It's just keep it on the priority list, and make sure it's watched.
As staff was reviewing the application, I mean, one of the major components of even the stipulation, and it really didn't change from as Mr. Sanders' testimony shows and the information he supplied, the investments in the distribution system of the 70 million or whatever, it's fairly consistent, and it doesn't really change the stipulation, and that number, $3 million reduction, as Mr. Sanders pointed out to hearing examiner Krankamp, was effectively the product of mathematics, order of operations, and not some substantive reduction to the investments. So it would seem that PNM's position in this case is, and I assume as staff, you all looked at this, your position as staff is PNM really does need to make these infrastructure investments that comprise those distribution, generation, transmission assets. Is that correct?
Yes, yeah, PNM has vast investments in everything down from from a small substation, to lines, moving, across your street, to residential customers, to all the way up to transmission. So and generation. So there's over, well over $1 billion just in new resources that were being added to the system. Some of that is to accommodate two-way power flow so that we can accommodate community solar development. Some of it's for other customer needs, some of it's AMI, some of it, it's a whole variety of different investments on all three levels: distribution, transmission, and generation. And so it goes from renewables to gas turbine upgrades at the Luna power plant. So and every one of them is necessary as far as we could assess.
Okay, then final question. I know hearing examiner Krankamp will have some questions about this, but just with respect to your last sort of point of your testimony at paragraph or page 18, this is the tolling, your position on tolling. And I'm not trying to ask you a legal question. I really want to just know from like a logistics, really, from as a participant in these proceedings on technical matters and engineering questions. One of the issues we run into is, you could have an application, the parties could engage in negotiation, and they could reach a stipulation. That stipulation could be contested or uncontested. And the commission could find itself in a place where there's perhaps issues that were not addressed within the context of the agreement, or perhaps results reached in negotiations that are not acceptable. And then the commission would be in a position at the end of that to say, well, we don't think the stipulation should be approved, but that would then leave no time to go back and adjudicate the original application, because all these things take time. So I guess my question would be, from your perspective as a participant in these proceedings, I mean, are you comfortable, with like the original application just getting approved, regardless of like the merits of it? Do you understand the quandary?
Yeah, no, I do.
I mean, I presume that you as staff members, you all want to participate and assert your perspectives on these things. And I assume at times it will be, because we've seen it happen previously. Don't accept the stipulation. I mean, and that's particularly when the contested stipulations, but you just end up in a position where you would want the commission acting on facts. But if we've dedicated time to the stipulation, there is no more time left for the application, and that seems to present itself as like a bit of an immovable object.
Yeah, I understand. And I need to apologize. This last piece on tolling was actually, it was something I got a little confused on, because we we had offered this information in another stipulation case for another utility previously, and I just kind of threw this in at the end just in case I know it wasn't asked, whereas in the last case it was actually asked for a position on it, and this one I just threw this in for good measure, but it probably causes more confusion than it needs to, and and I could certainly withdraw this if need be.
No,
But,
that's fine. And we've had active discussions about all these matters in varying cases. It comes up constantly. So this is where I'm not surprised that it was here. I understand the perspective, but I think from a position of just talking with you as a fact matter participant in these proceedings, I just strikes me that there's challenges that arise that if you suggest, for instance, the stipulation should not be approved, but that would then leave us potentially in a situation where we don't have time to adjudicate the original application, which then I'd ask you oftentimes, like, the stipulation is a very different thing than the initial application here, right? It required us to ask a different set of questions, as a matter of fact.
Yes, exactly. And I think a lot of people, a lot of the interveners have stated that they haven't really provided their side of the story. And, we never did file direct testimony, so you don't even have that to go on. In this case, it just jumped right to a stipulation. And so, I think in practicality, we would have to hear everybody out if this fell through.
Right. That was all. Thank you, Mr. Zinkich. Appreciate it.
Good afternoon, Mr. Zinkich.
Hello.
I did have a number of questions for you regarding that tolling paragraph there. I'm going to go ahead and skip that given what you've just testified. I think that has been addressed. Let me ask you some other questions that I had. This Good Neighbor Fund testimony, this is on page, I guess it's 7 and 8 of your testimony. I think really the reason why you've heard a number of questions about it throughout the proceeding is we're really just trying to figure out what to make of it. And let me just ask you, I guess, sort of a basic question. Was this an important provision of the stipulation from staff's perspective? And if it is an important provision of the stipulation, why is that?
Well, like I said, it came up late, and certainly staff didn't propose this, but I mean, it's I think once it was offered, and there was plenty of discussion throughout the proceedings, about the impact to low-income customers. I mean, that's anytime you're looking at a 20% rate increase, that's going to come up. And so there wasn't really a good answer, unless you have somebody else subsidizing that rate, or not even a rate class, it's just another group. How are you going to work that? And that's where this came up at the 11th hour, I would say, as a potential way to mitigate some of that. It's not the end all be all, like Mr. Monroy said, caps out at maybe 175 a month, a year. So I mean, it for some people that's one bill, and you have to be in good standing. You have to be behind, but still in good standing. So it's, I'm not trying to downplay the good that this does, but it is limited, and it's not going to solve all the ills of the rate increase. So, but it's, you get what you can get out of these stipulations, and that seemed to be a very nice, a good gesture by the party. the
Sure.
applicant.
That makes sense. And I appreciate that answer. Let me ask you, and you may not know the answer to this, does a ratepayer have to apply for relief under this Good Neighbor Fund, or how does that work? From a ratepayer's perspective, I understand you said that they're past due, but still in good standing. Does PNM contact them? Do they apply for it? How does that work? And if you don't know, that's fine.
Yeah, I really don't know the mechanics of it.
Okay.
Sorry.
No, that's fine. Another question that I had for you, similar to a question that I asked Dr. Weller from WRA, this provision of the stipulation about filing a joint motion about the wildfire mitigation plan or the wildfire management. I guess I'll ask you the same question. Was this another important provision of the stipulation from staff's perspective, or how should we view that provision?
Yeah, I mean, again, this wasn't something that staff, we try to play the middle ground and not propose too much, and just see where things go. But the party that did propose this, we certainly understand that. Dr. Weller and I both come from energy and minerals in our past lives, and so we were aware of what the State Forestry Division was doing there, and they had come in with some suggestions kind of late in the proceeding on that case. But still, it was good information, relevant, best practices, stuff that should be at least discussed and hopefully accommodated in these wildfire plans for the utilities. And so it makes perfect sense that there should be another look at these wildfire plans and make sure that we are doing everything that's in the best practices, and the latest information is accommodated or is included in those plans.
Okay. All right. I don't think I have any other questions for you, Mr. Zigich, but I do appreciate your testimony today.
Yeah.
Mr. Rossi, do you have any questions on redirect?
No, I do not. Thank you.
Great. Thank you. I don't see any other questions. So I think with that, Mr. Zigich, we appreciate your testimony again, and you are excused, sir. Hearing examiner Ryan, how do you want to proceed? I think Mr. Tupler is available now, so we can take him now. I think it's probably too soon to take another break, but it's up to you.
No, let's do Mr. Lee. Are you good to keep going?
Sure.
Let's keep
Okay.
going.
All right. Mr. Rossi, you can call your next witness.
Thank you, sir. Staff will call Mark Tupler.
Okay, thank you. Mr. Lee, if you want to swear in the witness, please.
Mr. Tupler, you solemnly swear the testimony you're about to give, no matter not opinion, should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Go ahead, Mr. Rossi.
Thank you, Mr. Hearing Examiner. Good afternoon, sir. Can you please state your name for the record?
Yes, of course. My name is Mark A. Tupler.
And how are you employed?
I am a senior economist in the utility division with the New Mexico PRC.
As part of your duties, did you review this application?
Yes, sir, I did.
And did you prepare testimony for this proceeding?
I did.
Do you have a copy of staff exhibit number 2, your testimony in support of unopposed comprehensive stipulation?
Yes, sir. It's right in front of me.
Okay. Was this testimony prepared by you?
It was prepared by me, yes.
Is this exhibit your sworn testimony in this matter?
Yes, sir.
If I asked you the same questions today, would your answers be the same?
Yes, they would.
And are your answers true and accurate to the best of your knowledge?
Yes, sir.
At this time, I move to admit staff exhibit number 2.
Thank you. Per the stipulation, there's no objection to the admission of this exhibit, so staff exhibit number 2 is admitted into the record.
I have no further questions for this witness, and he is subject to further questions. Thank you.
Thank you very much. Let's see. Commissioner Nybert, do you have any questions for Mr. Tepler?
No, sir.
Okay, thank you. Hearing examiner Ryan, any questions for Mr. Tepler?
Just one. Mr. Tupler, when Mr. McKenzie testified earlier, he noted that in the last rate case, the result of 9.26 was, I forget his exact words. I'm just paraphrase. It was unsatisfactory. And so now the company is stipulating, I mean, they came in with a much larger request of 10.45 and they're stipulating out at 9.45. And I can go do the math at a certain point. I just can't do it now, but we can effectively come up with some sort of number based on what's the difference between 9.26 and 9.45. And I guess my question for you is, as a rate of return analyst, I mean, is a 20 basis point increase something that has real teeth?
I would certainly say yes.
And why is that?
I would say that the number better reflects a proper ROE for a company like PNM, especially when compared to its peers.
And from staff's perspective, what do you make of the company's? I mean, I read Mr. McKenzie's direct testimony, and he was very clear about, it was really necessary for the company to come in to arrive at the 10.45. What am I to make of that in light of the company's willingness in the context of the stipulation to settle at 9.45? I mean, what do you make of it, I suppose?
Well, I'm always curious as to the basis to the other ROE experts' testimony. Of course, I read them all. The method that the commission has established with the DCF, the discounted cash flow method, is really the only method that matters, in my opinion, because it's the only method that matters. Even before I came to this position, and I've done a number of rate cases now, from my investment banking days, the value of a company is based on its future cash flows, period. In today's stock market, of course, there are some fluctuations with popularity or stock of the day and items like that, but there's no basis to that. However, there is a very strong basis, and it's been proven historically that the value of a company is worth its discounted cash flows today. You arrange that calculation into the ROE component of that equation. And because of the different methods and the different variables that you can include in those methods, there's going to be a range of ROEs submitted in testimony. I can go further on that if you'd like, but I think that answers your question.
And just remind me, and this may very well be in your testimony, I'm just looking for it, but what is the range under the DCF analysis that you came up with for the company?
So mine, if I'm not mistaken, let me get to it. I have it in front of me here. So my range was 9.26 to 9.95, which made my average 9.61, which was only about 16 basis points away from the agreed upon stipulated ROE.
And those numbers are reflected in that chart that comes at the end of your Market Tupler -2.
Yes, that's where those numbers come from.
Is there any it just seems on some level we get testimony quite frequently where there's like a 100 basis point difference even within the DCF analysis, and it just strikes me that we go from 9.26 to 9.45, and that's sort of unacceptable to acceptable. I just don't see how empirically like that 100 basis point range like really. I remember with someone from the Florida Public Service Company commented that that's one of the problems you run in with ROE witnesses is that the ranges are so big and that starts to impinge on the credibility of the analysis. But it seems like part of the analysis itself necessarily produces these ranges that are pretty wide. So I don't know how to resolve that tension. Do you have any comments on that subject?
I do, sir. First and foremost, you have to take a look at the analysis and understand the variables that were used. For the discounted cash flow method, you're looking at a dividend, of course. So you want to use a recent representative dividend. You want to maybe in your peer group is, I guess, what I'm explaining here. That's how we kind of come up to the numbers that we produce as ROE experts. You look at the dividend, you look at the stock's price over a certain period of time. I like to use a 30-day average because it gives you a much better idea of where a stock is traded during a particular day. I'm sorry, a particular month instead of just a particular day. I think we've all seen some of the volatility in the market. It's hard to put a spot price on anything, especially if we're using it to develop a rate that is forward looking. And that's what the stock market does with its dividends and prices is it's always evaluating every bit of information that's available. Probably some information that's maybe not available, but that's a whole different story. And the time frame, the future. You got to look at the variables behind the analysis to kind of come up with an idea of whether the number that's produced from that analysis is fair, just, and reasonable. From the staff perspective, I certainly like that directive, if you will, because I can take raw data, raw numbers without any predisposed manipulation to the numbers and come up with a number or a range is what I like to look at that I can then use as my range of reasonableness. It's in my testimony, but I stand behind it.
And just one last question. As I understand, what Commissioner O'Connell was inquiring this morning was whether the utility had agreed to an ROE number that would potentially lead to issues with raising equity capital and therefore, in return, sort of hurt ratepayers. Is there any concern with that claim? I mean, do you think that's a legitimate concern, or is there what's your comment about that?
Well, you'd have to look, if you want to look at this from an investor's perspective, the vast majority of investors in utility companies are large investors, large institutional investors, pension funds, insurance companies, large banks, investment banks, very large customers that are going to have an investment policy that may limit what and where you can invest. So for a fully diversified portfolio that an investor might take a look at, there might be a requirement that a certain percentage of the assets be invested in utilities in the western half of the United States, something like that. There's investment policies for every organization. Their board of directors gets to determine those parameters. If that portion of a portfolio is allocated to, say, the Southwest utilities, the ROE for each of the states or each of the utilities in those states is going to be a major factor of whether that institutional investor will invest in that company. If it fits into the investment policy, it can be invested in. If it doesn't, if there's a hurdle equity return rate as an example, written into that investor's investment policy, then they bypass that particular investment. If you need to have a certain percentage of the portfolio in New Mexico-based utilities, but they don't meet a hurdle rate, it might be just as easy to go to an Arizona-based utility or a Colorado-based utility, or fill in the blank. You see where I'm going with this. Investment policy a lot of times determines whether an investment can be made into a portfolio. And if it doesn't, there's always alternatives. We don't want to be trapped in an alternative situation.
Hey, thank you, Mr. Tupla. That's all my questions. Hearing Examiner Brian Kemp.
Thank you. Good afternoon, Mr. Tupler.
Yes, sir. Good afternoon.
I want to follow up on that. We've been having this dialogue, I think, throughout the hearing today about the ROE and the ability of PNM to attract capital. And just sort of following up on the last line of questioning from Hearing Examiner Ryan, I'm looking at page 4 of your testimony, and I was a little bit struck by, you said that the stipulated ROE is lower than, but marginally in line with average allowed returns in other states across the Western region and within the United States. And it indeed reflects the historical trends and commission approved ROEs. And I guess, if it is marginally lower than other states across the West, would that impair PNM to an extent in terms of its ability to attract capital?
Well, from my experience, I would tell you that portfolio managers use the return as only one of the variables that they're going to look at when deciding on whether to include a particular company in a portfolio. While the return is very important, it's got to be at least 50% of the criteria. It's not the entire criteria. As an example, diversification is a very big issue for institutional investors. So they're going to be willing to give up one thing or another, whatever it might be, for the overall terms of that particular transaction. In this case, being below the average was a surprise to me. Something else that ROE measures is risk. In fact, if we take it down to its bare bones, return on equity measures only risk. It really does, from my experience. So what that ROE tells me is that PNM is less risky than the average utility. I think this was broken up between East and West by Regulatory Research Associates. There's an east side of the country and a western side of the country. They divide them up. And I think that goes back to, what is it? I think it's the Hope doctrine that says location, which makes sense. That ROE tells me that it is less risky than the average utility in the West, but it doesn't comport with the credit ratings that they have from the national credit agencies. Something tells me that there's a disconnect there, and I haven't been able to figure it out, but I try to get as close to the bullseye as I can. That's why I described it as marginally close, I think was the term that I used, to the average. Because the stipulation, of course, was a very solid negotiated meeting of the minds, being as close to my number as possible, or being as close to an average as possible, I think hits it right on the mark.
Okay, that's helpful. And I have to ask another question. You talked a little bit about, investment policies and what it is that investors are looking for. And the question struck me, and maybe you're not able to answer, maybe you are, but just when investors are evaluating the risk associated with utilities, especially in the Western United States, has there been a pullback at all with respect to, in light of, I guess, increased wildfire risk, because we've heard that from several of the witnesses here today, and certainly it's all over the news. Are investors less likely to invest in utilities in the Western United States because of concern about the risk of wildfires affecting, returns?
That's a very interesting question. I would tell you that most institutional investors, most good investors know that this is not a new problem. Wildfires have been historic in the West from day one, if we can even put some measurement to it. This is not new. It's comparable to hurricanes and floods and what else we might have weather related on the eastern half of the country, if you will. So natural disasters are not new to the investment world when it comes to evaluating investments in utilities in specific parts of the country. That being said, I think maybe the response to those calamities, can I call them a calamity, or catastrophes? I think the response to it is what investors are more cautious about. They want to see how a state or a utility or a population recovers from it and gets back to that cash flow I talked about a little bit earlier. You have seen some of the larger insurance companies pull out of California. That was one of the most astonishing factors in that whole disaster from my perspective, because insurance companies are leaving one of the largest economies on the planet, and that is not a good sign. That being said, investors realize that there are natural disasters or calamities or acts of God, I believe is what they're written into contract. So they are seeing this, but again, their guess of the future is no better than anybody else's necessarily. They're making strictly business decisions and investment policy driven decisions of where they're going to place their investment dollars. I hope that was helpful.
No, it absolutely was. I also want to loop you in on some questions that, or I guess a dialogue that has taken place. Mr. McKenzie from, one of PNM's witnesses was testifying about how the investment community responds to stipulations. And he was testifying that I think under his models, the ROE was slightly lower than what he thinks, what his models suggest it should have been. But notwithstanding the fact that it's just slightly below that, he still thought that the investment community would respond very positively because this would be an uncontested stipulation. And I just wanted to bring you into that particular discussion and see if you had any thoughts on whether you think that the investment community would respond that way.
Yes, sir. I did hear Dr. McKenzie describe that. I agreed with him. And I think the investment public will consider this a positive resolution, and the credit reporting agencies would look at it that way as well. I'd like to take that answer just one step further, though, because I think there was some clarity if I remember as I was listening. Credit rating agencies have been around for decades, as long as the investment public has been out there. So they're doing something right along the way. One of the things that they do is they don't make rash judgments based on one particular decision or one particular event. They know that the businesses that they are analyzing are intended to be going concerns indefinitely. So there are things that can happen over time, both positive and negative, to affect their credit capacity, if we can call it that, or credit rating capacity. What the credit rating agencies like to look at are trends. What happened last year? What happened the year before? Maybe what happened the year before that? And how is it reflecting today? And what are our estimations for what it'll be tomorrow? So they're going to be looking at trends over time to help form or mold their credit score, if you will, because at the end of the day, these are credit scores. They're formula driven and or algorithm driven, I think is what we have to call it today. And they will look at trends in those variables. So it's not just one thing that happens, it's a number of things over a particular time frame. It might be proprietary, though. Each of the credit rating agencies has their own brand name of evaluation. So we may not know the exact formula, but in my experience, I have seen them adjust very little to great news, and I've seen them adjust very little to bad news. So it's a trend over time that they are more concerned about, again, because the investment public is to be indefinite into the future and a going concern.
Okay. And then I guess my last question to you concerns the exhibit to your testimony, MAT-2. And I think that this is showing, I guess, how you arrived at your calculation of the ROE. Is that correct?
Yes.
Okay. Can you walk me through this and just show me how I should be reading this?
Okay, bear with me as I bring it to my main screen here so I can see
No
it. It's
problem.
a little crooked in my edition here, but let's see. There we go. I think I've got it. Okay, so first and foremost, starting at the very top with the named companies, you can see that, and I explain this, well, I don't explain it in this testimony, but it would be explained further in a prepared testimony, that these are the companies that I've selected as comparable peer group companies to PNM. That being said, there's a lot of, I would call them raw data, if you will. You can see there that I have recent prices. I have a 30-day price. I have some earnings per share estimates. I have PE ratios, all the standard things investors look at from one point or another, as well as yield, of course, the dividend, the market cap. And this market cap column is in here intentionally. One of the basis to my peer group is that it's a comparable peer group of like-sized companies. As a former business banker, I know that a $3 billion company is looked at a little differently than a $30 billion company or a $300 billion company. I believe there might be some in the utility arena. That being said, I tried to pull comparable market size companies together because I think you get a true apples to apples comparison. So from there, you see some of the other variables that are used in the analysis. Let me slide my screen through. We have credit ratings. We have Moody's, S&P and Moody's credit rating columns there as well as earnings growth estimates, all very standardized data that can be found in a number of different places, depending on what your source is. Mine is Value Line. And I've quoted this somewhere in this document, if I'm not mistaken, that using very well-established data is a smart way to put an analysis together. Because again, there's no manipulation of the data. It's just raw numbers and they come out as they do. That being said, you can see the color-coordinated items that I've put on the screen under the DCF calculation there. In the middle bottom or middle underneath the table of companies, you see the calculation boxes. I do have a CAPM in there. I don't even know why I have the CAPM in there anymore. I used to use it as a balancing tool, but it's very clear that the commission likes the DCF. I like the DCF, so I focus on the DCF. That being said, because this model has had a few iterations to it, the CAPM is still accurate, but it's not a major factor in my analysis. That being said, getting back to the DCF box, you can see that 995 there is what was calculated based on the raw numbers from the analysis in the table above. That 995 set the higher end parameter of my range of reasonableness for ROE down to, if I'm not mistaken, it is the 926 from the existing case. That range there is what I considered to be my range of reasonableness.
Okay.
Is that helpful?
Yes, it is. I think that answers my questions.
Good. Thank you.
Thank you. Hearing examiner Ryan, anything further? Okay. Mr. Rossi, any questions on redirect?
No, Mr. Hearing Examiner, no further questions.
Okay, thank you. Well, seeing no further questions, Mr. Tupler, thank you very much for your time and your testimony. We appreciate it.
Thank you, sir.
Thank you. Hearing examiner Ryan, I think it's probably time to take our final break of the day.
Yeah.
Is that correct?
Sounds good. Yep.
Okay. So it's 3:15 now. We'll come back at about 3:25. We'll be off the record. Thank you. Okay, Mr. Lee, are you ready, sir?
Yes, sir.
All right. Okay, the time is now 3:26. We're back on the record. And let's see. Hearing examiner Ryan, do we want to see if we can have Dr. Blank testify now?
Are we through with Mr. Rossi's witness, or do we have others?
No, we have others. Of the ones that he has available today, we have another 3, I think.
Well, let's ask Mr. Rowland. What Mr. Rowland, what's the status of Dr. Blank?
Larry, Dr. Blank was checking in his hotel when we took a break. He had a little bit of delay. He said he probably needed about 5 to 10 minutes and was going to text me once he was set up in the hotel room. I have not received that text yet that he is set up and ready to go. So I don't know if we want to try to do one other witness beforehand or give him another 5 minutes. I think either one would work.
Yeah, I think we'll try to let's try to do one more witness and then hopefully Dr. Blank will be available. Mr. Rossi, does that work for you if we go? I know that Dr. Zadelis is not available right now, but what about your next witness, Jonah Malden?
Yes, Mr. Baldine should be logging in. He is, staff is fine with that order of handling one more witness and then giving Dr. Blank the option.
Okay, sounds good.
Thank you.
We'll do that. Thank you. Okay, I think Mr. Maldine is with us. Yes. Okay, Mr. Lee, can you please swear in the witness?
Mr. Maldine, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter and opinion should be the truth, the whole truth, nothing but the truth.
I do.
Thank you, sir.
Please go ahead, Mr. Rossi.
Thank you. Good afternoon, sir. Can you please state your name for the record?
Yes, Jonah B. Malden.
And how are you employed?
I'm the accounting bureau chief in the utility division for the New Mexico PRC.
As part of your duties, did you review this application?
Yes, I did.
And did you prepare testimony for this proceeding?
Yes.
And now this is the exhibit that's out of order. Do you have a copy of staff exhibit number 4, that your testimony of Jonah B. Maldine in support of the unopposed comprehensive stipulation?
Yes, I do.
And was this testimony prepared by you?
Yes.
Is this exhibit your sworn testimony in this matter?
Yes.
If I asked you the same questions today, would your answers be the same?
Yes.
And are the answers true and accurate to the best of your knowledge?
Yes.
At this time, we'll move to admit staff exhibit 4.
Thank you, Mr. Rossi. Per the stipulation, there's no objection to the admission of staff's exhibit 4, and it is therefore admitted into the record.
I have no further questions for this witness. He is available for other questions.
Thank you very much. Turning first to Commissioner Nybert. Commissioner, do you have any questions for Mr. Maldine?
No, sir.
Thank you. Hearing examiner Ryan.
Mr. Maldine, one of the questions I had about this case relates to the investments for distribution improvements, and then I believe as a category it's sort of broadly referred to as generation and transmission. I don't think I'm misspeaking there. But the question I had was, these are obviously monies and investments that are going to be separate from the grid modernization approvals that were given recently in 22-00058, which will pass through the grid mod rider. Is commission staff at all concerned about being able to distinguish between what is, grid mod type distribution system investments and what are these other investments here, or does staff not have any challenges with that?
It's a good question. I think it's always a lot more clear when it's easily separated out. But I wouldn't say it was a major challenge throughout the case, at least for me personally. But I do agree that it would be a lot more straightforward and easy to decipher the information to have the costs maybe delegated to grid mod and distribution related to that within grid mod riders and cases versus kind of being lumped into the overall rate base.
Um, the Western Union fee-free payment program, is it correct to my understanding that this was I know that this was an issue that came up in the 22-270 rate case, and as I understand it, the major sticking point in terms of the issue there was that you're effectively asking the ratepayers generally to subsidize a payment system that will be utilized by some of PNM's most income insecure customers. It seems like something has changed, or am I mistaken? But in the sense that you all agreed in the stipulation, the staff agreed to about the supporting the fee-free Western Union investments.
Necessarily say that anything has changed. It's more so kind of the overall pie, looking at the agreement as a whole, which is why it's agreeable to us. And I think that there's you mentioned some valid concerns that came up in the last rate case, and really, I mean, taking the agreement with everything, all the benefits that the stipulation ends up bringing to ratepayers, the company, and all the parties involved. I think that's why it's definitely agreeable, and it does provide some benefits to the customers who are utilizing the Western Union payment method for their bills.
Am I correct that those are if I recall correctly, and we don't have, maybe there's some stuff in the direct testimony, I have to go back and review that, but PNM's direct testimony. But my understanding was that these folks who utilize these Western Union centers tend to be low-income individuals because they can't provide ACH numbers or they have banking issues. So that's why they're not doing the direct deposits that many of us are accustomed to. So in effect, what's going on here is that you have the poorest customers are getting a benefit. Is that basically what's going on?
I believe so. Yes, I do recall seeing that in PNM's direct testimony or something along those lines. So yeah, the customers that would primarily take advantage of this program may be disadvantaged or underserved populations.
With the regulatory liability for the legacy meters, did the company give us any indication as to how rapidly that regulatory liability will grow? I mean, do they give you a projection in terms of here's the retirement plan we're looking at?
Not that I can recall. As I understand it, that's kind of like a placeholder to place the return on those legacy meters, and that account balance will grow and capture the return on to return back to ratepayers. But I'm not entirely sure of the rate or the magnitude that's going to accrue at.
Right, because I think on some of with this, if this, and I marked it as a question, if we, it says here, the signatories have agreed, this is page 12 of your testimony, to allow PNM to create a regulatory liability, which will be equal to the return on legacy meters currently included in rates, as those legacy meters will be retired during the deployment of PNM's grid mod plan as approved in 2258. So in other words, as they retire legacy meters and deploy AMI, they're going to continue receiving the return on meters that are effectively no longer being utilized. And they shouldn't have that. Is that the idea?
Yeah, I think that's in general the idea, because as the legacy meters come out of service, they're no longer used and useful. So therefore, PNM agreed to just shave off the return component of the weighted average cost of capital, and place that into the regulatory liability, which will then be credited back to ratepayers.
Those are all the questions I had for you, Mr. Malton. Thank you very much.
Thank you.
Good afternoon, Mr. Maldine.
Good afternoon.
Most of my questions to you also relate to this Western Union component of the stipulation. And I just want to start with the answer that you give at the bottom of page 10 about whether staff supports the expansion of the Western Union fee-free payment program. And I'm not entirely sure how to make of this first sentence that you say that staff is supportive of the program because it's a part of the overall agreement between signatories, which ultimately led to an outcome that all could agree to. That almost sounds to me like you're saying that you support this in the context of the stipulation, but you might not support it if it was sort of a standalone, program. Can you tell me why this is in the public interest, or, am I correct in interpreting that sentence that way?
I would say that's, a general correct interpretation of that sentence. And it's more so kind of like, I looked at the stipulation as kind of like a bunch of levers that can be pulled, and kind of if you get the right sequence of the levers, then it's agreeable to everyone. I saw this as just kind of a way to get to a desirable outcome. So I'm not necessarily sure if I would support the program if it was if this proceeding had gone differently, but in the context of the whole thing, I think it's worthwhile to support. And as far as public benefit, I do think that there is a tangible benefit to customers that utilize these payment methods. So I do think that is a positive for sure about the program.
Now, let me ask you, one aspect of this program that I was a bit confused about was I see that at the bottom of page 9, you say that PNM is requesting $350,000 annually in base rates to fund this expansion. Then on the next page, you say that in 2023, a total of $131,350 was paid by PNM customers to Western Union. Those two numbers are somewhat different. Is there a reasonable expectation that customers will flock to Western Union more than twice what they're currently doing to take advantage of this?
I think there is the expectation that uptake will increase as they expand the program. by what magnitude, I'm not entirely sure. But I do think that there is an expectation that uptake will increase as the program gets going and there's more locations and availability and I suppose knowledge for those people that may utilize this method and find a benefit in doing so.
Okay. All right.
Sorry, can I follow up on that?
Yes,
General
please.
Camp?
Please.
You know, I think the objection, if I recall correctly, and I will go back to 22-270. I have to review the writing there and I whatever, but we don't need to do this now. But one of the arguments, Mr. Malden, about that, I think was, effectively what it becomes is a transfer payment to Western Union. I thought the objection was effectively, we don't want to have to subsidize Western Union's services through ratepayer general expenses, because that's just not a good idea. And was that at all part of the calculus in any of this?
I would say yes. We definitely looked at this program and we had our own opinions about it. But again, kind of coming back to the context of it being a part of the stipulation that I do fully support. I do think that it is in the public interest to support it as a overall a part of the stipulation and agreements.
Was this something staff proposed, or this just did not come from staff?
Did not come from staff.
And just to follow up on that, my understanding is that this was, I think, an original component in the application, was it not?
Yes, it was.
Okay. Can a customer go into a PNM office and pay their bill for free? I mean, they obviously have to pay their electric bill, but without paying a fee?
I'm not entirely sure. I do believe that they can, but I can't say with 100% certainty.
And last question about Western Union. And I am interpreting, when you say here in 2023, a total of $131,350 was paid by PNM customers to Western Union. I'm assuming that means that's a reference to the $1 fee. So in other words, there were 131,000 times that a PNM customer came into Western Union to pay their bill in 2023, right? Not that is inclusive of the actual bills that were paid.
I believe that's a correct interpretation, and that's how I looked at the number as well.
Okay, good. And then one last question, unrelated to Western Union. If you look at, and this was briefly mentioned, I don't remember who we were talking about it with. I'm assuming it was a PNM witness. This is on pages, this is up primarily on page 9 of your testimony. And it's with respect to the carrying charge for the rate case expenses. You note here that staff supports this modification, the modification being that it's not going to be the full whack, it's just going to be their cost of long-term debt, I think. That staff supports that modification because it is consistent with the commission's final order in the preceding PNM rate case. And I believe that's consistent with what PNM testified earlier. I'm just curious from the perspective of staff, beyond the previous rate case and maybe even beyond PNM, is this consistent with recent commission treatment of rate case expenses in other rate cases? As best you can recall.
I do know it was a part of, I believe it was a part of the agreement in New Mexico Gas Company's rate case, but that was also a stipulated case. As far as I could recall, I don't know that there is necessarily another rate case where the cost of equity was separated for rate case expenses, at least not off the top of my head.
Okay. I don't believe I have any further questions for you. Thank you, Mr. Maldine. I appreciate it.
Thank you.
Hearing Examiner Ryan, anything further?
No, thank you.
Okay. Let's see, Mr. Rossi, any questions on redirect?
No redirect. Thank you.
Okay. Seeing no further questions, Mr. Maldine, thank you very much for your testimony. You are excused, sir.
Thank you.
Thank you very much. And I believe at long last, Mr. Rowland, we are you are up next, and Dr. Blank.
Yes, thank you. And Dr. Blank, are you ready?
He is on the Zoom. He had
Yes.
his video on briefly, and it looks like he just turned it back on.
Yes, I'm here. Thank you.
Excellent.
All right.
Mr. Lee, if you would please swear in the witness.
Dr. Blank, you solemnly swear the testimony you're about to give to matter no opinion should be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank
Please
you,
go
sir.
ahead. Please go ahead, Mr. Rowland.
Thank you. Dr. Blank, if you could please list your full name, please.
Larry Blank.
Thank you, Dr. Blank. And can you please provide your current employment and your relationship with the city?
Yes, I am a principal of Tahoe Economics, LLC, a consulting firm I started in 1999. Currently based in Texas, 6061 Montgomery Road, Midlothian, Texas, 76065. I'm also employed by New Mexico State University. However, my engagement with the city is through Tahoe Economics. I am not here on behalf of NMSU.
Thank you, Dr. Blank. And in your consultation with the city of Albuquerque, were you at some point, did you review the application by PNM?
Yes.
And in consultation, did you provide testimony in support or in support of the stipulation reached by behalf of the parties?
Yes, I did.
And do you have that stipulation with you today? Or the testimony in support, I mean?
I do have my testimony with me, yes.
Okay. And is that the testimony in support by Dr. Larry or by Larry Blank on behalf of the city of Albuquerque dated January 10th, 2025?
Yes.
Okay. And did you prepare the testimony?
I did, yes.
And the testimony that you have in front of you, which I will also state that it's a CABQ exhibit number 1, is that true and accurate on the testimony that you prepared?
Yes, it is.
And if the questions were asked to you today, would the answers provided in your testimony be the same?
Yes.
Thank you. I don't have, or actually, let me go ahead and just move for the, to move into the record, the CABQ exhibit number 1.
Thank you. Per the stipulation, there's no objection to the admission of the City of Albuquerque's Exhibit 1, and it's hereby admitted.
Thank you. I don't have any further questions for Dr. Blank, and he is available for additional questions.
Okay, thank you. Turning first to Commissioner Nybert. Any questions for Dr. Blank?
No, sir.
Thank you. Hearing Examiner Ryan.
Good afternoon, Dr. Blank. I was reading your testimony and I came across the page 3, lines 1 through 3. I thought it was a nice statement, actually, so I'll just read it. A utility rate case decision serves the public interest when it solves a complex constrained optimization problem in a way that satisfies, to the extent possible, the competing self-interest of those affected by the decision. The constrained optimization problem, in essence, is how do we distribute the pain here, right? more or less?
Well, I'm actually thinking of multiple constraints here. We have the constraint, which is the financial health of the utility company. We have the constraints with respect to financial market expectations, in other words. We also have the constraints in ensuring that a revenue requirement that's approved is sufficient to provide for safe and reliable regulated utility service. So there's multiple constraints here, and then eventually we get to once we have that revenue requirement, then there can be constraints taken into consideration with respect to how we spread that revenue requirement across the rate classes, and then rate design issues as well. So yes.
I asked Mr. McKenzie earlier about Bluefield and Hope and the fact that, you know, the world has changed dramatically in the last 100 years, just from when we think about the way companies like PNM are able to mitigate risk through sophisticated, you know, financial means. I mean, even the computerization of everything is just something that would bewilder a person in the 20s and the 40s of the 1920s and the 1940s. And yet Bluefield and Hope remain the cases. And I just sort of, you know, hearing Examiner Kreienkamp and I were speaking, the courts, you know, I'm not asking you as an attorney, I'm just more as an analyst. You know, I understand Mr. McKenzie's answer to be, well, it's a very malleable standard that they articulated there. And for that reason, we've been able to adapt as we've moved forward. But on another level, it feels highly unsatisfying because, you know, courts will generally like look at the way they examine circumstances and come up with new tests. And that's like really clear in the First Amendment context, right? But here we are still operating 100 years later on the same case. And is there anything that the commission should think about that, or?
Well, first of all, again, as you said, I'm not speaking as an attorney, but it's my understanding that those cases, which culminated in the Hope Natural Gas case, continued to be the jurisprudence in the United States. So, to my knowledge, that has not changed on the legal side. On the you mentioned technological change. I still see great relevance in those Supreme Court cases, in that changes in technology, changes in business conditions, changes in the way we collect money from utility customers. All of those have been enhanced throughout the years. However, the bottom line in the decision that we see from Hope Natural Gas is that the rate of return that is used for the determination of the revenue requirement must be sufficient to compensate for the risks that are undertaken. So if there have been, and there have been clearly technological changes in the utility industries throughout the decades, insofar as those technological changes have changed the risk profile of utility companies, then that would flow into a decision as to what is an appropriate rate of return or return on equity. But the foundation established by these cases, I don't see that they are irrelevant today. I think they're as relevant today as they were decades ago. The Hope Natural Gas decision in particular, I find to be a remarkable, from an academic point of view, a very remarkable, very good, in a good sense, decision written by the court during a period of time in which finance had not even evolved into an academic field at universities yet. And the language is very relevant today.
One of the questions I had here was, we speaking just generally about stipulations, at page 4, you talk about you're addressing here whether it meets the varying criteria, and you say the settlement discussion spanned months of time and included total hours that probably exceeded the hours required for a litigated hearing. And I just was wondering, so when I read those words, I literally heard you to be saying that more work went into the settlement that wouldn't have been necessary to have a litigated case, and that's struck me as interesting. And so am I reading those words correctly?
Yes, and I have experienced that with other stipulations. Now, let me clarify. I've not attempted to quantify that, and to be able to quantify that, I would have to see the hours of every party engaged on this stipulation, right? So it's somewhat casual observation. You will note that I specifically mentioned the litigated hearing, right? So that was my primary focus when I had this filed. I believe that the hours that went into this stipulation far exceed, well, strike that, exceed, okay? I can't really put an order of magnitude, but certainly exceed the number of hours that would have gone into a litigated hearing. I would include preparation as well, because I did hear Mr. Monroy's response to this question earlier. And I think his response, which I respect, was coming from the perspective of the utility company, right? Coming from the perspective of PNM. I heard him mention avoiding rebuttal testimony, and of course the preparation that the utility company puts into in preparation for a hearing, which is I'm sure probably more hours than an individual, one of the individual intervening parties. However, I'm not sure if Mr. Monroy was giving thought to the additional hours put in by all of the parties on this case. There were many attorneys who were almost consistently present in these settlement discussions. I was not able to be present throughout all of those hours, but those hours of attorney times adds up to be a lot on this case. And so I was thinking about the attorney time. I was thinking about the expert witness time, because as the attorneys discuss and we provide input, we have to also go back to our own analysis, right? And either run this through models or cross-check numbers on things that are being put onto the table. And that requires a lot of time, a lot of thought. So let me pause there. I'm not sure I completely answered your question, but that's what I had in mind. I certainly appreciate the efforts of all the parties on this settlement, and it was considerable effort.
No, that definitely answered my question. Thank you. Those are all the questions I had for Dr. Blank, hearing examiner Krankamp.
Thank you. Well, good afternoon, Dr. Blank. Thank you for taking the time to testify for us today when you're traveling. We appreciate it.
Good afternoon, and I apologize for any delay I have caused in your schedule today.
No delay. Let's see. So there's a number of things that I wanted to ask you about. I guess first, just to direct you, to page 5 of your testimony. You gave an answer here to, you were asked to summarize the reasons you recommended support of the stipulation to the city. And you gave an answer talking a little bit about the city's interest in this case. And I thought that was very interesting. Given that we've been talking, I think, throughout the proceeding so far today about balancing interests between ratepayers and the financial health of the utility. And you gave an answer here that sort of suggested that the city itself has a number of interests that it would balance in any given case between, on the one hand, being a PNM customer, on the other hand, obviously having a large number of PNM residential ratepayers who live within the city. And then obviously also including, I would imagine, a large number of small businesses and some large businesses as well. And I was wondering if you would elaborate on that, about how the city goes about balancing all of those interests and how you would go about, I guess, balancing those interests in a case like this.
Yes, let me start with the city accounts as well. First off, let me start with the city accounts. We have, as a customer of PNM, the city of Albuquerque has accounts that fall under small general service, medium or large general service. And it's a large number of accounts. Of course, the smaller accounts outnumber the larger accounts, but the dollar amounts on the larger accounts, of course, is a larger number as well. And so, and we have street lighting, which is another unique interest. And so the way I typically approach a PNM rate case is I have to study almost all of the PNM accounts. I have to, in the context of, say, revenue allocation, I have to take into consideration, the proposal that has been filed by PNM on revenue allocation. Is there room for any modifications to what PNM has proposed? How would that impact the city? And so that's a balancing act that we as an intervener need to go through. And at the same time, we need to be cognizant of the fact that we are a political entity, right? We have elected officials, and we certainly have an interest in all of the businesses and residents who reside within Albuquerque, and the economy of the city of Albuquerque and greater New Mexico. So all of that weighs in. I think that what I'm describing here is an intervener who is rather unique, maybe a little more comparable to staff, because I recognize that staff also has to take into consideration all of these inputs. I think the difference from staff is my client actually has to pay these bills, right? And so I have to answer to the city if my recommendations are adopted, or in this case, my recommendation to support this stipulation. If I make a mistake, I'm accountable for that. And I will be answering all the way probably to the top within the city of Albuquerque as to why have our bills increased by more than what you thought they were going to increase. And so it's very much a balancing act, but at the same time, we have to take into account the economics, the cost to serve, and promote movement in direction toward cost of service, while at the same time being somewhat constrained in how far we can make those movements.
Thank you. That's helpful. And related to balancing, and I don't know how much of the testimony you've been able to hear, but we've had this discussion with several witnesses about this tension between cost causation and avoiding rate shock. And you allude to this, I think, throughout your testimony. I'm looking in particular at page 8. You talk about how several customer interests have sacrificed to keep rates of others within 145% of the system average. Again, given that really one of the most important criteria that the commission has to consider as far as whether to approve a stipulation is whether the stipulation itself violates any regulatory principle. I was wondering if you could speak a little bit more to that tension between cost causation again on the one hand, and then, the rate shock that would happen if if a residential customer received, let's say, a 32% increase in their bill.
Sure. So as you know from the stipulation, the residential class has been capped in this stipulation at 19.85%. Had we strictly followed cost of service, I'd have to look it up. I forget how high it would be. It'd be significantly higher. I begin to get nervous, I guess, when I start seeing increases that are in, say, the 25% range or higher. That's where I start to look for solutions to try to mitigate that. So there's no hard and fast objective definition of rate shock. But a sudden overnight increase of, say, 25-30%, that's substantial in my opinion. However, we know that this increase, which has been capped below 20%, will also be phased in. And that gave me more comfort with the magnitude of the increase that's being proposed here to the commission. Phasing it in is helpful. An overnight increase of almost 20% for some households certainly could be a burden. And phasing it in helps. It at least gives a little more time for the next increase to come in.
Okay.
Can I ask a follow-up question on that, John?
Yeah.
Yes.
Please do.
So it was interesting to hear you say that, we said earlier, rate shock has no sort of rigid definition, and that when we're thinking well, let's ask this question first. To your knowledge, what does the city of Albuquerque, the folks that would complain to you if rates start to creep up beyond what was anticipated, did they receive calls about frustrations with rates, to your knowledge?
I don't know.
You don't know?
I don't know. I did not hear that. If there were a lot of calls, probably I would have heard something, but I don't have that knowledge.
Okay, and so then, to the extent to which we're thinking about a thing like that's rate shock, and you're thinking about like what is it? Because ultimately, it's a question as to what can a ratepayer effectively be asked in a sort of elastic form to absorb, and wouldn't that necessarily differ depending on the demographics and socioeconomics of any particular service territory? In that, if you have a high concentration of low-income ratepayers, what constitutes rate shock is going to be perhaps a different thing than if you're looking at a utility in a more affluent or upper middle class or whatever, more stable socioeconomic circumstance. Is that a fair way of thinking about that subject?
Yes, I think that's a fair consideration. In the state of New Mexico, I've always been a little more sensitive than other parts of the country where I've worked. As you know, as I'm sure you're well aware, New Mexico ranks near the bottom in terms of household income or average household income, and that's a concern in New Mexico that also is unique compared to many other places in the United States or other service territories, to be more specific.
Thank you.
Yeah, and Dr. Blank, let me just follow up on that. One of the questions that has come up, hearing Examiner Ryan asked one witness, I asked another, is about the history of these class subsidies, and we're moving away from those. We're trying to move towards more cost causation. And thus far, we're not entirely sure. We haven't heard a witness yet who's entirely comfortable giving us sort of a ballpark of how long these class subsidies have been around. We know they've been around, I think, since at least 2015. I strongly suspect they were in place far before that. Do you have any sort of history that you can offer us? That's a question that I know is certainly at the forefront of my mind.
My history working on these cases in New Mexico, I'm trying to remember the first case I worked in New Mexico, probably going back maybe only about 15 years. So there's others. I can think of at least one other witness who specifically works on cost allocation issues, who is in this case, who has a longer history than I do. That maybe he may be able to be in a better position to try to answer that, and that would be Professor Gigax. However, this long history, I know it's a long history. I can't give you a date. I can't give you a time span specifically, but it is not unique to New Mexico. I would say most of the jurisdictions, not all, but most of the jurisdictions where I have worked on those issues, the so-called subsidization of residential customers has been in play and a consideration for a long time. So it's not unique to New Mexico. Some states have made greater steps, I guess, toward elimination of subsidization. And remember, it's not just residential. Sometimes we have other rate classes that have been subsidized for a long time. Some states have made greater steps to try to let's take the hurt now and make some larger steps towards cost of service. But most jurisdictions in that situation have not. It's been gradual steps. I had another thought, but let me see if you have a follow-up question first.
No, that's very helpful. I mean, I'm really not looking for an exact date, but just some backstory as far as, we've heard a lot about the principle of gradualism and trying to get more into a cost of service model. But I'm just very curious about how the system originally got the way that it is and what principles of rate design they might have been relying on at that time to institute those type of class subsidies.
One more thing, I remember my other thought, which is relevant to what you just said. Let's not forget, it depends on which cost of service model you're looking at, right? And this is not a perfect science. One expert will have strong opinions on certain methods to allocate costs, and you turn to the next expert who may have just as many years experience and they'll have a different opinion. We have in New Mexico, I think in recent years, in my experience, we've used the cost of service study from PNM as a kind of a starting point, a guide. What I mean by that is some of us parties have not gotten wrapped up in arguing over methods, although I am aware of the PRAC meetings that have taken place, and perhaps I've not been able to attend all of those. But what I'm trying to say here is having 100% agreement on the methods, and these methods can shift costs considerably from one rate class to another rate class. It's not a hard science, and there are strong differences of opinions as to what the appropriate method should be. And that's why we talk about a range of reasonableness. Of course, we will disagree on ranges of reasonableness as well, right? So that's why we have a commission. But in this case, that's why those interested parties who do have strong opinions on this have come together and been able to find a middle ground. And I respect those who have given up on one side to mitigate the pain on other customers. So I have great respect for those who have done that. They've been able to move off of their strong opinions and vice versa. So so I think what you have before you, again, I think I mentioned this somewhere in my testimony, you're looking at hundreds of years of experience, combined experience of experts who do not always agree with one another. Being able to come to an agreement on cost allocation, and with some reference to cost of service. Okay.
Well, let me ask you about that. I was going to ask you this question, and I think that's a nice segue. You know, you just talked about how what we have before us is an uncontested stipulation that lots of experts with a lot of experience have put this together and agreed that this is in the public interest. Mr. McKenzie, PNM's witness, said something that I thought was very interesting. He said that I understood him to say that, you know, the fact that PNM and all the parties have reached this uncontested stipulation is sort of evidence in and of itself that the stipulation is in the public interest. And I can interpret a little bit of your testimony on page 4 as saying something similar. Do you think that the fact that this is an uncontested stipulation is some sort of indication to the commission that this is in fact in the public interest?
I wouldn't use, let me say it this way. I think that is a good indicator, but it's not sufficient. All right. Just because you have an uncontested settlement does not necessarily mean or imply that it's in the public interest. I have seen settlements where certain parties may have been underrepresented, certain customer classes may have been underrepresented, and potentially those settlements were not in the public interest. I'm not going to try to sit here and recall if they were approved by the commission or not. Okay. However, I've seen settlements where certain parties may have been underrepresented in the discussions, possibly because they were not an intervener, right? That's usually the reason why. When I served on staff, I tried to be certain that I was also cognizant and advocating those interests that may not be at the negotiating table. So I'm not saying just because it's an uncontested settlement that is reason in and of itself for to meet the commission's requirement that it be in the public interest. What is different here, when you look at all the interests and all the interveners who played an active role in reaching this particular stipulation, we have one that, in my opinion, is in the public interest.
Thank you. And then last question, sort of going from the macro level to sort of the micro level. If you look at page 9 of your testimony, I wanted to ask you about this provision of the stipulation regarding streetlights. You were asked if there are any other provisions in the stipulation that are of particular interest to the city. There's this provision about separating the PNM-owned streetlights. I think that's what that means. The PNM-owned streetlights from the customer-owned streetlights within the development of the class cost of service study in the next rate case. And you talk about that there are notable cost differences in these two types of streetlights. Can you elaborate a little bit on that and help me better understand it?
Yes. So there are FERC accounts that are specific to streetlights that are owned by the utility company. So we're talking about the light fixtures, the lights themselves. Sometimes poles, sometimes we have dedicated poles that are just for the lights. So we're talking about the poles, the fixtures, the drop, let's call it service wires, right, to those poles. Those are all dedicated facilities. Now, the service wires or connections, you're going to have those usually with customer-owned lights as well. But the poles, the fixtures that are owned by PNM, those are costs that are unique and very different from the cost of serving a customer-owned street light, where the customer has maybe placed the pole, they own the light, they have taken on that cost themselves. And so that's the biggest difference. And so within the cost modeling, what I have encouraged and PNM has agreed that we work to make that separation transparent within the cost model itself. The cost model right now bundles both types of customers together, and then outside the model, PNM has they try to make that separation outside of the cost model. And so my preference is that we attempt to do that within the cost model, because it's not just the costs associated with those light fixtures that are owned by PNM, it's all the other costs that will be allocated because of those rate-based items. So when you have a rate-based item that is dedicated to a particular customer class, or in this case, a subclass, which is the street lighting owned by PNM, that also draws in allocation of other costs as we use rate-based allocators to bring in a whole variety of other costs. Let's just call them overhead costs or administrative and general costs as an example, right? More of that should be allocated to the the company-owned streetlights. And so I want to make sure that we do a better job in segmenting those costs, especially during a time period when many street lighting customers, including the city of Albuquerque, have decided to own their own streetlights. And I want to make sure that there's no subsidization occurring between company-owned streetlights and customer-owned streetlights. I'm not suggesting today that there is subsidization, but the only way to know is to properly separate those costs. And because potentially, I'm just speaking for myself. If I'm PNM, I may have an incentive to keep the street lighting business, wholly within my domain. I'm not saying that's an objective of PNM. They've never said that. But, there's potential anti-competitive considerations here as well. So if a city wants to make the investment in LED lights, they want to own those lights, or they might enter into a contract with a third party for the construction and maybe even the maintenance of those lights, that's in competition with the utility company. And so that's another reason why it's very important that we get this cost separation done properly.
Got it. That makes sense. I believe that's all the questions I have for you, Dr. Blank. I very much appreciate you coming in and testifying. Hearing Examiner Ryan, do you have anything to follow up on?
Nothing further. Thank you.
Okay, thank you. Mr. Rowland, anything on redirect?
No, sir.
Okay, thank you. Again, Dr. Blank, thank you so much. We appreciate you making the time. And with that, your excuse, sir.
Yes, thank you, sir.
Thank you. Okay, I have 4:25. Hearing Examiner Ryan, do we want to try to fit in one more witness from staff today or adjourn for the day?
Mr. Lee?
I could use the break.
There we go. That's our answer.
Okay. Let's see. So we are scheduled for 9 a.m. tomorrow morning, correct? And I think there's a lot of witnesses. to cover in the morning, or at least tomorrow.
Yeah, I mean,
believe-
my suggestion would be, and I'm not sort of saying this that we have to do this, but my feeling would be like to kind of go back in time maybe, and then sort of finish with staff, right? Like get the last staff witnesses at the end. But we don't have to do that. That's just one way we could do it.
I would
Yeah.
request that we have Dr. Zadalis early in the morning, because if we don't go into day 3, we won't be able to catch him at what would be midnight his time.
Is there any intervener witness that is unavailable in the afternoon? I just don't want to be surprised tomorrow.
I'm not sure the interveners are all.
Looks like Justin Barnes from CCAE from Coalition for Community Solar Access is available until 3 o'clock. And looks like Walmart's witness, Dr. McGovern, is available except for 11:30 a.m. to 1:30 p.m. our time.
And this is Julie Clark on behalf of Walmart. If Dr. McGovern could go in the afternoon, that would be better, but we'll leave that up to you if that doesn't work.
Looks like we're going to be able to accommodate that. That shouldn't be too much trouble right now.
Okay. Okay. Thank you. I appreciate it.
Sure. Okay. All right. Well, yeah, I'm fine beginning in the morning and finishing with staff's witness, and then going through the remaining interveners.
Well, here, let's just do this real quick. Let's so we can get concrete. So if the Dallas could go first at 9, and hopefully other interveners, if they're here, they'll chime in. Then we could have Crane and Gigax from the DOJ. Mr. Elliott, is that okay?
Yes.
So, I don't think Zadalis will go terribly long. So if those folks can be ready right at 9. Then we have Mr. Andrews. Can he also be ready between 9 and 10?
Mr. Gould?
You're muted, sir.
I thought I was unmuted, but
there you go.
Yeah. I have sent Mr. Andrews an email and telling him to be ready at 9 o'clock. So
great.
Okay, good.
And then we'll have Mr. Bieber. Right? Our friend.
Yes.
Yep. And is Mr. Boehm here, or is he gone away? He's gone away.
I don't see him on here.
But I didn't get any impression that would be a problem.
No,
then,
I don't see that. I don't see that listed as him being unavailable in the pre-hearing memorandum.
And is Walmart with us? Was that Mrs. Clark? Yes.
Yes.
And Ms. Clark, you wanted Mr. McGovern in the afternoon.
Ms. McGovern, yes.
Excuse me, Ms. McGovern. My apologies.
Dr. McGovern.
Dr. McGovern.
Yes, Dr. McGovern.
There we go.
Thank you.
So did I just identify everybody, or I forgot anyone? The Dallas Crane.
All the interveners, but there's 2 more remaining staff witnesses, Ms. Leba Tercero and then Mr. Jimenez. So if we finish the day with them tomorrow, then we should be able to. Are they available in the afternoon, Mr. Rossi?
Yes, no conflicts for either of them.
Okay, perfect. Then we'll plan on that.
Terrific.
Okay. Anything further before we adjourn for the day? Okay, seeing none, have a pleasant evening. We'll see you all tomorrow morning at 9. Thank you very much.